ಈಗ ಏನ್ ಮಾಡೋದು? ಇವತ್ತು ಬಂದಿಲ್ಲ ಅಲ್ಲ, ಫೈಲ್ ಇಲ್ಲೇ ಇದೆ ಅಂತಂದ್ರೆ ಕಳಿಸಿಲ್ವಾ? ಅಲ್ಲ, ಈಗ ಏನಾಯ್ತು ಅಂತ ಅದಾಗಿಲ್ಲ ಅಂತ ನಾನು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಹಾಕ್ದೆ. ಯಾಕಂದ್ರೆ ಎಷ್ಟು ದಿವಸ ಆಯ್ತು, ನಾನು 3 ಸಲ ಡೇಟ್ ಕೊಟ್ರಿ ನೀವು. ಅಲ್ಲ, ಬೇಕು ಮೇಡಮ್, ಕಾಪಿ ಕೊಡ್ತೇನೆ ನಾನು, ನನ್ನ ಹತ್ರ ಇದೆ. ನಾನು ಕೊಡ್ಲಾ ಅವ್ರಿಗೆ? ಆಯ್ತು.
Court officer. Court officer, can you hear me, madam?
Okay, madam. Thank you. File ಅಲ್ಲಿ ಕಳಿಸಿದಿರಲ್ಲ ಮೇಡಮ್?
Yes, sir. You are audible. Branch ಅಲ್ಲಿ ಇದೆ.
Thank you, madam. Madam, list number 1 first ತಗೊಳ್ತಿರೋ ಅಥವಾ list number 2 ತಗೊಳ್ತಿರೋ madam first?
List number 1, sir.
Thank you, madam.
List.
Hello. Yes, sorry.
List number 1 will be taken first.
Thank you, madam. Is it the same order every day?
Yes, sir. Unless unless the directions from the lordship, we will call. Usually, we will call first list first and second list second. So, if any alteration is there, ma'am will instruct me. According to that, I will call.
Thank you, madam.
Okay.
This matter, my lord, due to fall of the metro pole, my lord, the child and mother died, my lord. We have filed a enhancement of compensation request to GM 2023, my lord. Has been posted, my lord, any day next week, my lord.
MFA
No, writ petition GM
for enhancement of compensation.
from the metro, my lord.
Metro. Yes. Listed next week.
Your Lordships kindly, my lord, matter was posted for today, my lord, it's not come up. Matter,
What is that?
my lord, matter of the year 2023 writ petition pertains to the sugar factory, my lord. I applied for a license in 2010. By the activities on ground today, my lord, by a rival party, my rights are being defeated. So, my lord, I moved, I in fact mentioned the matter last week. Your Lordship fixed the date for today, it has not come up. Your Lordship may fix any convenience.
Next week.
I'm grateful.
On
Your
Wednesday.
Ladyship, this matter pertains to the unlawful arrest and detention of a Japanese national for 19 days. The Karnataka State Human Rights Commission was pleased to award a compensation and as well as certain recommendations in 2022. Despite the passage of over 4 years, it still has not been granted.
No, then what happened?
Your
The
Ladyship,
petition, no, the Human Rights Commission has already granted
yes,
compensation.
the orders. The writ
What is-
petition is seeking implementation of those, of the
Implementation of Human
recommendation.
Rights Commission order.
Yes, Your Ladyship.
List it on Thursday. Yes.
Grateful.
DRT matter.
Hmm?
GM DRT matter, Petitioner. Writ petition. Petitioner is challenging the possession notice.
Which year is the writ petition?
Blood fresh matter, please. Blood.
Fresh matters will come. If you comply with the office objections, it will come. Within 24 hours, every matter is listed. Nothing is pending in the, yes.
GMDRT matter, Your Worship. Yesterday, the senior counsel had mentioned through VC. This honorable court has sought a physical presence as well regarding the
This
process.
is matter
Ladyship may keep it on Friday if possible, Friday. This Friday.
7th April.
7th.
Yes.
7th.
My lord, MFF for the year 2017, my lord.
2017
2017, my lord. For the enhancement of compensation.
MFA.
MFF, 2017.
Now we will, all old matters, we will hear the company appeals first, enhancement later. We will see. Yes, call the list.
With your Lordship's kindly minutes. Minutes, one matter of the year 2021 minutes, stay is granted minutes. I am for the including applicant. Minutes, I have purchased the property under registered sale deed. Because of the stay granted by this honorable court.
Surface-
Minutes. No, not surfacing minutes, general residuary, general miscellaneous residuary minutes, 2021. Minutes, the
Yes, on 7th.
obliged.
My lord.
My lord, DRT matter, the matter has become infractuous. Kindly post it to tomorrow, old matter, ma'am.
My lord, matter, writ petition infractions,
matter.
ma'am. Infractions, writ petition.
But
Loan amount is closed, my lord.
Tomorrow. Planning. Call the list.
Page wise adjournment, list number 1, page number 4, serial number 12 to 14, page number 5, 15 to 21.
Serial number 18, my lord. Petitioner has been hospitalized, please 2 weeks time maybe.
My lord, serial.
2 weeks time.
Who hospitalized?
Petitioner.
What, why? If the petition is hospitalized, you can argue the matter.
No, I can argue the matter, but I want to get instruction regarding payment of the bank. 2 weeks, just 2 weeks, my lord.
All these old matters getting listed and
Sorry,
asking
my lord,
adjournment.
sorry. 2 weeks, just 2 weeks.
You have a stay?
Yes.
Have any, that's why you want adjournment, I know that.
No, actually stay there, madam.
This is matter on 8th of April, no further adjournment.
My lord, serial number
What
21.
earlier granted is extended, yes.
Serial number 21. Senior is not in town, my lords. He's traveled out of town. 2
Is it
weeks.
coming up for the first time before this court?
No, ma'am. My
Then?
lords, it was last time it had come. He
We
was-
will see. We will see when the matter reaches.
Your
Yes.
Lordship,
Number 6,
in serial number 13, I appear for the petitioner. We have filed our
Serial number
13, Your Lordship,
13.
1-3. I appear for the petitioner. We have filed a NOC wakalat. 2 weeks time may be granted.
2015 matter, I'll see whether there is anything survives for consideration or not, we will see. Yes.
till page number 6, serial number 22 to 28.
My lord,
Page
serial
7.
serial number 28, my lord, some proxy counsel, on record counsel, father has been hospitalized, my lords. He is in the Davangere. Today morning he has been there, my lords. Kindly I seek 2 weeks accommodation, my lords, because he is in intensive care.
Admit, post of final hearing, call for the TCR.
Grateful, my lords.
Yes. TCR is already there. Admit, post of final hearing. Yes.
Page number 7, cell number 29 to 31, page number 8, 32 to 33, page number 9, 34, page number 10, 35 to 42, page
Serial
number
number 37, Your Lordship. 37, I'm for the petitioner. I pray for a week's time. It pertains to a railway project. The similar matters have already been withdrawn, is my instruction. I seek a week's time. I'll take instruction and place
Matter
on
on Wednesday.
Serial number 35, my lordship.
as an interim order. Your Lord.
Interim order earlier granted is extended. Yes.
page number
Serial number
11, cell number
35, my
Lord,
lordship.
serial number 39.
What do you want in 25?
35, my lordship.
35.
35 weeks time, my lordship. There are 8 petitioner, 8 numbers petitioner, my lordship. There are 1 or 2 are died already. We have to ascertain who are there, my lordship.
We will see what is the writ petition about, then I'll grant time, not at this
Page 11.
mentioning. Yes.
Page
Lord,
11,
serial number
45,
39.
30?
39, please adjournment, my lord.
Hmm?
Senior is not available. Please adjournment, 2 weeks.
Have you informed the other side?
Not at me.
Yes,
Then wait.
Malik, please.
I will inform you.
Please wait.
Page number 11, 43 to 49, page 12, 50 to 53, page 13, 54 to 58, page number 14, 59 to 61, page 15, 64, 62, list number 2, page number 2, serial number 2 to 3, page number 3,
Your Lordship,
4 to 10.
serial number 4, causeless 2, seeking an adjournment as senior is out of town. He's in Chennai for another matter. We want to argue the matter.
We'll see. Wait. Yes.
Page number 3, serial number 6 to 10, page 3, 4, 11 to 12,
Yes.
list number 1,
Lord, one memo, my lord, RP matter. Memo for posting
What is the memo?
RP matter. RP has filed, I am respondent.
We'll see. Yes.
Serial number 20, serial number 29, Your Lordship. It's in Kannada version. That's why it may be posted for final argument. Admission is there. Serial number 29.
29 MS.
Admit. Final hearing.
Okay.
These are all 2014. Anybody who is asking adjournment at the risk of your clients, you're doing it. Yes.
List number 1 for serial number 1 for dismissal, Abhinav.
Before the respondent.
Yesterday's question, my lord, I have, my lord, 3 submissions to make on jurisdiction. My lord, since we are challenging section 25 of the RDDB Act, my lord, any high court in the country, my lord, will get jurisdiction. That is the first aspect. Second, my lord, this is a loan which is borrowed by the company. And my lord, any high court which has jurisdiction will be the court, my lord, where the company is registered. There is one judgment, I will produce that. The third aspect, my lord, how I say this honorable court will have jurisdiction is, my lord, I am a resident of Bangalore, and my lord, an arrest warrant is issued when I am residing here. Therefore, my lord, in any proceeding relating to, my lord, an arrest warrant where Article 21 is sought to be infringed, of course.
At best, you will have if there is arrest warrant, you will have a transit bail, but not whatever the submissions as you made just
Yes,
now.
ma'am.
These are all in a case generally, not when you are participating in the proceedings. When you say that the court at Bangalore has jurisdiction, but not the Delhi, you should have raised it. It should have been decided by that court. Simultaneous proceedings here in Bangalore and Delhi can't be continued.
Lord,
And we will not decide the legality of any order or any of the proceedings initiated before Delhi by the Bangalore High Court.
Very well, my lord. But then, my lord, the other question that would remain is, my lord, if the prayers are seen, section 25 is challenged. My lord, I'll just show, my lord. Yes.
No, what will happen is you
Yes.
cannot question the validity of an act independently without there being a cause of action for you. Cause of action for you is arising out of the proceedings that are already initiated before the courts at Delhi.
True, ma'am.
So this 25 also should be questioned before the Delhi court, not before this court. Because we can't, why should, now, like, it is like without a consequential relief, if you file it just a suit for declaration, that's how it is.
Yes, my lord, section 34. But my lord, what I would submit is this. My lord, proceedings no doubt have arisen there. It is before the DRT. But my lord, please look at this in a peculiar facts and circumstances of the case. My lord, the company is wound up. If the company is
Court,
bound
you
up,
have a very good case which the court will appreciate there with all these grounds.
no, my lord, if the company is wound up, my lord,
That's what
they,
I'm saying, no, all these grounds you raised there, if they don't appreciate, then you have a further remedy, but not this kind of, litigation we cannot entertain.
Lord, I'll just, my lord, give these judgments.
Yes, yes, please pass on.
Yes, first judgment is, my lord, 2004. This is Kusum ingots.
Yes.
Lord, please look at, my lord, I'll not read all the other portions.
Yes,
My lord,
paragraph.
21, my lord. Para 21. A parliamentary legislation, when it receives the assent of the President of India and is published in the official gazette, unless specifically excluded, will apply to the entire territory of India. If passing of a legislation gives rise to a cause of action, a writ petition questioning the constitutionality thereof can be filed in any high court of the country. It is not to be done because a cause of action will arise only when the provisions of the Act or some of them, which when implemented shall give rise to civil or evil consequences to the petitioner. A writ court is well settled, would not determine a constitutional question in a vacuum. So therefore, my lord, the court must have the requisite territorial jurisdiction. An order passed on a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view the provisions contained in subclause 2 of Article 226 of the Constitution in India, will have effect throughout the territory of India, subject, of course, to the applicability of the Act. So,
Yes.
so this
And
is
the
the
judgment?
this is the first aspect.
Yes.
Second, my lord, is a division bench of this honorable court. One there.
Yes.
Lord, this again, my lord, arose.
Paragraph,
My lord, this, my lord, unfortunately does not have paragraph.
page number.
Say third page, my lord.
Hmm.
This is again, my lord, a matter pertaining to debt recovery tribunal.
Hmm.
My lord, I'll just read, my lord, the third paragraph. A learned single judge in the third page, my lord.
Hmm.
A learned single judge who heard the matter felt that there was conflicting decisions in regard to the jurisdiction of High Court to entertain a writ petition filed against orders passed by debt recovery appellate tribunals. He also entertained a doubt as to whether the writ petition challenging an order of the appellate authority situated at Mumbai could be filed in this court. My lord, this is the Karnataka High Court. Therefore, he referred the matter to the division bench. On contentions raised, the following two questions arise for consideration in this petition. Whether a writ petition against an order passed by the debt recovery appellate tribunal situated at Mumbai in an appeal filed against an order of DRT Bangalore relating to a loan transaction which took place in the state of Karnataka could be filed in the state of Karnataka, whether the appellate tribunal was justified in reducing the rate. That may not be necessary. My lord, in relation to point one, my lord, this is a case where loan transaction took place here, company is registered here, and company is ultimately wound up here. It is a case where the loan was advanced in Karnataka. The mortgage property situated in Karnataka, my lord, same point A, my lord. Here also, my lord, mortgage properties are situated in Karnataka. And the respondents, borrower and guarantors are residents of Karnataka carrying on business in Karnataka. Here also, my lord, I am sought to be made as a guarantor. Therefore, the cause of action arose within the state of Karnataka. Hence, even though the order passed, order challenged in this writ petition is passed by a tribunal outside Karnataka, it is open to challenge in this court. We may here itself refer to the decision of this court in St. John's Teachers Training Institute versus Union of India, where a somewhat similar situation was considered, whether the order passed by a statutory authority situated within the territorial jurisdiction of a High Court merges in the order of the appellate court which is situated outside its jurisdiction. Unless there is any such factor giving rise to any cause of action, within the territory, such High Court will not entertain a writ petition merely on the ground that the original authority is located within the
So the
territory.
DRAT orders are questioned before this court.
Sorry, my lord.
DRAT order,
Yes, my
which
lord.
is in Madras.
Yes, my
You know,
lord.
when it is passed, that is
It is
maintainable.
trans, my lord.
No dispute on that.
Yes, my lord. Now, what is the factor, my lord, which is considered? Yes, my lord. The DRAT orders, my lord, can be challenged here. The principle is, my lord, the borrower is situated here. Here, the borrower is the company. Then number two, my lord, the properties are situated here. All the properties, my lord, of the company are situated, my lord, within the state of Karnataka. Number three, my lord, I am sought to be proceeded as a guarantor. I am residing at Bangalore. I resigned, my lord, from the company in the year 1999 at Bangalore. So therefore, my lord, all these factors will say that there is some cause of action. I am not saying, my lord, that the Delhi High Court does not have jurisdiction. If, my lord, two high courts, my lord, have jurisdiction, then, my lord, it is left to the convenience of the party, my lord, and it is invariably on the place where, my lord, he resides that will have jurisdiction in the matter.
Yes.
And the other judgment, my lord, is what is determinative in matters pertaining to, my lord, companies. My lord, is the place where the company is registered. This is the third aspect.
Paragraph.
My lord, paragraph number 15, my lord, 1-5. It is also noteworthy that the jurisdiction of the High Courts under Article 226, if exercisable respect of an order made by the Company Law Board, would be determined by the place where the cause of action or any part of it arises, and the Delhi High Court alone would not be the High Court for the purpose. The High Court within whose jurisdiction the registered office of the company concerned lies gives rise to at least a part of the cause of action would be entitled to exercise root jurisdiction under Article 226 of the Constitution of India. So therefore, my lord, what happens is, again in company matters, this is important because, my lord, matters pertain to recovery of debt pertaining to a company. My lord, company is a juristic person, has an independent existence. And therefore, even if tribunals outside the state of Karnataka were to pass any orders, then, my lord, the question will be the High Court which in which, my lord, the company is registered will have jurisdiction. My lord, last aspect is, my lord, then, my lord, if the warrant is sought to be executed, my lord, there is one compilation. Of course, this is on the merits of the matter. But then, my lord, just pass this on. Article 21 and 14 are considered.
I don't want.
In the first judgment, please take para 10 and 11, my lord. This is what essentially, my lord, we are trying to, my lord, canvas before the court.
Yes.
Lord, please take, my lord, running page 8, para 10. Lord, earlier paragraphs, my lord, they refer to the Law Commission reports and all those things. I will skip that. After all this, my lord, this is the conclusion. Equally meaningful is the import of Article 21 of the Constitution of India in the context of imprisonment for non-payment of debts. The high value of human dignity and the worth of human persons enshrined in Article 21, read with Article 14 and 19, obligates the state not to incarcerate except under law which is fair, just and reasonable in its procedural essence. Menka Gandhi's case has developed further in Sunil Batra versus Delhi administration, Sitaram versus state of UP, and Sunil Batra versus Delhi administration lays out this proposition. It is too obvious to need elaboration that to cast a person in prison because of his poverty and consequently inability to meet his contractual liability is appalling. To be poor in this land of Daridra Narayana is no crime, and to recover debts by the procedure of putting one in prison is too flagrantly violative Article 21. Unless there is proof of minimal fairness of his willful failure to pay in spite of his sufficient means and absence of more terrible pressing claims on his means, such as medical bills to treat cancer or grave illness. Unreasonableness and unfairness is such a procedure is inferable to Article 11 of the Covenant. But this is precisely the interpretation we have to put to the proviso to Section 51 CPC, and the lethal blow of Article 21 cannot strike down the provision as now interpreted. My lord, so what happens, my lord, is now, my lord, the situation which you are faced factually, my lord, is proceedings are initiated for recovery of debt of a company. Company has got assets. Official liquidator, my lord, confirms that there are assets. Now, my lord, when this is the fact, does the recovery officer, my lord, straight away get the right to execute a arrest warrant? Would be the question. Of course, my lord, if my lord holds that this court has got jurisdiction, my lords have said they will consider that. Why I'm drawing the attention of this honorable court is, my lord, when my lord imprisonment or execution of warrant is concerned, my lord, Article 21 comes. My lord, my liberty is sought to be taken away within the precincts of territorial jurisdiction of this honorable court. So therefore, my lord, if I am were to be arrested and I want to avoid the arrest, of course, on legal grounds that are permissible, not, my lord, deceitfully or going underground, then, my lord, definitely, my lord, I will have to approach the court where, my lord, my liberty is sought to be taken away under Article 21. The question would be, is it in a manner known to law? My answer would be no. Because for the debts of somebody else, my lord, I am sought to be penalized. Which is why, my lord, I am saying that the cause of action has arisen here. So on 4 points, my lord, I would
So,
say.
as I said, in those circumstances, the court would grant a transit bail and say, please go to the court which court has issued a warrant against you. Even those circumstances also, the courts can't consider. For example, a Delhi court
Yes,
has
ma'am.
issued a arrest warrant
Yes,
against you. Now you are within the jurisdiction of this court.
Yes, ma'am.
Looking at the urgency and the manner in which it's going to be executed, you come before the court would entertain it and will grant you a transit bail. But not, court will not say that, though no proceedings are pending here, because you're here, will
My
grant you.
lord, that is provided, my lord, the proceedings are in a manner known to law. Then, my lord, the court would say, you please seek for your redressal there. But if I am able to show.
There is a case where you are contesting. You are contesting the matter before.
Lord, I am not contesting the matter. In the sense, my lord, I appeared there. I brought it to the notice. I will just show the
And
proceed.
if that is the case, whatever you have stated, so you could have stated before the very same court and could have obtained some order from the court whether your court has jurisdiction or no jurisdiction. Again, is that you have your remedy of filing an appeal or
No, my
whatever
lord,
it
Delhi
is.
High Court, my
But
lord,
we can't keep the pending proceedings like that. I think the
Delhi High Court, my lord, has jurisdiction, no doubt. But, my lord, my submission is, well, it cannot be said that the Karnataka High Court has no jurisdiction.
So it is like, if your submission has to be taken now, the respondents will initiate the proceedings in Delhi High Court, you will contest it. You will initiate the proceedings in Karnataka High Court and they will contest here. And both courts will pass their own orders in their own
My lord,
jurisdiction.
if I have already initiated here, my lord, I cannot initiate
But
parallelly
they
in
have
Delhi.
already, but here, they have
Well,
already initiated and you
They
are a
have
party to
initiated,
that.
they have initiated before the DRT, my lord. DRT's order, my lord, is amenable to writ jurisdiction before this court. My lord, just like my lord said, my lord, DRAT order. Really, any order passed by the DRAT, if my lord, this court can interfere. Any order passed by the DRT Delhi, my lord, cannot also be interfered. If I had already initiated a proceeding before Delhi, then the law says, my lord, I cannot initiate it here. There is no jurisdictional, my lord, wanting for this court to exercise, my lord, jurisdiction. And, my lord, just because the proceeding, my lord, first of all, whether it is initiated there is correct or not will be a different question. But if an action, my lord, can be impugned here in this High Court, based on the 4 factors that I am pointing out, definitely, my lord, they cannot say that the other side cannot say that this court has no jurisdiction. So this court will have jurisdiction. Whether, my lord, this court finds fault with the process or not is an entirely different matter.
Yes.
But on account of these 4 factors, my lord, this court will have jurisdiction.
I'll consider, yes.
My lord, I appear for the respondent number 6, Union of India. My lord, if your lordship could kindly turn to page 12. I would be making submissions only with regard to prayer B, my lord. Declare that section 25.
Prayer B, my lords, we are not on that question at all. My lords
Prayer
are
B
still
is not pressed, my lord. I will just sit down.
No, it is not. My lords are asking me a question whether this court has got the jurisdiction.
My lord, I am making submissions on the prayer which is sought. If my learned friend says he will not press prayer B, I will just sit down. I will not utter a word.
If my lord friend
If at
wants to
all-
argue on B, let him argue. But then I must argue on the merits of my lord prayer B. Now my lords are only considering whether this court has got jurisdiction.
Then let him
My-
file a memo to that extent, my lord, that he would not press B, my lord. Otherwise, my lord, what happens is this, my lord. If prayer B is there,
No, whether he files a memo or not, the court prima facie is not convinced with the jurisdiction of this court. So I'll be passing
But
orders on
if
that.
it is only on the jurisdiction, my
Yes,
lord,
only on the
let
jurisdiction.
it be confined, let that submission be taken. It is only with regard to this, the jurisdiction, my lord. The reason is 25B is straight away covered by this decision. Lord, para F, section 25 and 28, validity held, recovery officer has to attach and sell the immovable property in order to recover the debts. He has the power to appoint a receiver for protection and preservation of such immovable property. Hence, section 25 and 28 are not arbitrary, unreasonable, or without any guidelines. Lord, I would just take your lordships to page 457. I'm sorry, before that, my lord, 455, para F. I'll just read the head note, my lord. I'll thereafter read the paragraph, my lord. Page 455, para 9. A perusal of section 25 and 28 of the Act cannot lead one to the conclusion that the same are arbitrary, unreasonable, and without any guidelines. It is quite clear that the order to recover the debt, the recovery officer has to attach and sell the immovable property, and that for protection and preservation of the same has the power to appoint the receiver management thereafter. 476B, my lord. I'll just take your lordships to 476B. That is the last page, my lord. It starts from 457.5, my lord. 457.5, the paragraph number 5.
Yes.
Please, my lord. The recovery officer, your lordship got it, my lord?
Yes.
5. The recovery officer may recover any amount of debt due from the defendant by restraint and sale of his movable property in the manner laid down in the 3rd schedule of the Income Tax Act 1961, while section 25 provides for the mode of the recovery of the debt either by attachment or sale or arrest or appointment of a receiver. Section 28 provides for the mode of recovery in addition to one specified in section 25. A perusal of the aforesaid provisions cannot lead one to the conclusion that the same are arbitrary, unreasonable, or without any guidelines. It is quite clear that the order to recover the debt, the recovery officer has to attach and sell the immovable property, and that the protection for preservation of the same, he has the power to appoint a receiver for the management thereof. I'll just skip the rest of the things, my lord. I'll just read para F, my lord. For the aforesaid reasons, while allowing the appeals of the Union of India and the bank, we hold that the recovery of the debt due to Bank and Financial Institution Act 1993 is valid piece of legislation. As a result thereof, the writ petition or appeal filed by various parties challenging the validity of the said act or some of the provisions thereof are dismissed. It would be open for the parties to raise other contentions on the merits of their cases before the authority constituted under the act, and only thereafter should a High Court entertain a petition under Article 226 or 227 of the Constitution. Therefore, my lord, I would just leave it to your lords. Now, my lord, the constitutional validity of 25 and 28 and various other provisions are upheld by virtue of this judgment, my lord. Since my learned friend is saying, my lord, he would not press that, my lord.
No, I am not saying that, my lord. Lord,
He's
my lords
making
were
submissions.
asking me on the question of, my lord, maintainability. Therefore, I made submissions on the maintainability. Because
No, even after hearing you, I am of the view that it is not maintainable. So there is no question of.
exactly, my lord, that is what I am trying to tell my learned friend. That, my lord, I have not argued on merits.
I'll record his contentions also. Yes, what about yesterday somebody was appearing on behalf of the official liquidator?
I'm appearing on behalf of the official liquidator, my lord. Insofar as prayer A, where the official liquidator has been concerned, my lord, we've already complied with the said order. In fact, we have issued a statement of reply in the said proceedings. In the statement, we have attached the status report, my lord.
You appear for which respondent?
Lords, I'm appearing for respondent number 4, the lender bank, who's today the certificate holder. My lords, the proceedings before the recovery officer in DRT.
File your objections?
No, my lords, I have not filed my objections, my lords. In fact, the records which have been produced by the petitioner itself demonstrate that
When is the matter coming up before the
29th of May, my lords.
Before?
The DRT, the recovery officer, DRT Delhi, my lords. And in fact, the petitioner was appearing, had not filed the list of assets. The recovery officer
When he appeared before the DRT?
On multiple dates. In fact, the writ petition has
I have
produced the order sheets.
the order sheet, my lord.
In those order sheets, it's recorded that the petitioner had appeared through a counsel, thereafter takes away the...
Before filing this writ petition, he was appearing?
Before filing of the writ petition. The petitioner was called upon to file list of assets, which was not done. The contention was raised that the official liquidator needs to submit the status report as regards the assets which have of the liquidated company. Now, that having been done, the official liquidator is also appearing before the recovery officer. So the entire issue is right now being heard and decided by the recovery officer, including the contention regarding assets of the liquidated company being sufficient, if at all.
File his objections there.
Milords?
Petitioner filed his objections in the case.
Milords, I'm not aware of the objections
Milords,
being
the
filed, but if they
petitioner
have
is in fact, the petitioner is in fact filed a discharge application before the DRT Delhi, my lords, parallelly to these proceedings to quash the said proceedings.
Because I'm not the counsel on record in Delhi, but I've sought instructions that they are contesting the matter also before the recovery.
Please come. The present petition is filed. What was the interim order granted in this?
My lord, interim order is not to precipitate, my lord, my arrest. My lord,
For 8 weeks,
arrest.
and that has
My lord,
not been given effect.
please see, my lord.
That's not extended.
No, my lords, that I don't.
No, subsequently, they said, my lord, they will not precipitate the matter, my lord.
In the given circumstances.
Where is that order? Let's see. I find one order at the beginning.
Yes, my lord.
After that, what happened? Only it is for a period of 8 weeks.
Yes, my lord. Subsequently, my lord, it was told that, my lord, there is no intention of arresting.
Interim stay of the order is on 15/7/2016 was the order.
Yes, my lord.
Then after that, interim order extended on 2017. Then after that, it is not extended. No,
No, my lord, it is not arrested because, my lord, my lord, I am not coming in the way of, my lord, recovery proceedings.
No, we are not on that.
Yes.
I'm only on the point whether the interim order is extended. Right from 2017, you are not having the benefit of.
No, my lord, interim order was not extended because, my lord, that threat of, my lord, arrest. They said, my lord, they are not going to execute that having regard to the pendency. Therefore, my lord, the court did not extend the order. Of course, that is not recorded in the order sheet. But, my lord, the question, immediate threat was, my lord, whether I should be arrested or not. In that regard, my lord, the court had granted an order. Subsequently, when the question was asked, they said, we don't want to, because there are other assets available. So they said there is no intention of executing that. Therefore, my lord, the court said, if there is no such threat, question of extending the interim order would not arise at all.
Well, as regards the certificate bank holder, I am not making any such submission as regards the sufficiency of assets. The recovery officer will be at liberty, because as we stand today, nothing has been actually come to me. So I am not making any such concession.
The following prayer. The case of the petitioner that the first respondent company approached the fourth respondent and submitted a loan application seeking for financial assistance for the installation of solar water heating system devices. Loan was sanctioned dated 29/3/1997. Pursuant thereto, a loan agreement was entered into between the first and the fourth respondent companies on 10/6/1997. In pursuant to the loan agreement dated 10/6/1997, the first respondent executed a deed of hypothecation dated 10/6/1997 in favor of the fourth respondent company, whereby first charge was created on the mobile assets with respect to solar water heating system devices of the first respondent company. Also, two deeds of guarantees dated 10/6/1977 and 19/7/1997 was executed by the petitioner. One Sri Anant Bhatt, another Rajaram Kandige and KT Vijay Krishna in favor of the fourth respondent. In addition to the said deed of hypothecation and deeds of guarantee, Rajaram Kandiga has also executed a demand promissory note dated 10/6/1997 on behalf of the fourth respondent company. It is on behalf of or in favor of?
Pardon, my lord?
It is on behalf of or in favor of fourth respondent company. Para number 3.
In favor, my lord, in favor.
In favor of the fourth respondent company. As there was, when there is a default on the part of the company, on the part of the first respondent company, fourth respondent sent a letter dated 28/2004, whereby they called upon the first respondent company to pay the amounts due under the loan agreement. Thereafter, the fourth respondent has instituted the proceedings, that is OA number 38 of 2006, before the Debt Recovery Tribunal, Delhi. It is stated that the second respondent, without properly appreciating the defense set out by the petitioner and without considering the factual scenario, has passed an order dated 30/4/2004, whereby the DRT held that the first respondent company, petitioner and the guarantor, are jointly and severally liable to pay an amount of rupees 93,83,527 with interest at rupees 13% per annum. A recovery certificate in this regard is also issued. It is stated that K.T. Vijay Krishna and Anant Bhatt were discharged from the liability under the deed of guarantee executed in pursuance of the loan agreement, and proceedings against Rajaram Kandiga have not been initiated, and only the petitioner has been singled out and arrest warrant has been issued against the petitioner. It is stated that the first respondent company already wound up by virtue of the orders dated 18/27/2025 passed by the High Court of Karnataka in company petition number 178 of 2004. Even prior to the institution of the proceedings by the fourth respondent before the tribunal on the petition filed with the Reserve Bank of India, the petitioner, who was the director of the company, has resigned in the year 1999 itself by virtue of a letter dated 17/9/1999, and the same was also forwarded to the jurisdictional registrar of companies. Now it is stated that the fourth respondent instituted recovery proceedings before the recovery officer and arrest warrant is issued. It is stated that on 23/10/2015, the official liquidator affirmed that the first respondent is under liquidation and the value of the properties of the first respondent company will be sold by the official liquidator, and that the same will be more than the amount involved in the recovery certificate. The official liquidator sought time from the third respondent to engage an advocate by virtue of the letter dated 22/7/2015. Despite the first reminder being sent to the official liquidator, stated report of the liquidation proceedings were not produced to the third respondent. On 4/12/2015, another reminder was issued to the official liquidator to file the status report. Again, time was sought by the counsel for the fourth respondent. It is informed by the counsel of one of the directors of the first respondent company that there was a meeting between the official liquidator regarding the sale of the assets. Since none appeared for the official liquidator, second respondent directed that one more reminder be given to the official liquidator to file a status report. The petitioner, pursuant to a notice issued to him, directed him to appear personally before the recovery officer, sent a communication informing him about his ill health and the deteriorating physical health condition. It is stated that the petitioner underwent a elective coronary artery bypass grafting on 6/12/2011. And the petitioner has underwent another surgery on 5/3/2016 and was yet to recover from the surgery. And he was advised for a complete bed rest and was also advised not to travel for a period of 1 to 2 months. It was under this situation that a letter dated 21/4/2016 was sent to the third respondent. The recovery officer, without considering the application or the medical condition of the petitioner, has proceeded to issue an arrest warrant against the petitioner. On the same day, one of the directors of the wound-up first respondent company submitted that the property of the company has been made available for auction, and the official liquidator is also ready to liquidate the property, and therefore a direction was issued to provide a fresh statement of accounts to the official liquidator. It is stated that Section 25 of the Act provides that the recovery officer, on receipt of the copy of the certificate under subsection 2 of section 19 of the Act can provide to proceed to recover the amounts of debt is specified in the certificate by wound up form, all the modes as mentioned therein. As there are, it is stated that the first respondent company which is under liquidation, there is sufficient assets of the wound up company to satisfy the liability of the fourth respondent. Despite this, the recovery officer proceeded straight away to issue an arrest warrant. In those circumstances, they are questioning the validity of section 25 of the RDBA Act before this court. When the next one, initially on 15/7/2016, an interim order was granted, interim stay of the order in RC number 81 of 2014 dated 1/6/2016 was granted for a period of 6 weeks from the date of order. Later, that order was extended on 25/8/2016, 28/11/2017, and thereafter, the said interim order is not extended. When this matter came up before this court has Azazil and CL and counsel appearing for the petitioner to argue on the maintainability of the jurisdiction of this court in entertaining this petition, when already the proceedings are initiated before the DRT Delhi and an order is passed. On that, Glen counsel for the petitioner submits that this court has got the jurisdiction for the reason the properties are situated within the jurisdiction of the High Court of Karnataka. Further, the company is in Bangalore. By the order passed by the company went into liquidation, and by the order passed by the High Court of Karnataka, the company was wound up. It is submitted that when the petitioner is residing in Bangalore and when an order of arrest was issued and the fundamental rights of the petitioners are violated, the High Court at Bangalore is having jurisdiction. In that regard, he had relied on the
validity. Since validity is challenged, my lord, this court will have.
And also it is submitted that the validity of the act can also be questioned in any court in India. In that regard, he has relied on, with regard to the questioning the validity of the act, he had relied on the judgment in case of Kusum Ingots and Alloys Limited versus the Union of India and another, reported in 2004-6, SCC 254, extract paragraph number 21 and 22. Then he has relied on another the judgment of a division bench of this court in Syndicate Bank versus Mrs. K. Chandrakala Lal Bhakta and others, reported in 2002, SCC Online Karnataka 227. He relied on this mark portion is there, that to extract. Then with regard to on the same line, he has relied on another judgment in the case of Stridewell Leathers Private Limited and others versus Bunkerpoor's Symboli Beverages Private Limited, reported in 1994, 1 SCC 34. Extract paragraph number 15. Relying on these judgments, it is submitted that the High Court of Karnataka is having jurisdiction to entertain the writ petition and the reliefs that are sought in the writ petition. With regard to the fundamental rights, the rights that are guaranteed under Article 21 of the Constitution of India, he relied on certain judgments, and as this court is on the jurisdiction of this court in entertaining this petition, this court feels that it is not necessary to consider all those aspects. On behalf of the sixth respondent, Union of India, the DSG submits that this issue with regard to section, one of the reliefs, that is really the prayer number B, to declare section 25B of the recovery of debts due to banks and financial institutions as unconstitutional. It is submitted that that issue is well settled by the Delhi High Court in case of Union of India and another.
Supreme Court.
Union of by the Supreme Court and Union of India and another was the Delhi High Court Bar Association and others. Where is it reported? No citation.
2002 4 SEC 27. 2002 4 SEC 275.
4 SEC 275.
Yes, ma'am.
Reported in 2002 4 SEC 275, wherein the Honorable Apex Court has upheld the validity of the constitutional validity of section 25 and 28 of the RDBA Act. He relied on that paragraph, this it 476. No, 475, it's number 5 it starts, and till A and B, then again F and G, extract. And it is submitted that as far as the Union of India is concerned, as in the light of the judgment of the Honorable Apex Court, that issue is settled, and that requires no consideration in the hands of this court. Land counsel appearing for the fourth respondent submits that the proceedings were initiated before the Debt Recovery Tribunal Delhi in the year 2014.
Recovery proceedings, my lords.
In 2014.
2014.
In the year 2014. And the petitioner who has appeared before the court who has appeared before the DRT has thereafter filed the present writ petition. It is submitted that the petitioner has to having participated in those proceedings before the DRT at Delhi, the petitioner cannot come before this court by filing the instant writ petition. It is in instant writ petition. It is submitted that the writ petition before this court is not maintainable. Official liquidator is which respondent?
Respondent number 1, my lord. We are appearing on behalf of the company itself.
Appearing for the respondent number 1 submits that they've already submitted all the details before the before the DRT Delhi.
The recovery of
DRT Delhi, my lords. My lords, one clarification. The prayer sought is regarding RC 81 of 2014, which has subsequently been transferred to DRT Delhi 2, my lords. So that it's been recorded in TRC 793 of 2022, my lords.
What is that, DRC?
DRT, my lords. It's been transferred from RC number 81 of 2014 as sought for in the prayer. That recovery certificate, those recovery proceedings have been subsequently transferred into a TRC proceedings before the DRT Delhi to recovery officer number 1. So the transfer had happened in 2022 and it has been renumbered as TRC number 3.
No, where are those details?
The official liquidator statement of objections, the proceeding numbers are there, my lords. The statement filed by the official liquidator on 21/11. The last annexure is the online status of the recovery proceedings.
One minute.
Lords, the RC proceedings have only been transferred and renumbered. That's the submission that my learned friend is making. page 15 of the.
No, yes, find one judgment.
No, my lords, prior to that on 21 level. The only submission is regarding
It
the
was-
change of the number of the recovery
Have a
proceeding.
copy of it.
Yes, my lord.
Please pass on. What did you write? As such, nothing survives for consideration in the petition as far as PAN number A is concerned. It is submitted that now the proceedings are transferred to the Debt Recovery Tribunal, Recovery Officer 1, Debt Recovery Tribunal 2, Delhi. And it is renumbered.
Renumbered as TRC now.
As it is renumbered as TRC number 793 of 2022.
Yes.
Please, ma'am.
2022. Yeah, it is, yeah, what is it, why you, what is, you're relying on some judgment?
My lords, on a previous date of hearing, the learned counsel for the petitioner had stated that there was a doubt regarding the certificate holder bank standing outside winding up proceedings. That has been clarified in the judgment which I produced, my lords.
It is submitted that as the fourth respondent and the first respondent and the petitioner are contesting the matter before the DRT Delhi, before the recovery officer. This writ petition is not maintainable. Having heard the counsels on either side, there is a material on record. The writ petition as filed and the reliefs as sought before this court are not maintainable. The respondent number 4 has initiated the proceeding before the Debt Recovery Tribunal Delhi. An order is passed, then the recovery proceedings are initiated. At that time, as the petitioner has failed to appear before the recovery officer.
He appeared thereafter did not appear and file the list of assets. Demand notice was issued.
List of assets is filed. I produced the certified
It
copy
is like
of assets.
after the recovery officer, after that the arrest warrant is issued. That is questioned before the court. The submission of the learned counsel to the petitioner, relying on those judgments in the considered opinion of this court, will not come to the rescue of the petitioner. There is no dispute about the fact that this court, the petitioner has argued on with regard to the jurisdiction about where the company is situated, where the petitioner is residing. The fourth respondent company is situated in Delhi.
Yes, the head office.
Is situated in Delhi, and they've initiated the proceedings in Delhi. If according to the petitioner, the proceedings cannot be maintained before the DRT Delhi, and it has to be within the jurisdiction of the jurisdiction of Karnataka or the DRT at Karnataka or the High Court of Karnataka, the petitioner ought to have brought it to the notice of the DRT and ought to have obtained an order from the DRT. When an order is already passed by the DRT and when the matter is at the state of recovery of before the recovery officer, the petitioner has come before the court. In the considered opinion of the court, such a procedure is not available, and the party cannot be permitted to, having already participated in those proceedings, cannot come before this court, questioning the jurisdiction of the courts at Delhi. The only courts available to the petitioner is before the courts at Delhi. Then coming to the aspect of the arrest warrant that is being issued. They have issued the arrest warrant as per the procedure as contemplated under section 25 of the RDBA Act. The petitioner has questioned the constitutional validity of the Act. When it is a submission that in the light of the judgment in case of in case of Kusum Ingots and Alloys Limited, that the constitutional validity can be questioned before any court. The petitioner is questioning the constitutional validity of section 25 of the RDBA Act. 28 or 25?
25.
25 of the RDBA Act in the light of the fact that the recovery officer has issued an arrest warrant when other properties are available and when the company is in liquidation, such a warrant cannot be issued. And the procedure as contemplated under section 25 of the RDBA Act is unconstitutional. As argued by the learned DST, the constitutional validity of the Act is already upheld by the Honorable Apex Court. Be that as it may, in this context, when the petitioner is questioning the constitutional validity of section 25 of the RDBA Act, basing on an order that is passed by the recovery officer, an arrest warrant that is issued by the recovery officer, when this court is of the view that the petitioner cannot question any of the proceedings that are initiated before the DRT in Delhi or the recovery proceedings before the recovery officer at Delhi, then this court is not inclined to go into the said aspect, and the petitioner, the judgment that's what so and so is also not applicable to the facts of the case. In view of the above discussion, the writ petition before this court is not maintainable, and the only remedy available to the petitioner is to go before the DRT, before the recovery officer, where the proceedings are pending. As far as the interim order is concerned, as the interim order is not extended right from the year 2017, this court is not inclined to give any protection to the petitioner.
All questions on merits
All
are
the
kept,
questions on merits are kept open.
but some protection may be granted till I
Because it
approach.
is not there from 17. That's why I've specifically asked.
No, my lord, it is not there. That is because, my lord, they said they don't intend to arrest.
But we can't, but I cannot do something which is not there from the last 8 years. If they're not doing, they will also not do now.
That is all right, my lord, but then some protection that, my lord, since my lords have relegated me, my lord, let them not arrest
You
me.
say, why you have not executed the arrest warrant right from that time?
Milords, in fact, the arrest warrant was issued in the year 2016, and thereafter they had approached this honorable court. Now, Milords, the proceedings are being going on, and we have been trying our best to get whatever assets are available and recover it, Milords. So
what do you say about this?
Milords, as regards the recovery officer's powers to issue an arrest warrant, Milords, the court is the power has been upheld. In fact,
What then in that case we'll say for the next 4 weeks from today, or from the date of receipt of the copy of the order till 4 weeks, there shall not be any coercive steps.
Milords, in fact, the objective is not to arrest. The
Yes.
objective is only
No,
to
that's
recover
what
and
he's
use.
asking.
Yes, Milords. As long as they are
shall not-
participating before the recovery officer and
Petitioner,
appearing, the recovery officer will not exhaust that remedy.
Counts for the petitioner. The respondent shall not take any coercive steps for a period of 4 weeks from the date of receipt of the order.
Great.
Yes.
Milords, the respondent, only the recovery officer, because otherwise my recovery procedure, if it said only respondents may not precipitate, I will not be able to.
Coercive steps or by the recovery officer.
By
isn't
the
it?
recovery officer.
Recovery officer is which respondent?
Well, third respondent.
Third respondent.
Great.
Yes.
Milords, can it be further qualified coercive step as regards arrest? Because otherwise even
the-
attachment and
There shall not be any, the petitioner shall not be arrested for a period of 4 weeks from the date of receipt of the copy of the order.
Great.
Cell number 2, Sumana Naganan, for petitioner. Aditya Narayan.
Thank you.
This is that matter where your
Yes,
lordship
yes.
had asked the union.
What happened in this?
Lord, let it be referred to mediation before the mediation center, my lord.
Here itself.
My lord, insofar as that OM is concerned, my lord, it is not for the commercial transaction, my lord. It's only for financial transaction, my lord. Therefore, my lord, this matter can be referred to the mediation center, Bangalore Mediation Center, my lord. Let them decide that. We'll go before the mediation.
Very well. Let it be in some time bound.
Considering the nature of dispute between the petitioner and the first respondent company.
Please.
For the first respondent, the The parties are directed to appear before the Bangalore Mediation Center on
And somewhere in first week of April, not.
Very well.
on 8th of April. On 8th of April.
Great.
Yes.
Lord, you may direct that this matter be called within some time-bound manner, my lords. Otherwise, it should not extend there. Already, it's been 6 years that I've been pursuing, my lords, for this relief.
Then it should be after in the, shall I give a date in the month of June?
Possibly, my lords, first week of June. We'll also
Yes.
cooperate and
This
try
is
and
matter on 8th of June.
Very well. Grateful.
Yes, next.
Cell number 3. Cell number 3.
Interim order may be.
Interim order earlier granted is extended till then. Yes,
I'm appearing for the respondent, my lord. We have not received the petition copy also in this matter yet.
No representation for dismissal on second.
Cell number 4.
Obliged.
Suresh V.
Respondent number 1, my lord.
Ratna Kumar.
Matter was heard in length, last date of hearing.
The copy has been served in the morning today. Lordships will fix a date for hearing. In fact, your lordships have heard this matter.
In length.
And in length. Thereafter, your lordships felt that, my lord, it requires consideration. Any date may be fixed, we are ready.
Yes.
Lord, as regards, my lord, my learned friend submission that it was, my lord, my lords had heard this matter at length, but considering, noting the fact that there was an alternative remedy, it was to be disposed of by relegating them to the appropriate tribunal. That time, my lords had made an observation, we should file a written arguments. Written arguments came to be filed. I am not making an allegation. We had filed the first set of written arguments in the office. Office misplaced it 2 months back only, my lord. And we had served them by a way of email then. Even now, as a matter of abundant precaution, we have served it again. Same thing we have served. And if the order sheet is to be seen, my lord, it is coming at the stage of, my lord, for almost more than 2 years. Nothing is paid. 75 crores is the due. And your lordships, my lord, whether there is an alternative remedy, whether they can be relegated or not, we have made our written arguments. We have served a copy. It can come on any of the dates, ensuing dates. My lord, from our end, we have filed our written arguments. We will not come in the way of the court, because last time there was a lot of, my lord, exchanges. We were not virtually permitted to, my lord, submit. We have filed the written arguments. It can be set on any date, my lord, for.
This is matter on 15th of April. Yes, next 5.
Cell number 5. Cell number 5. Patan. Yeah, Acharya Farad.
On the last occasion, Lordship was pleased to pass on the judgment about the alternative remedy. Now, the Phoenix Arc Private Limited, I think your Lordship has a copy, and that's not at all applicable to the facts of the present case. Because here is a case, the earlier, I have not challenged the section 13.
The case is not about, I am only on the bank, not on
even
the facts of the case.
No. The one case is that we cannot approach the High Court directly. But here is a case, my lord. That's what I request your lordship. Apart from distinguish the facts of the present case, I may be permitted to take your lordship to the previous order of this honorable court. I had approached earlier. In fact, here is a case. The property which is sought to be brought for.
It's not going to that.
No. This is very important, my lord.
Please.
This per se.
The court might have entertained. That's not.
No. It's not the question. 2020, there was a direction, and how that DRT has dealt with that, your lordship may kindly see. Now the DRT is required to record a finding whether the property which is sought to be brought. I am not allowed. There is no security of interest by the petitioner. I have not mortgaged this property. Somebody else has mortgaged some other property which has nothing to do with this, and this honorable court has already come to the conclusion that even the DRT has directed the bank to produce the order of the land tribunal from which the title is flowed. Now that itself has been quashed by this honorable court, and it is a bogus order. This order, I have produced that order also. In spite of that, though the finding is to the effect that whether my property is applicable or not, it has not gone through that, my lord. Your lordship, kindly for a moment, I will take your lordship to the order of this honorable court about whether the order of the land tribunal from which the bank has given a legal opinion, it has sent that property. Now there is a dispute with respect to the property in question, No, I had approached
When
this
an
on.
order is passed, why you are not going to the DRAT? Why
No, you are not sure. Why, I mean, it's virtually sitting in judgment or the order of this honorable court. There is an order of this honorable court. Now I have to go before the DRAT to see whether this order, honorable, has come to the conclusion that the property which is sought to be brought for sale has nothing to do with that. There is not property. The very order of the land tribunal has been quashed. Even the DRT has directed them to produce the order of the land tribunal dated 21/4/1977. That has been quashed by this honorable court, and it is a non-existent property. Kindly see page, now this order at page 79, when annexure C, then virtually this order will have to be examined by the DRT. Kindly see 79 page, my lord, annexure C order, wherein last operative portion I'll not take trouble, your lordship. 93, order dated 21st April 1977, said to have been passed by the respondent land tribunal, would be nullity in the F law. Now the person who had mortgaged this property in favor of the bank is a party here, and this order has attained a finality on 18th June 2020. Till date they are not challenged. Now the DRT doesn't even bother to go into that.
Come to the order of DRT.
Yes. Now kindly I will take you to the relevant portion of the order of the land, DRT. Kindly see for a moment. It is at page commencing from annexure A, page 47.
Yes.
Yes, ma'am. That's why this bank has been called upon to file a statement of judgment before this one. Page 66. Where? The running page 66, my lord.
Yes.
Yes. The first issue for consideration in the matter is that the bank has issued section 13(2) demand notice after classifying the account as NPA, to which the applicant being a third party. Now, a third party, I have nothing to do with that, has raised objections inter alia disputing his property by the bank.
What is your case? Who are you?
I am an owner of the property.
When did you purchase?
It is an order that has been conferred. Occupancy right came to be conferred on me as back as in the year 1980. I have produced the order of the land tribunal. 1980.
Where is that?
It's in Canada, but there is no issue that has been upheld by this honorable court. My order, the order is at annexure D, my lord. That is order dated 27/12/19. I can only point out your lordship annexure D, typed copy. The order of the land tribunal dated 27/12/1980. This order has been upheld by this honorable court, and their order, the 21/4/1977 order, has been quashed, and the property covered therein is non-existent property. The property is not at all there. In spite of that, when there was a attempt, my property was sought to be sold. I am not even a borrower. When that was, I approached this honorable court in 2020, and the bank was called upon how the legal opinions, how the properties.
We'll go step by step.
Yes, yes.
Let me understand first.
Yes.
What is your property?
My-
What is
my
the buyer's
title-
Property?
Yes.
Which writ petition you have filed? Writ petition number?
Which writ?
There are two writ petitions.
Yes, yes. Earlier writ petition number is 9364 of 2020. That is at annexure K, page 136.
Not that writ petition. Writ petition with regard to your
Yes, that is annexure. 1 minute, Lord. Annexure C, page 79.
Yes. Writ petition number.
Writ petition number 25781 of 2012.
Please come to the discussion part.
Yes. Page 90, my lord. Paragraph 10
Yes,
from
please
there
read.
on.
Please read.
In the light of submission made to land in council appearing for the parties, it is not in dispute with respect to the fact that the land in question belonged to respondent number 5 Mutt, whereby the respondent number 5 Mutt leased the land in question in favor of respondent number 2, he Ashok Pai, as per annexure B and C produced in the writ petition. In turn, the respondent number 2 Ashok Pai subleased the land in favor of in the annexure petitioner J. Vijayendra Naik in writ petition number so and so, as per annexure lease dated so and so. The petitioner Vijayendra Naik has produced a receipt for payment of rent made in respect of the land in question as per annexure E and G.
What about the other respondent is not served?
Here, my lord. No, as far as these all land, the persons who are claiming tenant,
Is he a party to this proceedings or not?
In the present proceedings, they are not party.
Yes.
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 Yes. As produced a receipt made in the respect of the land in question as per its name. It is pertinent to mention here that petitioner J. Vijayendra Naik, who is deceased and who is the present petitioner, has filed application seeking occupancy right in the 2 bits of land in land bearing number 159 of village Udupi Taluk, and the said proceeding respondent number 2 Ashok Pai entered appearance and deposed that he had a consent for granting of occupancy right in respect to the petitioner J. Vijayendra Naik. The respondent number 5 Mutt was also placed ex parte. The respondent land tribunal, after considering the material and record by its order dated 27th December 1980, conferred occupancy right for the entire extent of 25 cents in each 2 bits in survey number 158 of Shivali village. In furtherance, form number 10 has been issued by the respondent competent revenue authority as per NXAL, which concludes the issuance of occupancy right. It is also pertinent to mention here that the land in question has been converted for non-agricultural purpose by petitioner J. Vijayendra Naik as per NXAL M and Win. In that view of the matter, I force in the submission made by appearing for respondent J. Vijayendra in writ petition number 25/781 of 2012 that the order dated 21st April 1977 is one which has been created to defeat the right of the petitioner J. Vijayendra Naik. It is also evident from Annexure A.
I have seen this.
Yes. Now, ultimately, operative portion of the order at page 93, this court comes to the conclusion that order dated 21st April 1977, Annexure A in writ petition 25/781 said to have been passed by the land tribunal would be nullity and accordingly disquashed. In fact, what has happened is there are 2 bits of land, 25 cents each. They have created, the person who had mortgaged the property, he says it is 40 cents of land. And he says it is covered under the order of the land tribunal dated 21st April 1977. But whereas the order in respect of which these 2 lands I have been conferred with occupancy right on 27th December 1980. So this order passed by the land tribunal is confirmed. So I have got a title, and the tribunal now says there is no declaration that I have been declared. That is.
Please come to the
Yes.
order.
Shall I come to the order of the land? Tribunal.
Order passed
Yes,
by the
yes.
court in the earlier writ petition. Where is it?
Earlier writ petition, my lord. Yes. Annexure K.
Page number.
Page number 136. May I, a relevant portion, my lord, may I take your last?
Yes.
I had approached this on court when the property, I had already initiated proceedings under section 17. In spite, there was no interim order by the tribunal. In spite of that, the property was brought for sale. It is my property could not have been brought for sale. I'm not even a borrower. At that point of time, when it is sought to be auctioned, I approached this honorable court as back in the year 2020.
Yes, I have seen this.
Yes. Now kindly see page number 138. May I take your lordship?
Seen that. I've
Yes.
seen. Please come
Yes.
to the DRT order.
Present order, my lord. Yes. There is a clear direction. Now the present order of the DRT, page 40, Annex 66. I just one minute. Paragraph 42. May I take your, may I read, my lord? The first issue for consideration in the matter is that bank has issued section 13(2) demand notice after classifying the account NPA to which the applicant being a third party has
reading
page 66, paragraph 42. I'll read further because the first issue for consideration in the matter is that bank has issued section 13(2) demand notice after classifying the account as NPA to which the applicant being a third party has raised objection inter alia disputing his property by the bank's borrower Bhaskar Shetty and had raised contentions by the legal notice 16/3/2005 to which the bank has suitably replied by document number 1 contending that borrower had mortgaged the property on default after classing with the account NPA. Bank has proceeded further in the recovery under Surface Act. The issue before this is a consideration. The issue before this honorable tribunal to ascertain whether the bank initiated measures under Surface Act and have followed the procedures in issuing statutory demand notice and possession notice and also measures as contemplated in the Act. It is manifest from the records the respondent has sanctioned the loan to its borrower Bhaskar Shetty, who had created mortgage in respect of land survey number 159 1A21 measuring 40 cents of land favoring the respondent bank See from annexure sale deed dated so and so, executed by Ashok Pai in favor of Bhaskar Shetty, deceased borrower. The receipt in the sale reflects that Ashok Pai had acquired land tribunal proceedings on 21/4/1977, granting occupancy right in favor of Ashok Pai and issued for number 10/15/498. Based on the land tribunal occupancy certificate, Ashok Pai executed sale deed in favoring Bhaskar Shetty, the borrower, after converting the land into residential purpose with a order of deputy commissioner dated and case Bhaskar
Yes,
Shetty
we'll
had.
ask him, we'll ask. What do you say?
The bank has been issued with the notice. I am yet to receive the instructions from the bank, my lord, with regard to the notice ordered on the bank. And my lord, by oral instructions that my lord, the very same petitioner now has approached the bank with my lord, with the prayer for one-time settlement of the due. On what capacity he has approached the bank with regard to the settlement of the scheme under 1
I have nothing to do with it.
But my lord,
Face of it, the order passed by the tribunal is bad because the tribunal has proceeded on a premise that it will not adjudicate the rights of the parties. It is already adjudicated, it is crystallized. Now, as per the order of this court, according to him, which has attained penalty, whatever the occupancy rate that is issued in favor of the borrower of the bank is set aside, and his rights are affirmed in respect of the property. So there is no question of crystallizing the rights by the tribunal. Already it is by the High Court. It is already done.
but looking into the writ petition papers, my lord, which has been served on the bank, now let me have an answerable defense, my lord, so that I will file my objections.
Pose this matter for orders on 9th of April.
The second week, my lord.
Huh?
Second week, 10th or 12th.
On 15th of April.
Please, my lord. Great.
14th is a holiday.
Heard in part.
15th.
Number 6.
Yes.
Cell number 6. Telecast B, for petitioner.
2 weeks time will be granted to comply the observation.
No office objection. What is the writ petition
Sale
about?
did not take place, my lord.
DRT,
Sale
madam.
has been cancelled, my lord.
One
This
minute,
honorable court.
Let's see the prayer. Come to the prayer. Set
Kindly
aside the
after
auction
next week, my
sale,
lord. Senior is not
which
there.
is consequently versus from issuing sale certificate.
But kindly after next week, my lord. Senior is not there.
Sale is being cancelled. Auction purchaser did not pay the remaining amount. The
It is
sport-
cancelled.
No, my lord. In this case, he has paid 25%, my lord. After,
It is cancelled, it seems. That's for him to say, isn't it?
okay, my lord. Kindly after next week, my lord, because they are returned the amount, we don't know.
You are the auction purchaser.
No. I am the.
Who are you concerned? The writ petition is filed, seeking the following prayer. The matter came up for hearing and counsel appearing to the respondent bank submits that the auction is cancelled as the bidder has failed to pay the amount.
Please, my lord.
The bidder has failed to pay the amount. When the relief that is sought in the writ petition is to set aside the auction and not to issue the sale certificate. When the respondent themselves have cancelled the sale, nothing survives for consideration in this writ petition. Accordingly, the writ petition is dismissed as instructions. Yes, next.
10,000.
I appear for the petition in this case, ma'am.
Yes.
Unless I have received the statement of objections, kindly apply for 1 week time for filing rejoinder amendments to the statement of objections.
Time for respondent bank, let's
Come to the prayer. What is that they are seeking in this?
For the return of original
Bank
documents.
to return the original title deeds of scheduled property which have been unlawfully withheld despite the full repayment of the loan amount. Why it is withheld?
Lords, the petitioner has had availed a credit facility by monthly basis, my lords, for the working capital, my lords. And the petitioner is yet to pay the unapplied interest, my lords, unapplied interest and also the actual
How much amount
expenses.
is due as of now?
23 lakhs 11,859.
Then counsel appearing for the respondent bank has filed the objections and stated that the petition is yet to pay an amount of rupees 23 lakhs.
23 lakhs
23
11,859.
lakhs and odd. As such, the title deeds were not returned to the petitioner.
Yes, ma'am.
Then counsel for the petitioner submits that he'll file his rejoinder. This is matter on 16th of April.
Cell number 8. Nandish Patil, for
Yes,
petitioner.
extension of time.
Petitioner.
There is that letter. Extension letter. This court has disposed of the matter on 11th November 2025. When was the order copy received? When was the order copy received by you? This court has disposed of the matter on 11th November 2025, directing the court to decide the case on merits within 4 weeks from the date of receipt of a copy of the order. And the letter is addressed on 22/2026. And why is it placed now? A letter of 22/2026. Why is it placed in the month of March? Ask the distribution. Your presence is not necessary. I'll pass orders in the afternoon. Ask the registered judicial why it is placed after a month. Yes.
My lord, so serial number 9, C. Vinay Swamy undertakes to file wakalat for respondent. My lord, the sale has not been taken place for the want of bidders, and the matter has been settled under OTS.
It is settled?
Yes, my lord, it's settled under OTS.
You are Mr. Vinayak Swamy.
C. Vinay Swamy, my lord. My senior name, C. Vinay Swamy.
There is no representation on behalf of the petitioner. The writ petition is filed seeking the following prayer. Then counsel appearing for the respondent bank. Mr. Vinayak Swamy submits that he has.
C. Vinay Swamy, my lord. Vinay.
C. Vinay. Huh?
Vinay
Vinay
Swamy.
C. Vinay Swamy submits that he has instructions to file wakalat on behalf of the respondents. It is submitted that the entire the loan amount is the loan is paid through OTS, hence nothing survives for consideration in this petition. Considering the fact that already under OTS the entire money is paid, the account is closed, nothing survives for consideration in this petition. Accordingly, dismissed as infractions.
Number 10, R.S. Rajesh.
Serial number 10, my lord, I am permitted to appear in this matter. My lord, after filing the writ petitions, my lord, this court refused to grant any interim order. On 19/12, my lord, order to issue emergent notice. Thereafter, my lord, on 29/12/2025, they filed essay in essay number 20 of 2026 before the Honorable DRT. My lord, now the matter is seized before the Honorable DRT. Even otherwise, that it is not maintainable against me.
The writ petition is filed.
Challenging the possession notice.
Seeking the following prayer. The notice was issued and no interim order is granted. Notice was issued by this court
On
19/12/2025. Today when the matter came up, there is no representation on behalf of the petitioner. Land counsel, Mr. So-and-so, Francis Xavier, appearing on behalf of the respondent bank, submits that when after this court has issued notice to the respondents on 29/2/2020.
12.
29/12/2025, the petitioner has approached the DRT by filing essay number 20 of 2026. Considering the fact that the petitioner has already availed the alternative remedy, nothing survives for consideration in this writ petition. Accordingly dismissed.
Much of.
Cell number 11, Kenduri
Petitioner,
SM
my lord.
Petitioner.
A week's time may be granted to
So,
comply the appeal objection. To comply the appeal objection.
So let's see what's the writ petition about.
Requesting the annexed case, my lord.
Let's see.
I have filed
there
wakalat
is-
for respondent number 2 in
One
this
minute,
matter.
1 minute. Directing the first respondent not to precipitate action proceeding inside under Securitization Act. Recovery proceedings as illegal.
In the trial court, my lord, OS filed by me. OS suit is filed by me, lordship. The trial court granted interim order of stay. In spite of that, they are,
No, if they're proceeding in spite of that, your remedy is not to come to the High Court saying that they're proceeding. The remedy is whatever the violation of the orders of the trial court, you prosecute them on that.
Your Lordship, he is the second respondent. Respondent number one is the bank, Your Lordship.
That's what I'm
Notice-
saying.
notice
But
that-
that you will not file a writ petition. This is not an executing court to execute the order of the trial court. Please get instructions. The writ petition is not maintainable.
The week's timing.
Yes. This is matter on 8th of April, no further time.
And kindly, interim order may be.
Interim order earlier granted is extended.
They may be
In
directed,
this, there is an interim order.
Yes.
they may be directed to furnish copies of
Then counsel for the petitioner shall serve the copy of the writ petition on the counsel appearing for the bank.
and respondent number 2.
Cell number 12.
My lord, kindly pass over the matter.
Appearing for the respondent, Your Honor. I have not been served with the copies. Your
Copy
Honor.
is already served.
No, Your Honor. Copies has not been.
Anyway, she's saying serve the copy.
Will
We'll have it on some other day.
Please.
Yeah.
The counsel of the petition serve the copy of the petition on the counsel for the respondent. This is matter on 16th of April.
Offline.
Yes.
Cell number 13. Samis. Firma for petitioner.
For the
Done.
I appear for the petitioner. I'm a new entrant, my lord, to the old litigation. Constitutional validity, my lord, of a provision of Succession Act is under challenge. Therefore, my lord, grant me a week's time. I'll file a synopsis and we'll go ahead with the matter, my lord. It's been pending for a long time.
But with your lordship's kind leave, I filed an IA, my lord, for impleadment. The IA is numbered, but it's not on board today. If that can also be listed, my lords, any date subject to your lordship's kind convenience.
IA number?
IA number 1 of 2026.
Who are you?
My lords, my name is Suhrit Parthasarathi. I appear for Ms. Deepika. I'm my lords, one of the relatives. I'm a party to the partition suit, which has been filed by the petitioner. I've was arrayed as a defendant in the partition suit and subsequently transposed as a plaintiff. So any ultimate decision that your lordships will take, my lords, will have a bearing on my rights as well, which is why I'm seeking impleadment.
The matter, my lord, fair. At their instance, on a other this thing, they took up the matter before the Supreme Court. Supreme Court has directed the trial court to complete the suit within a period of 1 year.
Is there in this?
There is an interim order. Now, trial court is posting the matter every day, and I am prevented because of the interim order. I am prevented from taking up the main contention that the suit is not maintainable.
From 2015, there is a stay.
But this happened about a month back. Supreme Court passed the order on another petition filed by
We
them.
have to hear this matter.
Pardon me, my lord.
We have to hear this
My lord,
matter.
it has to be
There
heard.
can't be a stay from
Correct.
2015
It
on
has
a
to be
suit.
heard, my lord. It has been moved because, my lord, there is a order of the Honorable Supreme Court requesting the trial court to endeavor to dispose of within 1 year. That proceedings now, my lord, is going at speed, my lord. Therefore, they have moved the matter. I'm not, my lord, it has to be heard. I'll file a synopsis, my lord, and we'll argue, my lord, somewhere this side of vacation itself we'll do it.
But the difficulty is, my lord, in the trial court now matter is
No, it is posted for hearing on application filed by, my lord, for transposition and for my affidavit.
We'll have it on 8th.
My lords, my only request is, my lord, if your lordships would kindly have my IA sometime, my lords, even before that, if I can be brought, or I'll make my submissions on that date, my lords, subject to your lordship's convenience.
as far as he is coming on record, we have no objection, my lord, because he cannot
So
have any
formally
other
that day we
contention.
will, they say that they have no objection, we'll allow it on that day, on the same day,
As your lordship is. Your lordship is having it, my lords, on which date, my lords?
7th of
Seventh.
April.
Eighth
No,
April.
adjournment. We'll continue, we'll conclude it on that day.
Thought said 8th or 7th.
7th
Seventh.
or 8th. If you want 8th, it's fine. 8th.
7th is fine. My lords, if your lordships would have it on 7th itself, my lords, subject to your lordship's convenience.
7th.
I'm grateful.
Yes,
Cell number 14. Arun Bhatt for petitioner. KV Lokesh.
Yesterday it was heard matter. Not, I have to produce the statement. I'm also choose to file a memo for withdrawal of the petition. Lord, since the possession notice has been challenged in this case, during the pendency of the writ petition, Lord, they have withdrawn the possession notice, and now the fresh auction notice has been issued, fixing the, my lord, the auction on 27th, which is day after tomorrow. My lord, this court has ordered to pay, my lord, 50 lakh. That has been paid. Apart from the said amount, my lord, we have paid another 70 lakhs from the date of, my lord, obtaining the loan.
Why are we going back again to the yesterday's submissions?
Yes, my lord.
Yesterday, the matter is adjourned that you're going to pay the money. That's it. You're going to pay the money as per the statement furnished by them. That's it. No arguments on this today.
Correct, my lord. My humble submission would be, my lord, as per the mortgage deed executed by the petitioner and the respondent, 8% is the, my lord, they can charge, my lord. Now, after obtaining the statement, we came to know, my lord, they have charged 15% without any basis. That will have to be, my lord, challenged before the DRT, my lord. If this honorable court will permit, my lord, I will produce the statement wherein it is specifically mentioned.
Want to go to the DRT, please go. The
Yes.
court is not coming.
Yes. That is what my concern. Only, my lord, in the respect of the loan transaction, my lord, they are illegally, my lord, charging.
Take that.
If my learned friend want to produce a statement, let them produce, my lord, handing over the copy.
It is submitted that after they have questioned the public auction notice in this. Auction notice or possession notice?
Possession notice challenged.
Possession notice is challenged. They have withdrawn the same, and thereafter they have initiated fresh proceedings. And now the petitioner wants to challenge the same, apart from the other factors with regard to the interest and all. Hence, the petitioner seeks liberty to avail the appropriate remedy before the DRT. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the remedy before the DRT, and the petitioner shall have the benefit of section 14 of the.
No, one submission, my lord. Lord, day after
I'm
tomorrow.
not going to do
Lord,
it.
within 1 week, my lord, we will file it. Till then, my lord.
What you can't have it directly, can't have it indirectly also.
Lord, we have complied the order of this honorable court and also paid, my lord, more than the amount which is as on due as on today.
Petitioner shall have the benefit of section 14 of the Limitation Act. That's it.
Cell number 15, Srinivas.
I undertake to appear for the respondent bank, my lord. I received the file yesterday from the earlier counsel. I need 2 days time. My lord. This relates to a mortgage which is created in 2015.
Yes, we'll have it. You have an interim order?
Tomorrow, no problem.
You have an interim order, I'm asking.
Yes, my lord. I have an interim
This is matter on 21st of April. Interim order earlier granted is extended till then. Yes, explain. Huh? Or will delete the name of Mr. Vignesh Shetty with the name of Mr. Divya Purandu.
Cell number 16.
Lord,
Petitioner.
appearing for the bank.
Dr.
Lord, I've sought instructions, my lord, are the same, my lord. I leave it to my lords, my
Yes.
lord, because they have been enjoying stay, and so therefore. In
Where
this
is that?
30th May, already filed with undertaking.
The same one?
Please.
Yes, where is that? Take that undertaking.
My submissions may be recorded,
Yes.
my lord. Yes.
23-3. ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರಂತೆ.
Correct petition is filed. Seeking the following prayer. The bank has, the facts of the case are, the petitioner has approached the bank for a loan facility, for credit limit of rupees 1 crore 10 lakhs and post shipment credit limit of 1 crore 40 lakhs. Which for the agriculture sector. As a petitioner was irregular in paying the loan amount, the account is classified as a NPA on 11/12/2024. Thereafter, the proceedings under the Surface Act were initiated by the bank and a possession notice was issued on 24/2/2025. Then the petitioner has filed SA number 14 of 2025 before the DRT. Initially, an interim order was granted on 3/3/2025, subject to the petitioner paying 25% of the outstanding amount within 2 months in 2 installments, totally amounting to rupees 37,66,414. The petitioner has paid the said amount to the respondent bank as ordered by the DRT. It is stated that a sum of rupees 90,58,445.15 paise is due towards packing credit and a sum of rupees 48,69,865 is due towards the post shipment credit as on today. It is stated that the petition is ready and willing to repay the entire loan amount provided a reasonable time is given to the petitioner, as of overseas customers or delaying payments to be made to the petitioner against the goods exported to them. It is stated that due to adverse market conditions in the overseas business, the overseas customers are delaying the payments to the petitioner, which in turn affected the repayment of the loans by the petitioner. It is stated that in spite of bringing all these facts to the notice of the DRT, has failed to consider the same and has passed the order dated 27/2/2026, upholding a position notice issued by the bank on technical grounds. It is a contention that none of the grounds raised by the petitioner were considered by the DRT. Hence, the petition is before this court. Though normally this court is not entertaining the writ petitions that are filed against the order passed by the DRT, as they have any notice that is issued by the bank before this court, as they have an effective alternative remedy before the DRT or before the DRAT. However, in cases where the parties are ready to pay the amount within a reasonable time by filing an undertaking affidavit, this court is entertaining the application. The whole purport and purpose of the Surface Act is for the recovery of the amounts by the banks and financial institutions in a speedy manner. In this case, according to the Land Council appearing for the respondent, the outstanding amount as on today is.
Lord, I filed objections in that 1 crore 62 lakhs, my lord. 1 crore 62 lakhs 80,462.
Mention in the affidavit, sir.
As on 22/3/2026. 462. As on 22/3/2026.
As on 22/3/2026. The Land Council for the petitioner has submitted before this court. They are ready to pay the entire amount by September 30th, 2026. The bank is fighting the litigation before the tribunal from the account is declared as NPA on
11/12/2024.
11/12/2024. Almost for 1.5 year, the bank could not recover any amounts except the amount except the amount which is paid with the petitioner as a condition imposed by the DRT. When the petitioner has filed an affidavit before this court that is ready to clear the entire amount by September 30th, Land Council for the petitioner, the respondent bank, has submitted only that the bank is not interested for the said proposal. However, it is submitted that she will get specific instruction. Accordingly, the matter is adjourned to today. Today, the Land Council for the bank submits that the petitioner was enjoying the interim order for a period of 1 year before the DRT. And now for this proposal, the bank is not acceptable for the proposal. It is submitted that the present writ petition is not maintainable and the petitioner has to go before the DRAT, and the petitioner is further seeking another 6 months' time to repay the amount. And for that, he is not entitled for any such treatment from this court. Next, any such accommodation from this court, not treatment, any such accommodation from this court. Having heard the counsels on either side, there is a material on record. The outstanding amount is running into 1 crore and odd. The bank is fighting the litigation from the year 2024. The account was declared as NPA in the year 2024. Now, when the petitioner has come up before the court by filing an undertaking affidavit that he'll be clearing the entire loans by September 2030, in the considered opinion of this court, that is, in fact, in the interest of the bank, where they're going to be a quietus to the litigation, and also the bank would be getting the amounts within a matter of 6 months. This court is coming across cases where the interim orders are subsisting for an interim order that is granted on the surface of proceedings. Is the interim orders are continuing for years together, or the matters are pending before the DRT or DRAT. In those circumstances, granting the 6 months time as sought for by the petitioner for repayment of the entire loan amount is in the interest of the institution and the interest of the bank and in the interest of the bank. Full stop. At the same time, this court is conscious of the fact that if the petitioner does not pay the amount, or only for the purpose of seeking some time from this court, if such an affidavit is filed, that cannot be, the court is conscious of the same. And also will be imposed in the order, so that the orders of the court and the affidavit that is filed before the court is complied with in its true sense. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the petitioner to pay 20% of the outstanding amount by May 30th. That's what he said. May 30th.
30th May.
And the remaining entire amount by September 20th. Next, number 2, in case a petitioner fails to pay the first installment by May 20th, by May 30th, the bank is at liberty to proceed with the further proceedings, and at the same time, the petitioner shall pay an amount. The petitioner has to pay costs of ₹5,000 for not complying with the undertaking as given before this court. Next, number 3, the petitioner shall pay the remaining amount. And in case, in the second one, if the petitioner fails to pay the amount, the bank is at liberty to proceed, and he has to pay 5 lakhs to the bank as cost. Next, number 3, the remaining amount shall be, if not paid by September 20th, the bank is at liberty to proceed, and having obtained an order from this court and having not been able to comply, the petitioner shall pay an amount of ₹10 lakhs as towards costs to the bank. Accordingly disposed of.
Cell number 17 for dictating orders.
Yes, petition.
My lord, in this case, my lord, yesterday 1:30 this writ petition was served, and I sent the writ petition to the bank. Bank wants to file the objection, my lord. They want 1 week time. In this case, why my subsequent to that account has already been
Under the same caption, this is matter
yes, my lord.
on 9th of April.
Please,
9th
until
of
then,
April.
let them not take any precipitate action.
List this matter on 9th of April under the
No
same caption. At the request of Land Counsel for the bank for filing objection.
Yes, ma'am.
Till such time, bank shall not take any further steps.
Yes, ma'am.
Yes, next.
Cell number 18 adjourned. Cell number 19. Kavita N for petitioner. HS Rukoji Rao.
Who appears for the Canara Bank? Rukoji.
Rukoji Rao.
Give the file. Crash the Enoch auction. There is no representation on behalf of the bank as well as on behalf of the petitioner. The list is matter for dismissal tomorrow. Next 20.
Serial number 20. Serial number 20. Syed Jafar.
Give the file.
Moinuddin.
The writ petition is filed against Bajaj Finserv, a subsidiary of Bajaj Finance Limited, in the light of the law laid down in so-and-so that Rishabharti. The writ petition against the private finance company is not maintainable, accordingly dismissed. Dismissed as not maintainable. The petitioner is at liberty to avail the appropriate remedy in accordance with law. He shall have the benefit of section 14 of the. Yes, 21.
21.
My lord, sir, for the petitioner, kindly seek for adjournment after 2 weeks.
What about this?
Challenging sale notice.
Huh?
Sale notice challenging.
Sale notice is questioned.
Yes, madam.
Sale had taken place.
Oh, my lord. Senior is not in station. Kindly have it on tomorrow, my lord.
This is matter in the month of June.
22. TP Muttana for petitioner.
I appear for the petitioner, my lord. In this case, my lord, the bank sanctioned the loan to the borrower, and then the account has become NPA. And then the officials of the bank went to the borrower's house to take possession of the property. And then he was earlier agreeable, and they recorded some that Panchanama stating that these are all the documents are there. And subsequently, then one person.
Here you are seeking. Come to the prayer.
My prayer, my lord, my prayer.
Call for the records of criminal miscellaneous. Issue writ of certiorari requires the order dated 15/12/2024.
Yes, ma'am. Order passed under section 14. Now, then at the time that they did not allow him to take all the record Panchanama and all, they draw them out. Then they pasted on that symbolic possession and all came. They filed the application under section 14 for taking physical possession.
Why can't it be for the DRAT?
My lord, this issue is it is against the order of section 14, my lord. The DRAT, this is only section 14 order. 14 order what? Why, my lord? He says because you have recorded the Panchanama, you will not pass orders. Then the bank filed an affidavit. You have not taken physical possession. Panchanama, while recording only, they have sent him out. That is why you pasted symbolic possession. All the documents produced. And then that learned CGM court, they say no.
This notice to the respondents.
Respondents also notice is not required, my lord. Because
not required. No,
because section 14.
No, the court will not come here, isn't it? Court is not. We'll see because you made them a parties.
But then okay, man.
Whatever on the factual aspect, we need to have clarity from them.
On short date may be given, my
yes, no notice to the respondents, emergent notice.
Emergent notice.
To the respondents. This is a matter on 27th April.
Yes,
Serial number 23.
I appear for the proxy counsel for Ranjan Kelkar, ma'am. He will take notice.
So where is the counsel for the petitioner? What is it sought?
Where is?
Directing the respondent to release the excess amount withheld. So and so. What is the name of the advocate?
Ranjan
So and so
Kelkar.
submits that. Nandi, what is that?
Ranjan Kelkar.
So and so has instructions to file wakalat on behalf of the respondent. Respondent shall file their objections. List this matter in the month of June.
Serial number 24.
Well, in this case, my lord, petitioner obtained loan from the respondent bank for milk vending business, my lord. But there was also insurance was amount collected.
You know what is the order?
But I am challenging the public action.
It's a small. It's a private finance.
Yes,
it's
ma'am.
finance. In the light of so and so.
My lord, now, my lord, public action was conducted, my lord. Otherwise, till then, my lord, to protect my right. Otherwise, my lord.
File again is so and so. You know that already you have withdrawn
My lord,
50 writ petitions.
by
Why are
that
you
time, my
filing
lord, no,
again?
my lord. By that time, your lordship dictated in another case, my lord, in Karnataka bank, my lord. By that time, this writ petition was already.
The so and so is filed against the private financial bank in the light of the law laid down in Shubharati so and so. the writ petition against the private bank is not maintainable, accordingly dismissed, giving liberty to the petitioner to avail the appropriate remedy. Yes, 25.
Cell number 25.
My lord, one submission, my lord. Now the,
Please understand, when the writ petition is not maintainable, court cannot grant interim relief. That's a settled law. Please
my
understand.
lord, I'm
Yes,
not,
25.
till then, my lord, to protect my, my lord. Otherwise, public action is confirmed, my lord.
Understand,
Madam.
you have to make legal.
My lord, I
submissions.
know, my lord, in my other writ cases, my lord, you are
But
actually
other
passed, my lord.
cases, when the writ is not maintainable, where is a question of interim
My
protection?
lord, by that time, the writ petition was already filed, my lord.
We can't. Yes,
Therefore, my
25.
lord. My lord, if approach it, may immediately
But
consider.
it's DRT, but we know
Yes.
your protection.
Yes.
Yes.
Hearing for the petitioner, Your Lordship. I've challenged the order dated 6/1/25 of the DRT, Your Lordship, wherein my application filed for
Come to the
recall.
prayer. What is the prayer you are seeking?
Yes,
To quash the impugned order rejecting the recall application
Yes, Your
dated
Lordship.
in OS number.
OA number, Your Lordship.
No, you said OS number. 75. That's 15. What is the page number also? I'm not able to understand.
Your Lordship, the
It's 15 or 75?
page number 10, Your Lordship, the impugned order.
Look at your prayer.
There is a typographical error, Your Lordship. It is OA number 1946 of 23.
Where is the
Your
order?
Lordship. Page number 10, Your Lordship. Annexure A. Your Lordship, may I produce the
Where is the order?
daily orders, Your Lordship?
Where is the order?
Lordship.
No, where is the order? Where is the recall application?
Your Lordship, the recall application is in page number 29, Your Lordship.
And where is the order?
Order has been passed on 6/1/26, Your Lordship, page number 10, Annexure A, Your Lordship. This is the order that has been passed by the DRT.
Where is the recall application? Where is the order on the recall application?
Your Lordship, the order has been passed in just one instance, Your Lordship. Hence, it has been considered as dismissed, Your Lordship. They have not passed a detailed order, Your Lordship.
No. When the court has dismissed it for default, DRT has no power to recall the order.
DRT has.
Where is that? Where is that recall application before the
Application
DRT?
has been filed in, that has been marked in page number 29, Your Lordship.
Then where is the order? That's what I am asking. If you have filed an application, court must have passed some order.
Please, Your Lordship.
Where is that order?
The order has been marked in page number 10, Your Lordship, Annexure A. This is the order that has been passed.
It can't be this order. You have filed a recall application to recall the order dated 9/2/2025.
Yes, Your Lordship.
This order is dated 6/1/2026, sir.
Your Lordship, we want to recall the order.
No, you file a recall application and you are not present again before the court.
Your Lordship, I have produced the entire daily orders, Your Lordship. May I show, Your Lordship? Your Lordship, we were absent on the second date, Your Lordship. That is on 31/1.
Where is this 19/2/2025 order?
19 to 6/1/2025, Your Lordship.
Come to page 29. What it says? You want the order dated 19/2/2025 to be recalled.
Yes,
Where
Your
is that 19/2/2025 order?
Your Lordship, I have produced the same, Your Lordship, now.
Give that.
Your Lordship, on 19/11, the order was passed.
I think something is not right with all your dates and all. You file an application, says that honorable court may be pleased to recall the order dated 19/2/2025 for the reasons stated in the accompanying affidavit. I am asking you, where is 19/2/2025 order? 19/2/2025 order is not in this. Please look into it. Yes, let's this matter on 1st of April.
Please, Your Lordship.
Yes.
Cell number 26. Cell number 26.
My lord, public action is challenged in this case, my lord. My lord, previously there was one more writ petition, 26.1, my lord, wherein the court directed us to file an affidavit for making a substantial payment. Lord, before that, nobody participated, my lord, it has become infructuous. My lord, no, this is the second writ petition, my lord, where public auction is being challenged. My lord, my submission to the court is, my lord, we are ready to make a substantial payment to the
What is outstanding?
outstanding is, my lord,
There will not be any interim order substantial, no that kind. Only on an undertaking I'll entertain. Otherwise, I'll not at all entertain the writ.
My lords, one submission. This matter sale has already taken place and sale certificate has already been issued, my lords. So they have to approach DRT.
my lord, till then my right may be reserved, my lord, with the liberty.
How your rights should be protected? Everything is done now.
At least
They
liberty,
have
my
taken
lord.
possession of the property. They have conducted the sale. What remains with you now? Except questioning
The
it.
only ground is, my lord, they have undervalued it.
WP number, so and so, so and so. The earlier the WP number 36844 of 2025 is filed questioning the auction. And as that auction was not concluded, another auction notice was issued. That is questioned in WP number 8988 of 2026, correct?
Please.
2026. It is submitted with the land council appearing for the petitioner that they are ready to pay the amount. Land council appearing for the respondent submits that the auction was concluded. The sale certificate was also issued. Not necessary. Sale certificate was also issued in favor of the highest bidder. And it is submitted that the petitioner, the petitioner cannot have the right of redemption at this juncture. In these circumstances, if the petition is agreed by the auction conducted by the respondents or the sale certificate that is issued in favor of the auction purchaser, he is at liberty to avail the appropriate remedy before the DRT. Accordingly, both the writ petitions or accordingly the WP the writ petitions are dismissed, giving liberty disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Petitioner shall have the benefit of section 14 of the Limitation Act.
Comment, Chetan Jadhav.
No, the father of petitioner number 2 was a chief
Is
engineer.
it nationalized bank, Kotak Mahindra Bank? Is it a
Yes.
private bank or a nationalized bank?
National. No, Kotak Bank, no. Private scheduled bank.
Yes.
No, the father of petitioner number 2 was working as a chief engineer. He retired not in the year 2020. After the lapse of 4 years, not a case came to be registered under the Prevention of Corruption Act, but which is beyond 4 years, not the case will not be registered any criminal action. But what happened is not because the case was registered, but the accounts of the petitioners were seized. But in the meantime, the petitioner had taken loan of 4 crores towards.
No, what is this? What is questioned before this court?
No, question before your lordship is brought. That is order under section 14 passed by ACMM as well as the notice issued under section 13(2) of the
No, for
Surface
that-
Act, Surface
for that
Act.
reason I'm asking against a private bank, the writ petition is not maintainable.
It falls within the meaning of Article 12.
No, that is what are the judgments of the Supreme Court arising out of the surface proceedings.
But so far as surface proceedings are concerned, but my submission to lordship not that it is not a case of deliberate or a default. It is a case where
First of
the
all, we have
tenants
to-
are there not in the
No,
premises.
unless and until we answer the issue of maintainability where I'm not entertaining, unless you convince the court on that, I can't pass an interim order.
But your lordship kindly turn to not this decision.
Yes.
Para 13, madam. 20.
Take those judgments also. Yes, yes.
So, dinner copy, no. But I have marked that portion, madam.
Take that.
But 2014 SEC.
No, there is a latest judgments, 2-3 judgments of the Supreme Court. Give it to them. Pass over. I'll take it up in the afternoon.
Those are financial institutions, sir. This is a bank, this is a private.
Give those 2 citations. Afternoon.
2:30, madam. Please.
Yes.
But today is the date not fixed for taking position. 2:30, madam.
Yes. Every day the same story they will tell. Every day the same thing you will tell, that group B employee promoted, he's not doing. Huh? No, whoever is, why she has come, you should tell the Registrar Judicial. Not necessary, ask Registrar Judicial to come in the afternoon. Yes.
Cell number 28 adjourned, cell number 29, 29 adjourned, cell number 30, cell number 30,
Yes, admit post of final hearing.
cell number 31,
TCR is there, yes, admit final hearing.
Lordship, I have filed a
Admit.
memo wherein I am arrived as a wrong party and I filed the memo to that effect along with the objections. I am only a booking agent of particular bus which was involved in the accident.
That will be decided.
My lord, 31.1, I pay for R1, my lord. This has been wrongly connected, my lord.
31 is unconnected.
Yes, my lord. It's a different.
D-link 31.
Please, my lord.
From 31.1.
And 31.1, office application has not been complied from past 14 years, my lord, by the appellant council. It is still pending as typed copy of the amended appeal not filed. Kindly, it may be dismissed on.
Please, on in respect of wakalat of R7.
No, my lord. 31.1, my lord. This is a different case, please, my lord. I pay for R1 in this case.
31.1 says non-filing of typed copy of the amended appeal.
Yes, my lord.
We'll see.
Both the claims
Yes, yes.
arising out of same accident.
But she says it is unconnected.
It's a different.
Same accident.
A different cases, my lord. Both are.
Against the same APS.
Yeah, disconnect both the thing. Next 32.
Yes.
Final
Much
hearing.
obliged.
Yes, 32.
32,
In 31 also, they have not
Here for
complied the
appellate.
office objection. 31, they have not complied the office objection.
Yes, 32.
cell number 32,
I appear for
Respondent
appellate.
number 9, Your Lordship. It's the owner appeal.
1, 2, 3.
Is final hearing.
cell number 33,
It's also.
Ready?
33,
It's a case of death on 32.
32, liability is involved, that's why, because owner's appeal.
No, anyway, I'm not hearing any of these matters. I will
Oh,
talk
okay,
on
then.
Friday. Yes, 33.
33, Jagdish HT, O Mahesh,
No, don't admit this. Let's just matter after 4 weeks. Yes.
preliminary hearing B group, cell number 34, Ravi Raghavan for petitioner,
Last, I request for a passover led by senior counsel. This is a matter
Yes,
where the
pass
issue
on,
is.
pass on.
cell number 35,
35, my lordship, I am for the petitioner, my lordship.
My lord, I am reporting the death of petitioner number 8 and 10, my lord.
Yes, my lord. There is a 3 petitions are
They may
there.
be just deleted, my lord.
Next week, maybe
8
I
and 10.
amend the petition, my lord.
35, my lord.
Yes.
35, 7 and 8 and 10. The 3 persons are dead. So I want to take amended the petition. I filed the necessary application.
Memo is filed by the counsel of the petitioner reporting death of petitioner number.
My lord, I am
10.
for respondent number 5.
You are reporting the death of petitioner.
Yes, my lord, because they are getting treated in my hospital, institution, my lord, Victoria Hospital.
It is then counsel the respondent has placed
agree.
the memo before the court reporting the death of petitioner number 8 and petitioner number 10. So what?
My lord, I am also filing a document as per the order dated 11/2, my lord, the treatment details of the petitioner.
The petitioner has also filed the details.
Respondent number 5.
Yes.
I am for the petitioner, my lord.
So please take steps if the
Yeah, I'll
if they are no
necessary
yes the petition counsel of the petition will take appropriate steps. Yes, 36.
cell number 36,
I appear for respondent bank, my lord. Yesterday I filed a memo, my lord.
Let me please. My submission is that we have already paid about 93 lakhs 75,000 out of 1 crore 13 lakhs 67,000. We have to pay about 30 lakhs with all that present. I'm only an agreement holder, but I'm willing to pay that amount and clear the understanding if some time is granted. My lord, about 30 days time is
stated that has already instituted suits for specific performance before the competent civil court.
That is
and has
between
obtained
me,
stay in both the suits in the light of the same.
that is between
this
me
matter,
and
my
the persons who have borrowed the money. The persons who have borrowed money have executed sale agreement in my favor, on which basis I have approached this honorable court. I had no knowledge about the fact that there was a loan.
Problem is, how can the court pass an order against the bank and in favor of the agreement holder, you pay the money? Unless and until your rights are crystallized, how can the court interfere with these kind of matters and grant this kind of orders? We can't, because.
My legal right,
Your legal right has to be agitated before a
because
competent
if
court
I pay any, I've already paid 90,000 and odd, my lord, 90 lakhs and odd.
can't entertain this kind of.
93 lakhs amount of the sale consideration is already tendered.
Total due is more than 2 crores, my lord.
1 minute.
One submission.
How you have accepted the amount from an agreement holder, that you please tell the court?
Yes, my lord.
My lord.
My lord.
Wait.
They have given a letter and accepted.
How can you accept?
Kindly see annexure.
That I will clarify with the bank, my lord.
1 minute, let
3/2/24 they have accepted.
me talk to him. Yes.
My lord, I'll clarify with the bank, my lord. I am not aware of that. It was received, according to my knowledge, the borrower has paid the amount, my lord.
Not the borrower. As per the orders of the court, this petitioner, who is an agreement holder, has paid the amount. If you have accepted the amount, then I'll ask the Reserve Bank of India to look into the affairs of your bank. Why you are doing these kind of things? If there is an order of the court, you should have preferred an appeal against that. How can you accept the money from an agreement holder?
That I'll clarify with the bank, my lord. I'll take instructions, my lord.
My lord, only one submission on behalf of respondent number 2, my lord. The amount whatever the petitioner paid has been returned by the respondent number 2, my lord. 20 lakhs they have paid under the agreement, my lord. That has been returned by the respondent number 2, my lord.
That's a whole difficulty.
That is
High court is adjudicating the rights of the parties in a specific,
my lord. Please,
as
my
if like it is a specific performance suit.
Please, my lord, please.
The learned counsel appearing for the senior counsel appearing for the petitioner, who is an agreement holder in respect to the property which is mortgaged, submits that as per the orders passed by the coordinate bench of this court, they paid an amount of rupees 96 lakhs and odd. Learned counsel appearing for the borrower submits that. In fact,
And
the
we are-
amount of 20 lakhs is returned to the petitioner.
account.
That is sale consideration
lord.
he is talking about.
Yes, my
my
lord.
That's what.
That's what,
That
yes,
is
ma'am.
what he is talking about. I
Please, my
understood.
lord, please.
How can he return after executing sale agreement?
They have returned the amount. This court is not able to understand how the bank has accepted the money from the agreement holder. The agreement holder, the respondent bank shall, the concern of the respondent bank shall file an affidavit before this court. Yes. This is matter on 23rd of April.
Much obliged.
Yes, next.
Interim order may kindly be extended. I was there till today. May be extended.
It was not extended in last date of hearing, my
How
lord.
are you concerned with the property?
And I understand for whatever reason I have convinced this honorable court and they have also accepted the fact that they have made payment. I have deposited the money. All I need to deposit the balance and I move against them for
I issued
specific
reply notice
performance.
saying that, my lord, don't pay any amount to the bank. I will pay it to the bank. I have issued a reply notice. In spite of my reply, my lord, they are paying. And my lord, there was a discussion between the builder. My lord, may kindly see the petitioner is a builder.
All these things what the court is hearing is unknown to law.
Yes, my lord. Yes, my lord.
Interim order earlier granted is extended. List this matter on that day on the day either you file an affidavit or not, I will pass orders. And I
Yes,
will
ma'am.
also make strictures against the bank
Please,
for accepting the amount.
please.
Cell number 37 adjourned,
Great.
38.
10th, my lord.
Zulfikar Kumar Shafi.
Appearing for petitioner, my lord. Scenery is not feeling well. Viral fever, my lord. Please kindly have the matter in the next month.
What is this?
Lord, I may permit it to Milord produce a memo. The one-time settlement offer which they have given Milord, which we already Milord considered and rejected.
One-time settlement.
Lord, that's what Milord I produced before this report, the rejection letter. Lord, what had happened, Milord, in this matter?
What is the relief he is seeking
Please,
before
Milord.
this court? First you come to
Lord, seeking
that.
one-time settlement only.
That how can this court
Page
grant?
of, please, Milord. Issue writ of direction in the prayer B, Milord. Nature of mandamus directing respondent to
Letter
receive the
dated,
OTS letter dated 20th 9th
Drawing the
2020.
OTS sanction dated issued in favor of the petitioner. Why have you withdrawn?
Milord, we have given certain time condition which they are not complied. In fact, annexure G, Milord, I may permit to place before this.
Matter on earlier matter list on What is it? No, list on April 10th, earlier matter.
I may place, my lord.
And this matter, at the request of land council, the petitioner listed on 17th of April.
I may permit to place because this, there is a direction for
The
me.
land council, the respondent has placed the memo before the court stating
That one-time settlement offer, my lord, we are
that they have
considering.
rejected the one-time settlement offer. Yes, next.
Date.
Number 39.
Milord, 39, my lord, I'm appealing for the respondent number 192, my lord. The entire loan account was closed on 11/10/2022, my lord, under the OTS scheme, and the petitioner has received the entire original document, my lord. After that, my lord, he has filed a writ petition, my lord, after lapse of 3 years. Kindly see, my lord, annexure M, my lord. The respondent bank has issued the endorsement before this court, my lord. Annexure M, my lord. Page number 75. Second parameter.
Issue a writ quashing the letter dated
Yes, my lord.
directing the respondent to consult the representation. What is the representation?
I've not seen this, my lord. Because the.
Is this matter on 21st? Yes, next. At the
Yes, ma'am.
request of council petitioner. Yes, 40.
40.
It's a matter as regards, my lord, the constitutional violating, my lord. Last time, my lordships had heard it.
Hmm.
But before going into the factual aspects, as regards the position in law under 226 clause 2, how this court, my lord, would get the jurisdiction. May I request the honorable court to come to section 26E of the Surface
As
Act?
far as the position of law is concerned, that the Buds Act, the Surface will override the Buds Act, I admit that. But only problem is, my lord, where we have certain investigation conducted, there are more than crore rupees were cheated to many people. And as far as the, under the Buds Act, the investigation conduct thereafter, we have filed the
Before we
investigation.
go there, please come to his prayer. Come to the prayer. What is that is for this court?
Clear that the
Declaring
Buds Act
Buds
so and so,
is
so and so.
super to the provisions of so and so. To hand over the keys of the mortgage premises bearing site number situated.
That may not
This
arise.
we will not, this is
All right,
cannot
let
do
the
it.
first prayer can be considered.
As far as first is
Yes, my
concerned,
lord.
in the light of the law,
Please.
we'll
Very
pass
well.
an order.
I'm happy.
As far as A is concerned,
Yes.
you have to go before the special court.
Yes.
And I state what you.
Yes, please, my lord. Please.
There is a judgment.
My lord, last time I had produced, my lord, Justice Padiwala's judgment, my lord, where his lordship says,
But that is not exactly under the Buds Act. He says the overriding effect.
parameter, it's in parameter.
It's not exact because the Buds Act as well as the Surface Act, both are central acts. It's not that, no, the Buds Act is not a state act.
Correct.
If it is a Buds Act is a state act, my lord, I would have straight away said yes. Both acts are central acts. Kindly see section 13, 12 and 13 of the Buds Act.
Here is argument. What is he saying? Yes, how is this applicable to the?
My lord, this is kindly come to, my lord, para 49 of the
Let's see what is the issue.
judgment,
that
yeah,
called for
the lordship, Rajendran's judgment, my lord, para 49.
Issue is discussed in 49.
Yes, my lord. No, my lord, the overriding effect of the Surface Act.
No. First we'll see what
Yes.
is the issue before the court.
My lord, before that, may I trouble the honorable court to take to section 26E, my lord. 26E for that, before that, my lord. Section 26E of the Surface Act. 26E. Priority of the secured creditors. Notwithstanding anything contained in any other law for the time being in force. After the registration of the security interest, the debts due to any secured creditor shall be paid in priority. My lord, word used shall be paid in priority over all other debts and revenues, taxes, cess, and other rates payable to the central government or the state government or the local authority. Explanation. For the purpose of this section, it is hereby clarified that on or after, kindly mark this, my lord, explanation portion. For the purpose of this section, it is hereby clarified that on or after the commencement of the IBC code, in case where the insolvency bankrupt proceedings are pending in respect of the secured assets of the borrower, priority of the secured creditors in the payment of the debt shall be subject to the provisions of that code. So, my lord, by virtue of 26E, what section 26E of the Securitization Act did, it sought to remedy the mischief that was not, my lord, available under section 35. The dichotomy between section 26E and section.
No, in respect to what is that other act, KADB or what is that?
That is, my lord, under the state enactment,
Huh?
KPID. That is under the state,
They
my lord.
said that would prevail.
But yes,
What is that? That's felt for consideration. That's what I'm asking in this judgment of Justice Pardiwala.
my lord, in judgment of justice,
Facts were considered.
Directly, my lord, Buds Act did not fall in for.
Not Buds Act.
yes.
What is the consideration? That I want to
Consideration was,
know.
my lord, that whether if in the first judgment, if I am to request the honorable court, I'll just take your lordships to the judgment, my lord.
I'm looking at the same way,
Yes.
Rajendran and others.
Yes, my lord.
Yes.
In that judgment, my lord, straight away, the question that had fallen for consideration was the consideration of Rule 8(6) of the surface area as regards the sale.
My
But
lord.
while considering that, my lord,
May I
the
place one judgment where exactly under the Buds Act? Buds Act, where it says that the surface acts will override the Buds Act. Please,
Please, sir.
is there. It's a Madras High Court judgment, my lord. Section 13 and 12 and 13 also discussed where that is a special enactment.
You have a copy of this?
let him, my lord, he can make so. I have no problem.
What is the full form?
My lord,
What is the full form of the act?
Buds Act, my lord, the act says.
Banning of unregulated deposit act.
Yes,
my lord.
Banning of unrelated deposit.
Unregulated act.
Unregulated Deposit Schemes Act. Banning of
Unregulated deposit schemes act of 2019.
Very well.
Kindly see section 12, my lord, of the act,
Of the Buds Act.
Buds Act.
These are-
12, 13 and 14.
Yes, not, it is not there.
Yes, I'll see.
It's
Section?
12.
Yes. So like, act itself is clear. 12 itself is clear.
But again, act itself is clear.
26, this has to be read along with 26E of the Surface Act, my lord. Because that amendment to 26E came in there in 2016. It relates back to the date of enactment. Substitution. Doctrine of pro tanto repeal.
Deposit taker shall be paid in priority over all other debts, but all revenue taxes and other rates payable to the appropriate government or the local authority. Yes.
12. Act itself says that.
Act says that it has priority over other. No, let's please come to this judgment, how it is discussed.
There is a Madras High Court, my lord. There exactly they have stated that the surface will have an overriding effect over the Buds Act.
How that provision section 12 is distinguished?
That's this there. I don't have a copy.
You have the, you don't have.
I don't have that. Only copy I had, I just supplied.
Apart from Lordship Justice Pardiwala's judgment, my lord, there is one more judgment which I placed it in Kotak Mahindra's judgment. Sir.
See para 19, my lord.
Yes.
18 onwards. Therefore, we know of the provisions, particularly section 26D and 26C of the Surface Act, in order to enforce such rights provided under chapter 3rd, security interest created must have been registered with the central agency. Therefore, only after such registration, the security creditor shall be paid in priority over all the debts and all revenues, taxes and cesses and other rates payable by the central government as per section 26E of the Act. Further, it is relevant to note that the amendment inserted these sections 26D and 26E into Surface Act 2002 will apply prospectively from the date of notification, whereas section 12 and 13 of the Buds Act would make it clear that save as otherwise provided under Surface Act, the amount due to the depositors from the deposit taker shall be paid in priority over other debts. A combined reading of section 12 and 13 of the Buds Act clearly indicates that the right under the Buds Act will be subject to the right already created under the Surface Act, provided the security interest created under the Surface Act is registered with the central registry as per section 26D of the only the rider is they have to register under section 26D to the central registry matter. In fact, before passing the banning of unregulated deposit scheme bill 2018, the Standing Committee of Finance in its 17th report has recommended to the government that the sentence save as otherwise provided in the Surface Act 2002 or insolvency and bank code so and so Any amount due to the depositor from a deposit taker shall be paid in priority for all the debts, all revenues, taxes, cess, and other rates payable, and other provisions under Chapter 4 of the bill may be deleted. Despite such a recommendation made by the committee, the Parliament did not accept it, and the provisions for making a Surface Act and IBC claim as a priority over other debts. It has been retained under the Section 12 and 13 of the Budget Act. In this regard, the full bench judgment of so-and-so held that dues of a secured creditor subject course to registration, subject to processing under IB code, would rank superior to the dues of relevant department
The
of the state.
provisions of the Securitization Act,
Pardon?
Surface Act, what are the provisions?
My lord, section 35. 35 and 26E.
This judgment, they were referring to the 26?
26E, my lord.
Yes.
What is not provided in 35 is supplied in 26E.
Let's see 35.
Yes. 35, the provisions of this act shall have the effect notwithstanding. It's a,
Nothing.
my lord, it starts with a non-obstant clause. Notwithstanding anything inconsistent therewith contained in any other law for the time being in force or instrument having effect by virtue of any such law. This was since from the inception of 2002, section 35. Whereas section 26E comes to be inserted subsequently, my lord. Kindly come to section 26E now. It is substituted by the amendment of 2016. Priority to the creditors, secured creditors. Notwithstanding anything contained in any other law for the time being in force, after the registration of the security interest, the debts due to any secured creditor shall be paid in priority over all other debts, revenues, taxes, cess, other rates payable to the central government or the state government or the local authority. So therefore, what remedy was not available under section 35 is supplied by the 2016 amendment to section 26E. And if both section 35 and 26E are juxtaposed, both of them are non-obstant clause. Both section 35, there is a non-obstant clause. Section 26E, there is a non-obstant clause which says it has an overriding effect. And as rightly pointed by the learned advocate, government advocate, my lord, the Madras High Court has followed the judgment, followed the overriding effect only on the ground that, my lord, in an identical circumstance, in the case of Rainbow Papers, again, Lordship Justice Indira Banerjee had an occasion to consider section 35. My lord, in Rainbow Papers case, it was the jurisdiction of two taxing authorities, state and center. State GST officer wanted to impose their
No, what do you say about section 12 of the Births Act?
my lord, if section 12, if your lordships will see, it does not have the non-obstant clause.
You see, let's read the Births Act.
Yes,
Section
ma'am.
12.
It does not say notwithstanding content. It does not start with the non-obstant clause.
Save as otherwise provided.
Yes. Provided. Yes.
Securitization and
Yes,
so
ma'am.
and so.
If Parliament were to be aware, Parliament would have started with notwithstanding anything contained in any other law for the time being in force. But whereas in Securitization Act, both under section 35, then under section.
If you look at this Births Act,
Yes, ma'am.
what is the reason for specifically mentioning about the Surface Act?
They have kept it, my lord, out of this for the reason they wanted it to override. Because in various judgments, section 35 is held to be having an overriding effect.
That's true, but no other provision in any other act
Yes,
contains
ma'am.
a specific reference to the Surface Act except the Births Act.
My lord, in section 12 also, if your lordships will see, save as otherwise provided. If we go to the, my lord, the literary construction of the statutory interpretation, save as otherwise provided means subject to the provisions and rigors of section 35 and section 26E of the Securitization Act.
Even then, my lord, see 13 also, precedence of attachment. Section 13 of the Births Act. Straight away to clause 2. Where an order of provisional attachment has been passed by the competent authority, such attachment shall continue until an order is passed under subsection 3 or subsection 5 of section 15 of the designated code. All the attached money or property of the deposit taker and the persons mentioned therein shall vest in the competent authority and shall remain so vested till further order of the designated code.
As regards this, my lord, this submission made by learned friend, attachment order passed can never be a charge under section 100 of the Transfer of Property Act. The SBI versus Travancore, my lord, Supreme Court is very clear. If an attachment order is passed by any designated court, attachment by itself will not create a charge under section 100.
Whatever it is, but still, that will be decided before the very same court, whatever the,
Yes,
whatever
ma'am.
your submissions, whether it will.
As regards, my lord, the second prayer, my lord, I'll give up the second prayer. Second prayer, I'll not press it. But so far the declaration at the hands of you, since coordinate bench of Madras High Court has already taken a view, and that order, my lord, remains in force. My lord, absolutely the provisions of SARFAESI Act must be given, because in Rainbow Papers judgment, what Lordship Justice Indira Banerjee would say, that SARFAESI will have an overriding effect. Way back in their 21.
We'll examine this.
And moreover, my lord, the constitutional validity is involved. I may be permitted to file my separate objections. Otherwise,
The AGS seeks time to file a motion. This is matter on 23rd of April.
Case number 41.
judgment.
KV Lokesh,
30.
41.
Yes.
For respondent, my lord. Petitioner challenge shared certificate, my lord.
I've already passed an order.
Sorry. In this case, we engage the senior counsel, Mr. Ravi Shankar. We have been held in other court also. Can you take it after one?
I've already taken a view on this and I have passed an order that there is no, the court cannot condone the delay.
So now, regarding to that matter has gone to the DRT has condoned the dismissed the delay. On
That's
base,
what I'm saying. Now, this issue is already, as far as this court is concerned, I have already passed an order saying that the Section 17 of the Limitation Act will not.
I'll consult with him just now. Next week I'll be.
This is matter.
Next week I'll be discussing. We'll discuss with him and come back and in team order of the action.
The order earlier granted is extended. Yes, next
42. Narayan Bhatt. OR for petitioner.
Request for a passover, my lord.
Passover.
Great.
Case number 43. Case number 43.
The petitioner.
Leader SC.
Petitioner in this matter, my lords. My lords, on the first date of hearing, my lords had passed an order for me to file an affidavit stating that within 3 months I'll be making payments, my lords. So I'm ready to make payments, my lords. Subject to that, I need some breathing period for me to pay the money. I've defaulted in the loan. The loan amount is somewhere around at 11 lakhs. By default, I'm a farmer. I'm a farmer, agriculturist by profession, by lords.
You have to file an affidavit. You have to file by this time. And again, for that, the matter won't adjourn one after the other adjournment.
I'll file it by this week, my lords. Maybe I may be permitted time.
This is matter on.
Lord, may I make a submission, my lord? They have approached for the OTS, my lord, and they have paid the part payment, and the last next payment is due on 10/4, my lord. It may be had before any date, my lord. 10/4 next week, next month.
You want it before or after?
Before, my lord.
This is the matter on 8th of April.
Please.
Grateful, my lords.
TP Muttana. Petitioner. P. Anand.
My lord, that prayer, my lord.
Appearing for respond number 3. Judgment.
44, my lord, that prayer. Page number 12.
Yes.
Issue a writ of mandamus to respond number 4, sub-registered office effect to delete the encumbrances entry related to the agreement of sale in respect of the scheduled property registered as a document number so and so. This I am not pursuing the matter. This second, alternatively, make a counter entry. And third, to issue any other directions or order of writ petition and the circumstance of the case. Now, in this regard, my lord, the bank has sold the property by following the procedure.
Seeking short adjournment. Seeking short adjournment, my lord.
You appear for whom?
Respond number 3, my lord.
She is who? You are the party, the private respondent.
No.
Have you given the papers to them?
Not it is.
Papers given, that judgment I'll copy, will give, my lord. I'll
At the
submit.
request of land counsel.
Judgment copy I'll submit before the court, my lord, now.
Matter on 6th of April.
Number 45.
Lordship, I appear for the respondent. I pray for some time.
Submission, my lord. 31st is the last date for. They are taking.
How many times you seek for time, Mr. Counsel?
One submission, my
Today
lord.
there is some inconvenience, Lordship. one account.
Out of due amount, my lord, 68,000 has been paid, my lord. Only other balance they asked to disclose, my lord. I am ready to pay that amount, my lord. Till then, my lord, I asked.
I'll make
interim
my
order by my
submissions
lord
on that.
for-
I'll make my submissions on that, Lordship. Kindly, one short
They will
account.
take the possession, my lord. I will challenge the possession notice, my lord. I am ready to pay the
That will be
amount.
taken up
They are
on
not
Friday, Your
disclosing
Lordship.
what is the other expenses.
Friday,
He is
I'll
a
make my
vegetable
submission.
vendor, my lord. He was hospitalized, my lord. Even though I paid 68,000 rupees, my lord, on 19/3 itself. Only balance amount they are not disclosing, my lord.
Bank can't, you can't appearing on behalf of the bank. How many times this court has adjourned the matter?
No, on the
Last
previous
occasion, you have to
occasion,
be
that was
directed
not.
to
13-3, 18-3, every time you are asking time, then I'll grant interim order and we'll file your
That's it.
objections.
That's
This
it,
court has
Lordship.
given sufficient
A
time to
day, a
respond to
day's
bank.
accommodation. I'm not speaking about a day's accommodation.
31st
Not
is the
I'm
last
taking
date for
tomorrow
taking
also.
possession, my lord.
Tomorrow.
This is matter on Friday,
Please.
no further time. If
No,
the
no.
respondent advocate fails to get instructions, on that, the interim order will be granted by this court on that, on the basis of that.
Please.
Yes.
Bill number 46.
Respondent bank, my lord.
For the petitioner, it is with regarding
Sale
private
notice
bank,
already
my lord.
challenged and it has become infructuous.
My lord,
Pardon?
It is
They have
with
challenged
regarding.
sale notice, my lord. Sale notice has already become infructuous.
No, the
And
sale
they
here
already
should
challenged
not
before the
take place.
DRT.
No, my lord, earlier,
Already they have challenged the said sale notice and that has become.
now this is not for.
Yeah, and here in instructions and you also.
It was dismissed for as infructuous, my lord. Now again, the same sale notice is being challenged here.
Same challenge, we have not challenged. My lord, we are asking for the regularization of the loan. We
Can
are-
be granted? Can the High Court grant, direct the respondents to regularize your account?
My lord, we are ready to pay the loan amount. Only thing is the some,
Between you and the bank, there can't be a direction by the court.
we
That's
have
why
given
you're not-
representation to them. They did not
And I told you
accept
about
it,
this
they did not
Karnataka
deny
bank,
it also.
Karnataka bank,
Yes, my lord.
the present petition is filed against Karnataka bank in the light of the law laid down by this court in Gautam versus so-and-so. The petition is not maintainable, accordingly dismissed, leaving it open to the petition to avail the appropriate remedy. Yes, 47.
47. 47 K. Prasanna Shetty.
The petitioner, Lord, yesterday's matter.
Yes.
Lord, challenge to section 14 order, my lord.
will seek instruction, my lord.
Huh?
I will seek instruction, my lord.
For that only the matter is coming today.
My lord,
Why do you
yesterday,
say that you want to, you will take
yesterday-
instructions and you don't get instructions?
yesterday copies are, my lord.
My lord.
Even before the matter is called, your senior was saying that he has instructions to appear. If he has instructions to appear, he should have instructions also.
Kindly await on tomorrow, my lord.
For joint family property, my lord, even he has no right in the property, my lord. That property has been pledged.
I'll grant
House
stay.
property, my lord.
Come after, come with your instructions
Kindly await on
whenever you
tomorrow.
want.
Kindly await on tomorrow, my
No, every matter senior is not there. If senior is not, that's not the problem
lord.
of the
Yesterday
court.
copies are, my lord.
Senior has to be here.
Till then, my lord.
This is matter tomorrow. Tomorrow I'll pass orders.
Please, because then, my lord. Court commissioner is appointed, my lord.
Tomorrow.
Please, great.
This is matter tomorrow.
Please.
By the time, if the instructions, if the respondent fails to get the instruction, that would be the ground for this court to grant the interim order.
Please, my lord. Great.
Yes, 48.
48. Maya Holla for petitioner.
Sale has not taken place.
Filing this memo for withdrawal and seeking this liberty to approach DRT. And the time spent here, my lords, may be
Yes, yes.
under
Sale
section
has
14
not
of the
taken place. That
limitation.
may be recorded, my lord. Sale has not taken place, my lord. Sale notice is
Memo
being
is
challenged.
filed, seeking to withdraw the writ petition with the liberty to avail the appropriate remedy before the DRT. Land counsel appearing for the respondent submits that the sale had not taken place. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Shall have the benefit of section 14 of the Limitation Act.
Grateful, grateful.
49. 49. 50.
Yes, this also list on some Friday.
10.
Yes.
Till number 52.
Yes,
parted
50,
matters.
50 also, 50, 51.
52.
All till 51. Yes, next,
Till number
52.
Till number 52.
I appear for the petitioner.
Month okay.
Sir. But the family court, Chikbalapur has passed in a.
We'll delete this matter from parted before, this is before the court having roster. Yes, sir.
53.
Some alerts. some urgency.
Little come at a list this matter before the court having roster on Friday.
Friday, ma'am. Oblige.
Cell number 53.
For the petitions.
For the respondent bank.
Yes.
Lord, petitioner herein, my lord, is an auction purchaser of a property, my lord, my lord, by the then bank. Lord, he had paid, my lord, the entire money in terms of the auction sale. Lord, the Arswell Corporation Bank, my lord, had put the property into auction. Lord, in spite of, my lord,
Find your objections.
We are ready to hand over the possession, my lord. In fact, we have sent them to courier also. They have received
What's
it.
the money back?
Yes, my lord, I want my,
Why you want the money back?
Lord, for 8 years, my lord, they did not hand over possession. My lord, there are various litigations, my lord, between the original,
The auction?
pardon, my lord, 2017, my lord, is the auction. And till I writing, my lord, and approaching,
Pay the money back and along with interest.
along with interest, my lord.
Pay the money back. Whenever you give the position, then he will take the position.
Lords, in fact, we have sent them the courier also. They have received.
Find your objection.
No, ma'am. We'll file
your
objections.
objections. The respondent shall file their objections within 2 weeks. I'll pass orders once the objections are on record.
Could it be little bit earlier, my lord, because it's already 8 years, my lord, 8 years old, my lord.
List the matter on 22nd.
Oblige.
Yes.
Number 54.
My lords, I appeal for the petitioner. May I request for a passover, my lords?
Yes, password. Next 55.
Grateful, my lords.
55 for the matters 55. Singhania.
My lord, this honorable court, my lord, directed to my lord, the survey copy upon me, they are not served. It's 3 times, my lord, matter coming from.
They were also not present. What to do?
Please, last 2, my lord, 3 occasions, my lord, they are not appearing.
The matter came up on 23/2/2026. There is no representation on behalf of the petitioner. Hence, the matter was directed to be listed today on the caption dismissal. Today also there is no representation. Accordingly, the petition dismissed as dismissed as non-prosecution.
Cell number 56.
Please, for the petitioner. So, in fact, yesterday, a learned government advocate volunteered to say
Yes,
something
regarding
so far as
the various judgments that I made submission from Supreme Court to.
We'll have it in the
Please.
afternoon because it will have to dictate the order.
Yes, please.
Yes.
Cell number 57. Putira Gowda.
Yesterday also there was no representation. Day before yesterday also there was no representation. Lord. In this matter, my lord, charge sheet is filed in special case number 1998 of 22.
This matter is of the year 2023. On 10/8/2023, stay of notices was granted by a coordinate bench of this court. On 23/3/2026, as there was no representation. The matter was directed to be listed on 24/3. Even on 24/3/2026 also there is no representation. And the matter was directed to be listed today. Today also there is no representation. Accordingly, dismissed for non-prosecution. Before that, Land Counsel for the respondent, HCGP submits that already pursuant to the said
Charge sheet is
notices,
filed, my lord.
the investigation is conducted and the charge sheet is also filed.
And it is in special case number 1998 of 22.
Yes, next.
38.
In this matter, my lords, my lord, may I pray for the lordship to have it on day after tomorrow, my lords. It will take a little time because Partnership Act, SURFACE, we already have
Not
everything.
necessary. Ask her to come in the afternoon. No, it won't take time. After Passover.
Passover. Cell number 59. 59.
My lords,
Vidyaravi.
appearing for petitioner, my lords.
Yes.
My lords, appearing for petitioner, my lords.
Yes.
My lord, the office objection has been cleared. On 24/2, there was notice issued for respondent 2 and 4. On same day, have been paid process fee also, my lord.
You have to argue on the merits of the matter, not on office objections. Please come down and argue the matter.
Okay, ma'am.
Please pass over. 60.
Cell number 60. Kavita.
My lord, in this case, I am for the petitioner, my lord. I have paid the court fee for process taken for R2, my lord.
What is the writ petition about?
My lord, in this case, my lord, I have challenged the order passed by the DRT and mandamus direction, my lord.
Let's see, what is that you're seeking? What is the order passed for the DRT?
DRT has been dismissed my essay on delay, my lord.
Issue a writ of certificate setting aside the order dated passed in and criminal miscellaneous, not to take any action. You have questioned the order passed by the DRT.
Not DRT, my lord. It's criminal miscellaneous to take section 14 order against the property, my lord.
So how can you question that section 14 order before this court on what ground?
I have to approach DRT, my lord. Liberty may be given and section 14 of limitation may be protected, my
You
lord.
are waiting for this court to say that from 2024. The writ petition is
No,
filed
I
in
have
the following.
completed the interim order passed by this honorable court, my lord.
Petitioner has an effective alternative remedy before the DRT, and the writ petition is not maintainable. Accordingly, this court is passed the following order. Writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Petitioner shall have the benefit of section 14 of the Limitation Act. Yes.
61, Nagaraj Shetty.
My lord, I completed the interim order that may be recorded, my lord.
It is submitted that the interim order passed by this court is complied with. Yes, next.
Obliged, my lord.
Kindly pass over, my lord.
Pass over.
62. 62.
For
V.
respondent,
Mohan.
my lord, a request for a passover.
Pass over. Yes, pass over.
List number 2.
Yes.
Cell number 1.
Pass over.
Cell
What about 1?
1.
1 and 2 is the both accused. They are to have been meditated as a classification is wrong.
It should go where? What is the classification?
GM police ought to have been. They said that GM RES.
Anyway, we can, yes,
2 also I'll appear. 1.1 both I'll appear.
you have instruction?
Yes, yes, madam.
Yes, pass over.
Both 2 accused they have filed a separate petition. That's all.
Cell number 2.
Pass over.
2.
What about 2?
Narayan number.
Charge sheet is filed, madam.
Yes, pass over. 3?
Cell number 3.
Yes, 3.
Pinto.
Serial number 3, I appeared for the second respondent bank, Your Honor.
Yes, pass over. Yes.
Number 4. K. Balakrishnan.
In this matter also, madam, C report is filed, madam.
Done.
Notice is also issued to the
Pass over.
Cell number 5. Lakshmi.
This notice has been challenged, madam. Interim order is operating the petition, madam. In view of interim order, madam, for the
Yes, pass over.
Cell number 6.
this matter, charge sheet is filed, madam.
Pass over.
Cell number 7.
7?
Sunil Kumar.
My lord, the crime is settled, my lord, between the parties. There was a theft, my lord. He received,
Pass over.
Cell number 8.
8?
Sanya Mali.
8 pleadings are completed, my lord. Objections are filed. It has to be heard, my lord.
You're ready?
Ready, my lord. Objections are filed.
Cell number 9.
Nine.
Final hearing.
Ready?
Chakkarappa.
10 also, charge sheet is filed, my lord.
Yes, 9, pass
9.
over.
9 pass over.
Yes,
10.
10.
10, my lord. Yesterday's matter, preliminary hearing. That spa matter.
Yes, it's pass over.
Pass over. For dismissal, cell number 11.
I'm for the petitioner.
Lokesh SG.
Petitioner.
Pass over.
Cell number 12.
Yes,
Mohammed G. Tahir.
pass over.
One submission I would like to make.
In serial number 10, matter was not listed yesterday, Your Lordship. Serial number 5 was listed yesterday and it is being
We
posted.
will see when some order, yes.
Serial number 14, Lord.
10, you were.
File, Lord, original
File,
auction
when you're
notice.
listing that.
It has to be returned.
All in that matter, all the original documents to be returned to the petitioner. Yes.
And one submission, complaint order of this honorable court by paying 50 lakh. It has to be.
Huh?
I have complaint order of this honorable court by paying 50 lakh as ordered by this honorable court by an interim order. It has to be commanded.
It is submitted that the petitioner has complied with the interim order passed by this court. Yes.
Obliged.
Go for it.
ಹೌದಾ? ಅಲ್ಲ ನಾನು ಅದ್ರಲ್ಲಿ 10 ಅಲ್ಲಿ ಎಸ್ಟರ್ಡೇಸ್ ಮ್ಯಾಟರ್ ಅಂದಿಲ್ಲ. ಇದು yesterday's matter.
9 ನೀವು ಹೇಳಿದ್ದು.
ಮೇಡಮ್
11 ಹೇಳಿದ್ದು.
ಹೌದು.
ಅದು ಆಮೇಲೆ ಕರೆದ್ರು. ಇದು ನಿಮ್ ಫೈನಲ್ ಇದೆ. ಡಿಸ್ಮಿಸ್ ಅಂತ ಬರಬೇಕು yesterday's matter. ನಿಮ್ದ್ರಲ್ಲಿ ಆಗಿದೆ.
serial number
cease number
36
ಆಗಿದೆ, next letter ಎಲ್ಲ ಆಗಿದೆ.
ಇಲ್ಲ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಅಲ್ವಾ ಸೊ ಅದಕ್ಕೆ
ನೀವು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಅಂತ ರಿಟ್ ಆಗಿರೋದು. ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ.
ಇದು ಡಿಸ್ಪೋಸ್
ಹೌದು ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಇಲ್ಲ ಅದಕ್ಕೆ
ಒಂದು ನಿಮಿಷ.
Lordship, serial number 34. Lord. Kindly have it tomorrow, Lordship.
Why is it passed over? Why are you asking for time now?
Yeah, let me other courts. Lord. Kindly have it here. 34 tomorrow. No adjournment tomorrow. I finish it up tomorrow. I'll argue tomorrow.
Which one yesterday's?
No, my lord, there's a different. This is where the court may kindly see the last time's order. My learned friend, my lord, since September has been put to notice by this court to produce registered mortgage to show that he has a right. He's sought time since then. I don't know. One more day. That's all I can say. Great.
So for the time.
Great.
34. Yes.
Pass over matters, list number 1, cell number 8. Cell number 8.
The letter is addressed by the Principal City Civil Sessions Court, Bangalore. No, by the so and so. Look at it. ACJM has addressed a letter seeking extension of time. This court, by order dated 11/11/2025, had directed the matter to be disposed of as expeditiously as possible, and is within 4 weeks. It is submitted that for various reasons the same could not be disposed of and sought for extension of time, considering the letter dated so and so. The writ petition is disposed of. The extension of time as sought for by the extension, the time is extended for another 1 week from the 4 weeks from the date of receipt of the copy of the order. The learned judge shall ensure that within 4 weeks the matter is disposed of.
Cell number 27. 7, Chetan Jadhav.
Yes.
Lord, I was submitting to Lordships. But initially, Lord, the father of the petitioner was working as a chief engineer. He retired in 2020. But he started, Lord, this business in the aid of his son. In the year 2024, Lord, after the retirement of 4 years, the Lokayukta police registered a case and all my accounts were seized. As a result, although I paid the interest, accrued interest and installment, etc., till October 25, not subsequently because of this freezing of the accounts, we could not make payment. Now, my lord, suddenly a notice came to be issued.
No, I've asked about the maintainability of the writ petition.
No, with regard to maintainability also, Lord, I have two decisions. I have also seen, Lord, the Muthoot Finance. But what is the distinction, Lord, between them is, here is a case where the petitioner is private scheduled bank governed by Reserve Bank of India. They are all financial institution. Muthoot.
No, there is Karnataka Bank also. There is a judgment.
Yes, I have also seen the observation. But now, if your lordship kindly put, but I have put.
Take that.
But I have two decisions on the point.
Yes.
2019 Supreme SEC 510.
Yes.
You will also kindly refer to Lord para 9.
Yes.
Para 9. The question that remains to be answered is whether the writ petition is maintainable against the respondent on the ground that it discharges public duty. This court in Andi Muktu so and so and others, the term authority used in Article 226 of the Constitution of India must receive a liberal meaning, unlike the term other authorities. In Article 12 is relevant only for the purpose of enforcement of fundamental rights. Under Article 32, Article 226 confers powers on the High Court to issue writs for enforcement of fundamental rights as well as non-fundamental rights. The words any person or authority used under Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of the positive obligation owed by the person or authority to the affected party, no matter by what means the duty is imposed. If a positive obligation exists, mandamus cannot be denied. But this is one decision. Now the other decision is para 10, Lord, Muthoot, that your lordship not referred to. But kindly turn to Lord para 10.
Yes.
Para 8 is also relevant. A body, public or private, should not be categorized as amenable or not amenable to writ jurisdiction. The most important and vital consideration should be the function test as regards the maintainability of writ application. If a public duty or public function is involved, any body, public or private concerned connection with that duty or function and limited to that would be subject to judicial scrutiny under the extraordinary jurisdiction of Article 226 of the Constitution of India. Now, we are coming to para 10 as well. Even while rejecting the writ petition on the ground of its maintainability, the High Court has protected the interest of the parties by observing para 6(1) as under. Following order shall govern. It would be open for the respondent petitioner to have recourse to civil remedy before the appropriate court in relation to the claim and grievance which she agitated by filing the writ petition. So my submission is, although writ petition was dismissed, but ultimately protection is protected.
But
Not
that would go contrary to the judgments of the apex court, several judgments. When the writ petition is not maintainable before the court, question of granting a protection of interim order would not arise.
But the latest judgment on the point that I could not immediately point out. But that is ultimately view is that the interest of the
No,
parties.
I'm talking about the latest judgment of the Supreme Court, which says when the writ petition is not maintainable, where is the question of granting interim order by the High Court? This kind of a practice have to be deprecated by the court.
But in this very Muthoot Finance only, I refer to para 10.
Because the Supreme Court has now ultimately the ratio that is laid down in that judgment is what we have to look at is that against a private financial bank.
I understand, I understand. But your lordship was pleased to refer to this Muthoot Finance. But ultimately,
not only that, what about that the other one? That Vishwabharati.
No, this is the latest. I checked. This is the latest. In para 10, it is not.
No, we don't have to. That's not the ratio laid down by the Supreme Court. What is ratio?
But whether ratio or arbiter. But what I am trying to submit is whether ratio or arbiter. Ultimately, interest of the parties must be protected. But on facts. Not after retirement of my father, 4 years after. In fact, that is not tenable. But prosecution was launched, and that this court has already granted stay. But though not the matter is stayed.
No, please understand the senior counsel. The difficulty is I cannot take inconsistent views. This is my view, so I can't take.
But on facts, on facts.
Facts also.
Here is a case. I understand. Here is a case where, but though it is not permissible, the Lokayukta police registered the case and this honorable court has granted stay. As a result, my entire accounts are freezed. As a result, I am not. It is arm twisting method. I was very regular, till October 25.
And this before the DRT.
And one more last point, if your lordship kindly peruse straight away page annexure E, page 51.
Yes.
It is the notice issuing to the petitioner for invocation of arbitration. That your lordship will find page 51 annexure E. But kindly see the next page, page 52. But here the demand is for 29 lakhs as on 10/2/2026. Your lordship. But suddenly within a week or so, it came to That is page 67. It came to 4 crores. That your lordships will find not page 67. Please refer to 60 days notice dated so and so, issued under section 13(2) of so and so. And the amount due to the bank is being 4 crores 2 lakhs 29,000, etc. But within 6-7 days, brother, how can it from just 29 lakhs to 4 crores? But the action of this respondent bank is totally qualified arbitrary exercise. When they issued notice for initiating arbitration proceedings, but within a week they also initiated this Surface Act, and the learned magistrate without referring to any dates, amounts, etc. I think without application of mind in a cut and paste order, this order is passed. So I think here is a case in the interest of justice, invoking the powers of this sound court is necessary to protect the interest.
Please come. The present petition is filed. Seeking the following prayer. The respondent before this court is Kotak Mahindra Bank Limited. The facts of the case are that petitioner has borrowed the amount. First petitioner is a borrower, second petitioner is its proprietor, and the third petitioner is a guarantor, having offered their property as security for the overdraft facility and business loan lent by the respondent to the first petitioner. It is stated that all the petitions are agreed with a letter dated 17/3/2026 in which they are directed to hand over vacant portion of the property offered as security. It is a case that after 4 years from the date of second petition retaining his superannuation, a false and frivolous complaint is made to the inspector or the Lokayukta, alleging that the second petitioner has amassed wealth beyond his known sources of income. Based on the said complaint, crime number 5 of 2024 is registered against the second petitioner under section 13(1)(b) read with section 13(2) of the Prevention of Corruption Act 1988. And all bank accounts of the second petitioner, including the overdraft facility and business loan account, were frozen. Agreed with the said action, the second petitioner has approached the High Court by filing WP number 23846 or 2026, and all further proceedings are stayed. It is the case that in spite of accounts being frozen, the first petitioner continued to serve both the overdraft facility as well as the business loan. However, due to circumstances beyond the control of the petitioner, some defaults occurred, and the respondent bank classified the loan lent to the first petitioner as a non-performing asset. As such, the petition is before this court. When counsel appearing for the senior counsel appearing for the petition submits that in one of the notices it is mentioned as the outstanding amount is 25 lakhs.
29 lakhs. Yes,
29 lakhs, and within 10 days, another notice that is issued shows that the outstanding amount is 1 crore.
4 crore.
Amount
4
is
crores 2 lakhs.
4 crores and odd. When the matter came up for hearing, this court has specifically raised a query with regard to the maintainability of the writ petition, as the respondent is a private banking institution. The senior counsel has placed before this court the judgment in case of A.K. Patnaik, in case of Harshat Govardhan Sundagar versus International Asset Reconstruction Company Limited, reported in 2014.
Supreme Court cases.
Supreme
263.
SC 263. It relied on at paragraph number 17, has held that An order passed by the Chief Metropolitan Magistrate can be challenged before the High Court. He has also relied on an order passed by the Apex Court in case of Shobha versus Muthoot Finance Limited, arising out of SLPC number 2625 to 2627 of 2025. Relying on this judgment, it is submitted that at paragraph number
10, 8 and 10.
8 and 9, so at paragraph number 10, the court has observed about the safeguards that were given by the High Court while holding that the writ petition is not maintainable. Then senior counsel submits that, though in the said judgment, the court has affirmed the view taken by the High Court that the writ petition against a private finance company is not maintainable. However, the court had observed, rather upheld the findings given by the High Court. It is submitted that in this case, the High Court, in case of Shobha, the High Court, though held that the writ petition is not maintainable, still has given the protection to the petitioner. It is submitted in the facts and circumstances of this case against the arbitrary action of the bank. The same, the interest of the petitioner may be protected till he approaches the appropriate forum for the redressal of his grievance. Having heard the counsels on either side, there is a material on record. The first and foremost issue is with regard to the maintainability of the writ petition against the private bank. Where are those judgments? The coordinate bench of this court in writ petition number 11869 of 2017, coupled writ petition number 27352 of 2006 in cases with Gautam and Karnataka Bank Limited, considering the various provisions of the has held that the writ against Karnataka Bank is not maintainable. The court has also considered the submission that the list of functions now being discharged by the bank would amply make it clear that they are discharging a public duty. As such, that it is maintainable. Considering the judgment of the Apex Court in MP Singh versus Union of India and others, court had rejected the said contention and held that the writ petition is not maintainable. Then in case of Phoenix ARC Private Limited versus Vishwabharati Vidya Mandir and others, reported in 2022, 5 SEC, page 345, the Honorable Apex Court at paragraph number 18 has held that the writ petition is not maintainable against a private institution. Extract paragraph number 18, paragraph number 45, 40. Only 40, only 18. (21) also. Extract. in the light of the law laid down in the above said judgments, a writ petition against a private banking institution is not maintainable. However, and coming to the submission of the learned senior counsel, that though the writ petition is not maintainable, in Shobha's case, the High Court has protected the interest of the parties. Hence, in this case also, the protection may be granted to the petitioner. This court, in the light of the settled law, that when once a writ petition is not maintainable before the court cannot grant any interim protection to the party. This practice has been deprecated with the Honorable Apex Court in recent judgments. In that view of the matter, this court cannot pass any protection order till the petitioner avails appropriate remedy. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner. The same is not maintainable before the court. Petitioner shall have the benefit of Section 14 of the Limitation Act. Yes.
Interim protection, Lord. Not given?
Not put.
Cell number 42. Cell number 42.
This matter was heard by your lordship last occasion. My lord, there was one entry in the encumbrance certificate and the property had no e-khata. I deposited 25%. Then my lord, I sought for e-khata. Then also.
It is the counsel for the respondent.
Mr. Muttarna Maltan is coming.
We'll call it once he comes. Yes.
Cell number 54. 54.
Counsel is assisting in other court, your lordship. Kindly pass over.
What is this matter about?
My lords, this matter, bank has approached this honorable court seeking a mandamus to remove the cars that have been seized by the competent authority. So competent authority was to revert whether they are ready to remove the cars or not, my lords.
They are ready to remove.
That was a submission made last time by the state assistant commissioner.
Yes. We'll call the matter.
Please.
Yes.
Cell number 56. Prakash MH.
Please, in fact, on the last occasion, Lord, respond number 3 and 4 are directed to make a submission regarding the appearance of the respondent number 5 herein. And in the yesterday also they have not present in morning also.
What about the judgment? Then you will dispose it of it. So in this case, according to you, there is no recital or a recital is there?
So this is a partition deed. The registered partition deed cannot come within the
partition deed.
Partition deed. And even I have gone through the judgments learned government advocate is placing before your lordships. Most of all the cases are related to the interpretation on the gift deed. Gift deed and applicability of the prospectiveness and retrospectiveness of the 2007 Act.
Or else I'll say heard the learned counsel for the petition in part, no representation for the respondents. This is matter as part heard on 15th of April. Delete from the caption dismissal.
Dismissal tag is there.
That's what I said. Delete from the caption dismissal. Post as part heard.
Please. But these judgments may not help to this case, but entirety of the section 23 it will help. I have pointed out each and everything. The first one is in favor of this.
Keep it separately.
Yes.
So that in other matters also it
Yes,
will be
yes.
used.
Entire thing is there.
Yes.
58.
Lord, in this case, Lord.
50? Yes.
Sanjay Prabhu.
Please, Lord.
Yes.
In this case, Lord, I would like to take your lordship to ink page 34, Lord. Ink page 34. This is a matter where, Lord, OA order, Lord, came to be passed, Lord, against me also, wherein it is with regard to the partnership firm, Lord, to which the loan was.
But I've asked you a question on the last occasion. You were a partner and you were a signatory to the mortgage. And now, just because you have retired from the bank, that will not come in the way of the bank. But that you sought time.
Originally, my lord, the property stands in the name of father, my lord. And 5/7/28, 2018, my lord, father died. And thereafter, on the capacity of the legal heir, if I'm bought, my lord, if I on the capacity of the partner, my lord, if I'm bought, I had retired on 22nd February 2018, my lord, prior to death of the father.
No, whatever it is, but you are a signatory to the mortgage. That's what is matters.
Property, my lord, it is a property was belonging to father, my lord.
Whoever it is, but all of you are signatories.
My lord, I do not stand as a partner subsequent to the death of the father, my lord. And before that also, I had retired from the partnership deed, my lord.
If I remember correctly, on the last occasion, you have given the dates. When was the mortgage? When have you retired?
The mortgage is,
So
my lord.
when I have specifically asked you, then you sought for time.
Please, my lord.
So when was the mortgage? Yes, Mr.
My lord, in respect of mortgage, my lord, they are not produced a document. I'll just take an instruction. My lord, there are two things. In fact, my lord, it is a petition which my lord, I got, my lord, today morning this out. What I found it, my lord, it is not their case that, my lord, they are not signed the document. They execute a mortgage. Subsequent to mortgage, my lord, he retired from the partnership.
That's what.
Therefore, my lord, I am not liable to pay the bank dues. That is their case. That is one. Second thing, my lord, the payer which sought before this honorable court is, my lord, original application allowed by the DRT in the year of 2024. That final order has been passed. No, my lord, in a writ jurisdiction, my lord, he can't, my lord, setting aside the order passed by the DRT under section 19. It, my lord, after adducing the evidence, matter, my lord, from, my lord,
When was that order passed?
2024, my lord.
Hmm.
In fact, original application which we filed, my lord, 2019 we have filed the original application, and 2029/6/2024, my lord, the honorable directory tribunal allowed the original application in my favor.
Date is 29.
29/6/2024.
Hmm.
My lord, that, my lord, order is held before this honorable court. My respectful submission, my lord, this is section 20. If any, my lord, issue, my lord, they wanted to take up before the, my lord, appropriate, they can go to DRT and they can. And apart from that, they are not disputing that, my lord, executing the documents in my favor. Only merely, my lord.
Please come to the order passed in the order impugned. Let's see what's wrong with the order.
Please, my lord.
My lord, account was NPA on 21/8.
My lord, kindly come to, my lord, page number 41.
41.
Please, my lord. I mean, brief facts.
Come to the reasoning part.
My lord, from 40, my lord, page number 48, my lord.
Independent is a partnership firm. That's what, this is where I read it.
Paragraph number 7. The further it is first
The
defendant.
father of defendant number 3, 4, 6 to 8 and husband of defendant number 5 were the partners.
And they executed a document. It's not in dispute also.
Executed the document, but there was no mortgage, my lord. In fact, the mortgage, with regard to the mortgage, they have to clarify, my lord, because I am not at all in the, access to any of the documents.
What are your grounds? What are your grounds in the appeal, in this writ petition?
My lord, Lordship, kindly to go to ink page 10, my lord. Petitioner.
Petitioner after retirement,
is not liable for any of the liabilities of the respondent. Number 2.
Where did you raise a ground with regard to this mortgage that you will never mortgage the property? Why did you say
They, my lord, I did not get an opportunity to. I was not served.
They're admitted.
Grounds, where did you raise?
There is no such ground, my lord.
Come read the order.
My lord, in fact, this is a OA proceedings, my lord. If there was a security interest created, my lord, they would have proceeded under SURFACE Act, my lord. One thing, my lord. And the OA proceedings, it's a OD account, OD account. And my lord.
No, we read. Let's not have this piecemeal argument.
Please, my lord.
Please read the order and tell the court what is wrong with the order.
Ink page 50, my lord.
The defendants executed necessary loan documents in favor of the applicant bank as security for the due repayment of the loan. 5.1.
My lord, ink page 51, my lord. Further, the second defendant, represented by its partners, had requested the applicant bank for the enhancement of the credit, that is 5 lakhs, my lord. From 5 lakhs, my lord, the enhancement was done for, my lord. They went on, my lord, and enhancing the, my lord, facilities, my lord. And para 2 itself, my lord, of the order, in page 51, under the existing OCC, that is para 2, line 4, my lord, and existing OCC, the letter of renewal dated 8/4/2000 After considering the request of the defendant number 2, the applicant sanctioned 5 lakhs to 6 lakhs and bank for the increased credit facility rupees 1 lakh on 8/4/2000. The loan was repaid the said amount with the interest of 3.75. That
Not contested the matter before the tribunal.
no, my lord.
Why?
My lord, I did not get the notice, my lord.
No, it's not correct, my lord.
Notice was not served, my lord. This is what was served, my lord. I got the order copy, my lord. Order copy was sent to me, my lord. Thereafter I got to know.
Notice is not served on them.
No, it's not correct. Expert had taken
No,
place.
if you file an affidavit that you have not
My
received,
lord,
the
I will ask.
the record is there. Then counsel for the respondent, petitioner submits that. No notice is served to the petitioner. The registry is directed to call for the entire record
Yes, my lord.
pertaining to the OA. If the OA record discloses that the notice is served on the petitioner, this court would impose exemplary costs on the petitioner. Yes, this is matter on 15th of April.
Great.
Please.
Vaidya Ravi, Lakshmi Narayan.
Same for petitioner, my lord. Yes, senior is not feeling well, my short date. My lord, one more matter.
Become
my
a
lord.
routine practice for every advocate to make this submission. Every day, this is what is happening. Why did you not appear on 18/3? And when the matter is in dismissal, you ask for time.
Next date, a senior will appear, my lord.
What is the guarantee that the senior will be there next week? Yes, what are your instructions?
Only for Union of India, respond number 1.
What about the bank?
Bank is await notice for respond number 2 to 4.
24 matter, notice is still awaited.
It's the SBI, madam.
State Bank of India, who appears?
2 to 4 is the State Bank of India.
No, one more matter, ma'am. Same
Who
matter.
is there? No, they are in the court.
State Bank of India.
Mr. Vignesh Shetty is directed to take notice on behalf of respondent number 3 and 4.
2 to 4.
2 to 4. And the land counsel for the petition serve the copy of the writ petition on the council. What is the other number?
One more number, ma'am.
List
24385. In that matter, the
along with
interim
so-
order has been given.
So, list this matter on 21st of April.
Number 61. Nagaraj Shetty for petitioner. Shivshankara A.
No representation in the morning and it is in dismissal or there was no representation on behalf of the petitioner in the forenoon and even in the afternoon also. There is no representation. Accordingly, the writ petition is dismissed for non-prosecution. Yes, next.
Cell number 62. P. Mohan.
For respondent.
Yes.
Lord, I've seen the judgments, my Lord. Lord, I request this court to bear with me for a few minutes, my Lord, because I want to show to your lordships, my Lord, try and convince your lordship that my writ petition would be maintainable given the circumstances of the case, my Lord. Now, please, my Lord, let me just first, my Lord, cite 1989 2 SCC, my Lord.
No, what do you say about the direct judgment of this court?
No, direct judgment, my Lord, all those cases are where, my Lord, they were borrowers, my Lord. All the cases, my Lord, which I've seen, my Lord, where the court has held.
There, the ratio is not about the facts. It's about
No, it
whether
is
a
about the
writ
fact.
petition
No,
is
no.
maintainable
Lord,
against Karnataka Bank.
your lordship may kindly see Shobha itself.
Yes.
Kindly see Shobha.
It's not about whether it is a borrower or.
No, what my submission.
Institution.
Lord, my.
No, have you seen this, that Vishwabharati judgment?
Yes, my Lord, I've seen, my
Vishwabharati
Lord.
judgment is on a question of whether maintainability against a private institution.
Correct, my Lord. My Lord, not only that, my Lord, there are other judgments also, my Lord. Several judgments, my Lord. I've gone through all of them, my Lord. But they were all, my Lord, either the employees who wanted to be reinstated or who wanted a specific performance of the contract of employment, my lord. My lord, this court, my lord,
These judgments are about arising under the Surface Act.
Surface Act also, my lord. That's Shobha is arising under Surface Act, my lord.
And even that Vishwavarti is also.
Is also, my
arising
lord.
from Karnataka.
But that, my lord, was again a case of a borrower, my lord. My lord, may I just explain who I am, my lord, who's before your lordship, my lord. My lord, the bank, my lord, issues a public notice to auction a property which is mortgaged, my lord. My lord, in that, my lord, I offer a bid, my lord. My lord, I am treated as the successful bidder. My lord, I even deposit the EMD. My lord, thereafter, my lord, I come to know that the bank has suppressed, my lord, that there is a litigation over the property, my lord. My lord, some partition suit is pending, my lord, where 50% is claimed by one of the plaintiffs, my lord. Now, my lord, I go to the bank, I give them a representation since there is a suppression of fact and you have not revealed to me that there is a litigation. Lord, therefore, please refund my money. Lord, now they have forfeited my amount. Lord. Now, whether that is arbitrary or not, my lord, does not even come under the Securitization Act. Now, my lord, if your lordship sees section 17 of the Surface Act, Lord, I cannot go to Surface, my lord, under 17 because it is not an action. Forfeiture is not an action under 13(4), my lord. Therefore, my lord, I am left without any forum otherwise than to go to a civil suit, my lord. In that context, I want to show, my lord, that, my lord, law, my lord, cannot be interpreted with such rigidity of a mathematical rigidity, my lord. Where, my lord, your lordship is jurisdiction is invoked to do justice, my lord. Probably sometimes, my lord, the law has to be bent to an extent.
Whatever you are seeking, it's a consequences or offshoot of a proceedings under the Surface Act.
But I cannot go under 17, my lord. Kindly see 17, my lord. If before I proceed any further.
Any person who is aggrieved by the action.
No, my lord, that's correct.
Supreme Court
Under
judgment on the point is there.
Huh?
Supreme Court judgment on
Yes,
the
all
point.
the parties. Yes.
That's
which one?
What he is submitting is about the measures.
Yes,
According to the
that's
forfeiture is not a measure.
No, same
Forfeiture
point.
is not a
No,
measure.
same points.
Huh?
Agarwal Tracom Private Limited versus Punjab National Bank. That tells is 17 is maintainable.
Read that paragraph. Read it.
Yeah, I'll read.
Please give me a
copy.
Okay.
Which para?
Para number 18, my lord. The short question that arises for consideration in this appeal is whether the High Court was justified in holding that the remedy of the appellant auction purchaser lies in challenging the action of the secured creditor PNB in forfeiting the deposit by filing an application under Section 17 of the Surface Act before the DRT, or remedy of the auction purchaser is in filing the writ petition under the Article 226 or 227 of the Constitution of India to examine the legality of such question.
Answer is where?
Last year. Para number 34. In the light of the foregoing discussion, we are of the considered opinion that the writ court, as also the appellate court, were justified in dismissing the appellate writ petition on the ground that availability of alternative statutory remedy of filing an application under Section 17 subclass 1 of Surface Act before the concerned tribunal to challenge the action of the PNB in forfeiting the appellant's deposit under Rule 9 subclass 5. We find no ground to interfere with the impugnant judgment of the High Court. The appellant is accordingly granted liberty to file an application before the concerned tribunal under Section 17 subclass 1 of the Surface Act, which has jurisdiction to entertain such application within 45 days from the date of this order. In case if the appellant files any such application, the tribunal shall decide the same on merits in accordance with law, uninfluenced by any of the
Yes.
observation made by this.
In view of this judgment, you have a remedy under 17.
Very well. But may I just articulate one thing, Lord? Your Lordship may record it and my Lord reject it also, my Lord, if your Lordship. My submission is, my Lord, it is not the law that, my Lord, merely because the respondent is a private body, my Lord, the writ will not be maintainable. Number one. Number two, Lord, when, my Lord, the
Not that you are remediless.
no, Lord, that is a separate argument, my Lord. No, I am only arguing about the maintainability.
Specifically constituted for deciding the dispute.
Lord, if the Supreme Court has held so, my Lord, then I am bound by it, my Lord. I will obviously approach the DRT. But what I am submitting, my Lord, now what they are doing is this, my Lord. They are very well aware, my lord, under the Contract Act, my lord, my lord, where there is suppression, misrepresentation, my lord, I am entitled to avoid the contract. I have avoided the contract. Lord, now they are saying, no, because once you have offered the EMD, not because of my mistake. Lord, that may be a case where, my lord, the purchaser did not want to purchase. Lord, here I am saying, my lord, that there is suppression. Now they have issued a fresh auction notice. Again, they have suppressed. Some other gullible person will face the same consequence which I am facing. Therefore, I am saying, my lord, when the bank, my lord, issues a public notice of an auction, what they are performing is a public duty, my lord. And when there is arbitrariness, my lord, in that, my lord, then your lordship cannot say, my lord, that, my lord, I will not exercise my jurisdiction is my point, my lord. Your lordship may consider that. Lord, only to that extent, my lord, I am submitting, my lord, that the Supreme Court itself has said, my lord, that, my lord, mandamus can be issued, my lord, in respect of a private party also. That is in 1989 to SCC 691, my lord.
Yes. Take the judgment.
Yes.
Please come.
Ajay.
The present petition is filed seeking the following relief. The
Lord, may I just show one more paragraph, Lord, in Shobha itself, Lord.
yes,
Very Shobha.
paragraph number 10.
Paragraph. Yes, Lord. No, paragraph 8, Lord.
Yes.
Paragraph 8.
Yes.
That's your lordship has seen it.
Yes.
Several times.
The petition is filed. Seeking the following case. The respondent is the respondent before this court is Karnataka Bank. There is senior counsel appearing for the petitioner submit that. The petitioner is auction purchaser.
Madam.
He has paid the EMD amount of rupees 23,50,000 and requested the bank to share the copies of the property title deeds with the petitioner. On the very same day, the petitioner handed over the property related documents to the petitioner's legal advisor, the scrutiny of title and such of encumbrance. The petitioner participated in the auction sale conducted with the respondent bank on 26/6/2025 and was held as successful bidder, quoting highest price of rupees 2,61 lakhs. On the very same day, the petitioner received a mail from the respondent bank intimating that the petitioner is successful bidder and directed the petitioner to deposit 25% of the bid amount. That is rupees 65 lakhs 25,000, which is inclusive of 10% EMD within next day and the remaining 70% within 15 days. On 21/6/2025, the petitioner was shocked to know that there is a partition suit pending, that's invoice number 982 of 2025 before the City Civil and Court and Session Judge Bangalore. And the respondent bank also is a party to the such, which has filed wakalat and appeared before the trial court. Petitioner, who had the long association with the respondent bank, contacted the bank and questioned by vital information. Unknown encumbrance is not revealed in the auction sale notice dated 2/6/2025. Petitioner has also written a letter stating that had he known about this encumbrance, he would not have ventured and participated in the auction. He wrote a request letter on 1/7/2025 about this suppression of the known encumbrance. And he has also requested for return of the EMD amount. The respondent bank addressed a letter dated 36/2025 to the petitioner forfeiting the earnest money deposit of 23,50,000 and issued another auction sale notice without even disclosing the fact of pending litigation. Then senior counsel submits that this action of the respondent is high-handed, arbitrary, and they cannot sell the property when they are known about the encumbrance on the said property.
Lord, my submission is not that they cannot sell, my lord. I am saying, Lord, they suppressed it.
They can't suppress the fact and sell the property on which there is an encumbrance. Submitted that when there is fault on the part of the respondent, they can't forfeit the amount. And had this fact been disclosed, they would have not participated in the auction. When this matter came up on the first day, this court had expressed the view that in the light of the order passed by a coordinate bench of this court in case of Karnataka Bank, a writ petition is not maintainable. Then senior counsel has made submissions on the maintainability of the writ petition. He has relied on the judgment of the apex court in Andi Mukta Satguru Sri Muktaji Vanda Swami Suvarna Jayanti Mahotsav Smarak Trust and others versus P.R. Rudani and others, reported in 1989 to SCC 691, which is a paragraph.
Yes, Lord, just give me a moment. Missing that. Lord, para 35.
Para?
Lord, para, just give me a moment. Lord, para 12 onwards, Lord. Lord, para 13, the decision of Varghese so-and-so case, there again dismissed lecturer of a private college was seeking reinstatement this court. But here in the, sorry, para 14, Lord. But here the facts are quite different. Therefore, we need to go thus far. There is no plea of specific performance of a contract. The respondents are not seeking a declaration that may be continued. They're not.
In his submission, senior counsel also points out that the petitioner has no other alternative remedy as forfeiture of the amount is not the measures as per section 17 and he cannot go before the DRT. Then his submissions also. Learned counsel appearing for the respondent submits that the Honorable Apex Court in case of Agarwal Trackham Private Limited was the Punjab National Bank and others has held that even on the forfeiture of the EMD amount, the aggrieved party can go before the tribunal under section 17. He has relied on paragraph number 34, 35 of the said order extracted. Next, in that continuation, when the matter came up, so he has relied on this judgment.
Look, sorry, that was para 20. I should have referred.
Para 20.
20.
In this judgment, para 20, and submits that the writ petition is maintainable. It is further submitted that when this court has specifically pointed out that in case of S. Shobha versus Muthoot Finance Limited, reported in 2025, SCC Online, SC 177, and also in case of that Vishwabharati. So the apex court has held that the writ petition is not maintainable against a private banking company and also asset reconstruction company and a private finance company. He submitted that in all those cases, either they are the borrowers, whereas here in this case, petitioner is only seeking the remedy of questioning the action of the respondents in forfeiting the EMD amount. It is submitted that when the action of the respondent bank is arbitrary, just because it is a private bank, cannot be a reason for this court not to exercise the jurisdiction under Article 226 of the Constitution of India. It is submitted that the writ petition itself is maintainable. Next, having heard the counsels on either side, there is a material on the relying on the judgment, that Gautam's case, that Gautam, Karnataka Bank is not maintainable. In the light of the law laid down by this court, in Gautam's case refers Supra, the writ petition, it is held that the writ petition is not maintainable against the Karnataka Bank. The consistent view is taken particularly under the surface proceedings in Shobha's case and in Vishwabharati's case, that against a private finance company, the writ petition is not maintainable. As such, this court is of the considered opinion that a writ petition against Karnataka Bank is not maintainable. Then coming to the next submission with regard to the submission that the petitioner cannot go before the DRT as forfeiture of the AMD amount is not a measure as per the Surface Act. The submission is also no legs to stand in the light of the judgment in Agarwal Tracom Private Limited referred Supra, and the petitioner can always question it before the DRT. In that view of the matter, the writ petition is dismissed, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Petitioner shall have the benefit of Section 14 of the Surface Limitation Act.
List number 2.
Obliged.
List number 2, serial number 1. Jalapati and Srinivas.
My lords, appear for the petitioner in this matter.
Yes.
May I please, my lords? My lords, I'm not pressing on prayer number 1 and 2, my lords.
Let's see what are your
Please, my
prayers.
lords. My lords, the second petitioner, my lords, is a police inspector who was working in a police station in Kanakpura Circle in Ramnagara district, my lords. My lords, based on a complaint with regarding to theft of certain jewelry, my lords, he conducts investigation. Then thereafterwards, he apprehends accused number 1, who was in Tamil Nadu. He says that he, along with other people, stole the jewelry in Kanakpura, and they have sold the said jewelry to one jewelry mart in Mysore, my lords. Based on the said information, my lords, the second respondent, who was the inspector, then inspector in the said police station, my lords, goes to Mysore along with his other subordinates, conducts search and forcibly locks the petitioner's shop, and also handcuffs him without an authority or a issue of authority by the court, drags him to the court and parades him in throughout Mysore with handcuffs and drags him into the court. Afterwards, taking him into the court, he removes the handcuffs, and thereafterwards he makes a requisition before the magistrate that an handcuff and a running chain has to be put to the accused so that they do not escape from the custody of the police, my lords. My lords, Annexure H, my lords.
So please come to the prayer.
Prayer, my lords. There is an order of this honorable court, my lords. Now the petitioner's shop is open. I'm not pressing on
Prayer
that.
number 1.
My lord, issue a writ in nature of mandamus or any other appropriate writ directing respondents to pay petitioner a sum of rupees 5 lakh as compensation for having illegally handcuffed the petitioner.
10 lakhs.
10 lakhs.
10 lakhs. Apologize, my lords. 10 lakhs, my lords. This is the gist of the case, my lords. The entire investigation, if it is looked into, even if you look into the case diary, it is annexed to the petition, my lords. There's a lot of discrepancy with regarding to the investigation which is conducted by the second respondent.
Now with regard
And
to-
my lords, they have filed a rejoinder, my lords. They do not even speak about handcuffing or anything of that.
Where is the material for this court to accept your contention that you're handcuffed?
My lord, and requisition is made before the magistrate, which is rejected. But in spite of that, I am handcuffed, my lord.
Where is that? Where is
My
that?
lords, if I may be allowed, I will produce video clippings of me
that's
being
what-
handcuffed,
no,
my lords.
Please understand, that's the whole difficulty in a jurisdiction under 226. All these facts we cannot decide here, whether he has handcuffed you or he has dragged you, did this and that. Then you should have filed a complaint against him, private complaint against the officer, where you
My
will
lord-
be able to adduce all the evidence before the court. No, this court cannot, even if you place all that and somebody denies it, but how will we decide all that?
My lords, my shop, without the authority of a magistrate, was illegally locked. That is the reason I came before this honorable court seeking two prayers, my lord. One to reopen my,
Except that it is locked.
that by way of an order of this court is accepted, my lord, and I have opened the shop.
Is it correct, Mr.?
No. This all, we had a permission from the magistrate. Then only we have seized his
My
premises.
lords, I will show the discrepancy in the
And one
case
thing-
diary.
and
I will show
one
the
thing.
discrepancy in the case diary, my lords.
Subject to allegations that he was handcuffed, barged in, all those things when he was produced before the magistrate. Nothing was prevented for him to make statement before the magistrate and record it, so that the magistrate would have been directed for the department to issue show cause notice to the concerned officials, or action would have been taken that. In absence of any materials where he was produced before, he is not an innocent man, he is an accused. They have.
Sorry, my lords, I was not an accused at that point of time at all.
No. Once there is a theft case, it is our duty to go and investigate it. It is a non-chargeable offense, non-bailable also. We did not get any, we got the permission, we went to the shop. By the time when we, after seizure also, what he has done, he has inside, he has break open the shop lock, he has removed all the jewelries which are kept inside it. He has fled fraud to that. In respect to that, there is charge sheet is already filed before the learned trial judge. Now the matter is set for appearance of the accused. Summons also issued. There was nothing prevented for him to report to the concerned magistrate.
That is the only contention what they have taken, my lords. Any naive person wherein he has been taken into custody by a uniformed officer, my lords, will he have that guts to tell the front of the magistrate, yes, I was humiliated, he has done such an overt act against me, my lords? My lords, let my learned friend who is appearing for the state, let him look at the case diary and tell me that I had forcibly put a lock to my shop. It is not so, my lords.
Then why did you, when the court has passed an order to open the lock? No, when was the shop locked?
My lords, 2022 when I filed this petition, my
There
lords.
should be a date for that.
13,
We took permission from the concerned magistrate.
When was the permission?
13/7/2022, my shop was locked, my lords.
1 month.
In 19224, the first petition, my lord, the
2004?
the petition, first petition 19224 of 2024. The present petitioner is an accused number 2 in the FIR. My lord. Kindly see my statement of objections, my lord. Kindly take my statement of objections.
No, just give the date. All of that is not necessary. When was the shop lock? When was the permission from the magistrate obtained?
Search warrant was taken, my lord, annexer R8.
Dated?
My lords, if I can come on the dates, my lords. 13/7/2022, my shop was closed, my lords. And 18/7/2022, after closing my shop, police conducted search of the shop, my lords.
Search was on 18/7.
18/7, my lords.
When was the permission from the magistrate?
Kindly see R8, my lord, form number 10, annexer R8, 16/7/2022.
That is after 13/7.
Yes, my lord.
Now, where is the material before the court that on 13/7 your shop is closed?
My lords, case diary, my lords.
Where is it?
Annexure E, my lords.
Page number.
Annexer is agreement of lease, my lord.
My lords, if I can kindly take my lords to order of this honorable court dated 27/10/2022.
Yes.
May I please, my lord? Learned additional government advocate could submit that the petitioner had not cooperated with the investigation as they have locked the premises with the investigation as they have locked the premises and ran away, which is disputed by the learned counsel for the petitioners. Learned additional government advocate could further submit that if the petitioner could cooperate with the investigation, the lock of the jewelry shop could be opened subject to such cooperation with the investigation before the investigating
That
officer.
submission we cannot consider now for the reason, on 18/7/2022, they have the permission to go
Yes, my
seize the
lord.
shop.
13, they closed my shop.
But for that, that is what I'm saying. Where is the material for 13?
Please, my lords, please, my lords. My lords, annexure F, ink page number 33. It is in Kannada, my lords, if I am allowed to read.
What is that?
My lords, the last paragraph, it says,
Mahajan.
Which petition, sir? Which one?
I am talking petition number 19068 of 2022.
19224 is before this court.
My lords,
What happened to the first petition? You gave the other one.
my lords, with regarding to those, the prayer was only with regarding to opening of the shop, my lords. But in this matter, he was illegally handcuffed, my lords.
To deseal the shop. Same prayer in this also.
Same prayer.
You sought for 10 lakh compensation for illegally seal a lock shop.
Lock.
And 5 lakhs.
5 lakhs
for
for
illegally handcuffed.
handcuffing, my lords. My lords, annexure F, my lords, ink page number 33, my lords. If I can kindly read, my lords.
Yes.
ಈ ದಿನ ದಿನಾಂಕ 13/7/2022 ರಂದು ಆರೋಪಿ ಸಂಖ್ಯೆ 1 ರವರು ನೀಡಿದ ಮಾಹಿತಿ ಮೇರೆಗೆ ಕಳವು ಪ್ರಕರಣದಲ್ಲಿ ಕಳವು ಮಾಡಿದ ಬಂಗಾರದ
Reading at page?
ink page 33 in petition 19068, my lords.
Yes.
Page ink page 33 annexure F, my lords. May I please, my lords? Second ink page 33, my lords. ಈ ದಿನಾಂಕ 13/7/2022 ರಂದು ಆರೋಪಿ ಸಂಖ್ಯೆ 1 ರವರು ನೀಡಿದ ಮಾಹಿತಿ ಮೇರೆಗೆ ಕಳವು ಪ್ರಕರಣದಲ್ಲಿ ಕಳವು ಮಾಡಿದ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಮೈಸೂರಿನ ಬೆನಕಾ ಗೋಲ್ಡ್ ಲೋನ್ ನ ತನ್ನ ಸ್ನೇಹಿತ ಶಿವರವರಿಗೆ ಪರಿಚಯವಿದ್ದ ಇರ್ಫಾನ್ ಮತ್ತು ಶಾಹಿಲ್ ಎಂಬುವರ ಮೂಲಕ ಮೈಸೂರು ನಗರ ಅಶೋಕ ರಸ್ತೆಯಲ್ಲಿರುವ ಹರೇ ಕೃಷ್ಣ ಜ್ಯುವೆಲ್ಸ್ ಅಂಗಡಿಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುವುದಾಗಿ, ತನ್ನ ಜೊತೆ ಬಂದರೆ ತಾನು ಕಳ್ಳತನ ಮಾಡಿದ ಒಡವೆಗಳನ್ನು ಮಾರಾಟ ಮಾಡಿರುವ ಹರೇ ಕೃಷ್ಣ ಜ್ಯುವೆಲ್ಸ್ ಅಂಗಡಿ ಮತ್ತು ತನ್ನಿಂದ ಒಡವೆಗಳನ್ನು ಖರೀದಿ ಮಾಡಿದವರನ್ನು ತೋರಿಸುವುದಾಗಿ ನುಡಿದಿದ್ದು, ಅದರಂತೆ ಆರೋಪಿಯ ಮಾಹಿತಿ ಮೇರೆಗೆ ಮೈಸೂರು ನಗರಕ್ಕೆ ತೆರಳಿ ಶಿವ ರವರನ್ನು ಕರೆಸಿಕೊಂಡು ವಿಚಾರಣೆ ಮಾಡಲಾಗಿ ಆರೋಪಿ ಸತೀಶ್ ಬಳಿ ಇದ್ದ ಒಡವೆಗಳನ್ನು ಶಾಹಿಲ್ ಮತ್ತು ಇರ್ಫಾನ್ ರವರ ಮೂಲಕ ಹರೇ ಕೃಷ್ಣ ಜ್ಯುವೆಲ್ಸ್ ಮಾಲೀಕರಾದ ರಾಜ್ಕುಮಾರ್ ಅವರೊಂದಿಗೆ ಮಾತನಾಡಿದ್ದು, ರಾಜ್ಕುಮಾರ್ ಅವರು ತನ್ನ ತಮ್ಮ ಯಶವಂತ್ ರವರನ್ನು ಆರೋಪಿ 1 ರವರ ಕೋಳಿ ಅಂಗಡಿ ಬಳಿ 4,70,000 ರೂಪಾಯಿಗಳನ್ನು ನೀಡಿ ಆರೋಪಿ 1 ಸತೀಶನಿಂದ ಒಡವೆಗಳನ್ನು ಖರೀದಿ ಮಾಡಿದಾಗಿ ತಿಳಿಸಿದ್ದು, ಆರೋಪಿ ಸತೀಶ್ ಮತ್ತು ಶಾಹಿಲ್ ರವರ ಮಾಹಿತಿ ಮೇರೆಗೆ ಹರೇ ಕೃಷ್ಣ ಜ್ಯುವೆಲ್ಸ್ ಅಂಗಡಿ ಬಳಿ ತನಿಖೆಗೊಂದು ತೆರಳಿದಾಗ, so 13/7/2022, even according to the case diary produced before this honorable court, the investigating officer himself says, along with the other accused people, he went to the petitioner's shop.
Did you say that he seized it?
My lords, he's not said that. What he says is, ಒಂದು ಸತೀಶ್ ಹರೇ ಕೃಷ್ಣ ಜ್ಯುವೆಲ್ಸ್ ಅಂಗಡಿ ಬಳಿ ತನಿಖೆಗೆಂದು ತೆರಳಿದಾಗ ಆರೋಪಿ 4 ರವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಲಾಗಿ, ತಾನು ತನ್ನ ಮಾಲೀಕರಾದ ರಾಜ್ಕುಮಾರ್ ರವರು ಹೇಳಿದಂತೆ ಮೈಸೂರು ತಾಲೂಕು ವರ್ಣಾ ಹೋಬಳಿ ಹಾರೋಹಳ್ಳಿಯಲ್ಲಿರುವ ಆರೋಪಿ 1 ಸತೀಶ್ ಕೋಳಿ ಅಂಗಡಿ ಬಳಿ ಹೋಗಿ 4,70,000 ರೂಪಾಯಿಗಳನ್ನು ಕೊಟ್ಟು ಆತನ ಬಳಿ ಇದ್ದ ಚಿನ್ನದ ಒಡವೆಗಳನ್ನು ಖರೀದಿ ಮಾಡಿಕೊಂಡು ಬಂದು ತಮ್ಮ ಅಣ್ಣ ಅಥವಾ ಮಾಲೀಕ ರಾಜ್ಕುಮಾರ್ ಅವರು ಹೇಳಿದಂತೆ ಸತೀಶ್ ಅನ್ನು ನೀಡಿದ ಚಿನ್ನದ ಒಡವೆಗಳನ್ನು ತಾನು ಹಾಗೂ ತಮ್ಮ ಆರೋಪಿ 3 ರವರು ಕರಗಿಸಿ ಸ್ವಲ್ಪ ಮಾರಾಟ ಮಾಡಿ ಉಳಿದ ಒಡವೆಗಳನ್ನು ಇಟ್ಟುಕೊಂಡಿರುವಂತೆ ನುಡಿದಿರುತ್ತಾರೆ. ತನಿಖಾಧಾರಿಯಾದ ನಾನು ಆರೋಪಿ ಸಂಖ್ಯೆ 3 ಮತ್ತು 4 ರವರಿಗೆ ಆರೋಪಿ 1 ರವರಿಂದ ಖರೀದಿ ಮಾಡಿರುವ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ತನಿಖೆಗಾಗಿ ಹಾಜರುಪಡಿಸುವಂತೆ ಸೂಚಿಸಿದ್ದು, ಆರೋಪಿ ಸಂಖ್ಯೆ 3 ಮತ್ತು 4 ರವರು ಚಿನ್ನದ ಒಡವೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಲು ನಿರಾಕರಿಸಿ. They say, I have objected for producing the said jewelry. ಆರೋಪಿ 2 ರವರು ಸ್ಥಳಕ್ಕೆ ಬಾರದೆ ಇರುವಂತೆ.
We don't require to look into other things. Only thing what I want you to tell the court is whether as per this 14/7/2022, what you are reading now, did the officer say that on 13/7 they have seized your premises?
My lords, on that day they did not seize my premises. They merely locked my premises forcibly.
Lock the premises. Did he say so?
No. My lords, it is clearly written in the order, my lords.
Which order?
Annexure G.
Asked by whom?
When they produced the petitioner before the magistrate, my lords.
Let's see. Page number.
35, ink page 35, my lords.
Yes. Yes.
Peruse the office note. The concerned CPA has filed requisition before this court seeking the permission of the court to handcuff and leading chain to accused number 3 and 4 when they are escorted our side at the time of investigation.
That has been rejected by the magistrate.
My lords, let me complete, sir. Peruse the requisition. On perusal of the requisition, it appears that accused number 3 and 4 are only the purchasers of stolen property, and the reason stated in the requisition that there are chances of accused escaping at the time of investigation is only an afterthought. There are no sufficient materials found in requisition to satisfy reasonably that it is very much necessary to handcuff the accused at the time of escorting for investigation. There must be a strong reason that accused are likely to jump the custody in order to handcuff them. As the handcuffing of the accused person without there being a very strong reason could amount to violation of constitutional right, the prayer made in the requisition is hereby rejected. Peruse the office note. The concerned CPA has filed a requisition before this court seeking search warrant in pursuant to the reference made in the said requisition. Due inquiry made and pursued the requisition. In the requisition, it is stated that accused number 3 and 4 have purchased stolen properties from accused number 1, and on inquiry made have found that accused number 3 and 4 being purchasers of the stolen property have kept them in their residential house number 139 Hansraj Gully, Mahavira Nagar, Mysore, and in Hare Krishna Jewelry Shop at Raj Goldsmith Jewelry Shop, and accused number 3 and 4 are not cooperating to the police at the time of investigation and refuse to close the shop. Hence, the shops were sealed by the police, and now requesting the permission to issue search warrant in order to ascertain and also in order to seize the stolen articles. In pursuance of the requisition and considering the nature of the offense, my lords, this clearly shows they had gone on that day. They have taken them into custody.
Last.
Blood. The purpose of investigation in a theft case is to first see that the stolen item should be prevented for misusing. For that reason only initially they have sealed it. Thereafter they have sought permission from the concerned court.
The procedure.
Procedure, my lord, the FIR was registered. Once what happens, my lord, they visited the premises, the shop where the alleged stolen items were kept. They did not cooperate with the investigation. If that shop is at that point of time was not sealed, they would have, it's not in something else, it's a small items, it's a gold items. They would have taken it away. They would have.
No, that's what I'm asking. Does the CRPC gives based on such a procedure that if there is any imminent necessity without any permission from the magistrate, you can search, seize?
The duty of the police is to prevent. No,
Not about the duty. It's about your duty is.
Initially they have sealed it. Otherwise, in theft case, it's the first priority is to recover the items. If I did not do so, then I will be failing my discharging my duties, my lord. If I did not seal it, you would have moved it. It's not something, it's a mission, something like that. You wouldn't have. But these are all ornaments. And initially, my lord, kindly see page number 34.
So before going to 34, you have to substantiate what you have done by way of what is the procedure. Have you followed a procedure laid down under law or what you did? You have to first support your.
Kindly see 37, I'll read it again once more. In the requisition, it is stated that accused number 3 and 4 have purchased the stolen properties from accused number 1 and on inquiry made have found that the accused number 3 and 4 being purchaser of the stolen property have kept them in their residential house, so and so, so and so, so and so, and in Hari Krishna jewelry shop and Raj Gold jewelry shop, and accused number 3 and 4 are not cooperating to the police at the time of investigation and refused to close the shops. But if they refuse to close the shop, if somebody has, if in case of some theft, that to particularly gold ornaments, gold, if somebody is refusing, what shall I do, my lord? As a police officer, should I come back so that he can remove it? My lord, and in murder case and in the theft case, in the murder case, the body should be recovered. In theft case, the item should be recovered. Otherwise, I would be helpless. So this is the reason I insist for closing it. I have not sealed it. I am closing it to prevent it further loss to the person who has lost it. So initially, I have closed it. Thereafter, I sought a permission before the magistrate saying that.
What that post facto permission, whether the CRPC contemplates it, your whatever is your endeavor, but you are bound by the rule of law.
Yes, my
There is
lord.
a procedure which contemplates that. That is only I am asking.
Kindly see 102, my lord, of the CRPC.
Yes. CRPC.
102.
She'll have.
CRPC ಇತ್ತಲ್ಲ ಅಲ್ವಾ?
CRPC. Yes, please read.
Power of police officers to seize certain property. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offence. Such police officer, if subordinate to so and so, every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court or so and so, where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required, and to give effect to the further orders of the court as to the disposal of the same. See, section 102 gives power for us to seize.
It is, if my learned friend is saying that, have they done it on record? What the material what I have filed before this honorable court, does it show that they have done it as per the law laid down, my lord?
The read 1 or 2.
My lords, power of police officer to seize certain property. Now my property is what, my lords? Property is with regarding the stolen property, my lords, which is in the premises of the shop, inside the shop. If he wanted to do it, he could have done it. That is not the case. Why he had to seal my entire shop?
Yes. Yes.
Even in a grievous case of murder, properties, either a weapon which is used, my lords, property is not an immovable property, my lords.
Yes.
How could he close my property my shop forcefully? He could have taken permission from the magistrate. That is not been done so.
Say so.
My lords,
It doesn't say so that prior permission is required. It says that after doing it, it should be brought to the notice of the magistrate.
My lords, whether they have bought that, my lords,
It is
what do
brought-
they say?
They have done it on 13th and 14th. It was brought to the notice of the magistrate.
18th they conduct search, my lord. Why was it required, my 18th? 18th, my lord. 13th they closed down my shop, my lords. 18th they conduct a season search, master.
Yes.
My lord, this itself shows that there are a lot of lacunas in the said investigation and the way they have acted with the petitioner and his family, my lords. This is not the way, my lords. They belong to the minority community in the entire state. They are always spectacle to these kind of offenses, my lord.
The writ petition WP number 19068 and WP number 19224 of 2022, both the writ petitions filed seeking the following prayers. What is the relation between the two?
My lords,
Relation between the two petitioners.
they are brothers.
The both the petitioners and both the writ petitions or the brothers. Land counsel appearing for the petitioner submits that the respondent police have acted in a high-handed manner on 13/7/2024 without following the due process in a high-handed manner. They seized the shop of the petitioner. And it is the case that they have taken the petitioner into custody forcibly, handcuffed the petitioner, and removed a currency note of the denomination of rupees 100 from the pocket of the petitioner. This action of the respondent in handcuffing the petitioner is highly arbitrary and illegal and violative of the rights guaranteed to the petitioner. It is submitted that they have taken the petitioner to the magistrate with the handcuffs and while presenting before the magistrate, they remove the handcuffs. In fact, they have asked a permission from the magistrate to handcuff and chain the petitioner, which was rejected by the magistrate, which clearly shows the high-handed action of the respondents. It is submitted that though the objections are filed, the objections are not, they have not categorically denied any of the allegations that are made by the petitioner. It is submitted that in the light of this action of the respondents, the petition, it is submitted that by way of an interim order, the locks were removed. And now, by way of the petition may be allowed and the petitioner may be granted the compensation as prayed for in the writ petition. Learned AGA, appearing on behalf of the respondent, submits that whereas the articles that are stolen were gold articles which are kept in the shop of the petitioners, and the petitioners were not cooperating with the investigation with the police. As such, having no other option, they have sealed the shop, and the same was brought to the notice of the magistrate immediately. It is submitted that in those circumstances, that's a requirement, and if the shop is not seized and the petition is permitted to take away the articles, it would be difficult to recover the same. So, in the interest of the same, the interest in the pursuit of doing justice, they have seized the shop, and this has been already brought to the notice of the magistrate. The allegation that the respondents have handcuffed the petitioner are all baseless, and they have not done any of the activities as stated by the petitioner. It is submitted that the same paragraph, it is submitted that the petition is liable to be dismissed by having heard so and so. The petitioner has made two allegations against the respondent. One is that they have seized the premises on 13th without the permission from the magistrate, and they have handcuffed the petitioner. And for this, he is seeking compensation. As far as the handcuffing of the petitioner is concerned, there is no material placed before the court to show that, except the requisition before the magistrate. Placing on that, this court cannot come to a conclusion that the petitioner was handcuffed, and it is a disputed question of fact which cannot be decided by this court, exercising the jurisdiction under Article 226 of the Constitution of India. Then coming to the second aspect, Section 102 of the CRPC reads thus, extract. As per the same, the respondent has the power to seize the premises and immediately whatever is the seized articles of the property has to be placed before the magistrate, and the concerned whoever want the custody of the same can file an application before the magistrate. Even on that count also, this court is not inclined to interfere. Accordingly, this court is passed the following order. The writ petition is disposed of, giving liberty to the petitioner as far as the allegation with regard to the handcuffing of the petitioner to avail the remedy before the appropriate forum, as the same cannot be decided by this court. Yes.
Serial number 2.
Serial number
2.
Yes.
Narayanamma.
My lord, I seek for a 2 weeks adjournment. 2 weeks adjournment, I seek.
Lord, in this matter, my lord, after investigation, charge sheet is filed, my lord. In special
What is
CC
the
numbers.
relief that is sought?
Lord, yes, sought, my lord, to, it is, relief is at page, my lord.
May we please
He is seeking
issue
to
us
stop further
also
investigation.
direct the respondent to stop further investigation of the affairs of the petitioner in connection. No, you conducted the investigation, file the charge sheet.
No,
You
I
have
am
filed in
not an
charge sheet,
accused
madam.
there. I am not an accused there. In the charge sheet, I am not an accused. Even in the proceedings, notice was issued under section 91 as a witness. And the acts come in.
No, the relief you sought is to stop the entire investigation.
Yes.
As far as crime number 97 is concerned.
Yes.
They have completed the investigation and filed the charge sheet.
Yes.
What remains now?
My bank account has been seized, that has been defrozen, but
Has
they
to
should
make
not
an
again
application.
revoke it.
He has to make an application before the.
What
No,
is
no,
that?
no. My bank account has been attached and subsequently by interim order, it has been deattached. It has been raised, attachment has been raised.
When a particular property is seized by the police in furtherance of registration of a crime, for any interim custody of it, you have to go before the concerned.
No, no, this court has defreezed it. Now they should not again say that it is writ petition has been disposed of, therefore I am going to attach it. Again,
I am not able to understand. What is it?
my lord. As an interim measure, this honorable court has raised the attachment. Now, once the writ petition is disposed of, they can say that interim order evaporates with the disposal of the writ petition. Again, I am going to attach it. And my question is, I was not accused even before the officer. Summons were issued to me under section 91 of the CRPC as a witness. And I am not carrying on any business. My business transaction earlier to 21 to 19, they are asking. The act came into force from 21 to 19. They
Past a
want.
consequential prayer. The main prayer itself is will not fall for consideration now.
No, you see, the main prayer, with an observation that they should not proceed against me.
Why would we say all that? Unless and until, what happened to this account?
Because, my lord, some amount was transferred from the accused number 1 account to petitioner's account, my lord. For that, my lord, 3 times notices were issued. They are not represented before the IO, my lord. They approached this court, my lord. Now, my lord, the investigation is completed. And it is the subject matter, my lord, before the concerned court, my lord. He has to make an application before the competent court, my lord. It is in next date of hearing is on 10/4/2026, my lord.
10/4?
2026, my lord. He has to make an application there, my lord. Now it is the part of the charge sheet, my lord.
My learned friend's statement is erroneous. Your Lordship may kindly see Annex E. The English translation, I have stated very clearly that I have not committed any offence under the Buds Act. And what you are asking is, yes, beyond your powers, you don't have powers to ask for it, but still.
Some property, some amount is transferred.
No, they
to your
want some account, they want some balance sheet, they want some transactions and I think prior to 19.
All that will be decided by the court, provided you go there.
No,
If you are here for-
I have not been arraigned as an accused there. I have not been arraigned as an accused here. I am neither here nor there, but their proceedings are here. What my apprehension is only this much. In the guise of.
You need not be arraigned as an accused. If your property is being seized in any criminal proceedings, you will get a right to file an application before the magistrate.
That is perfectly right, my lord. What I am
Yes.
trying to say is, as of now, what has been attached has been defreezed. But now they should not again reactivate it. That's what I am asking.
By virtue of an interim order, it is already now
No, my lord, it is not deactivated.
No, deactivate. I already, I activating the bank account. That is what interim order has been granted to me. What has happened is my.
There is no interim order in this.
That is the reason why my account of the file, I am not
No,
able
no,
to
there
get.
is no interim order. I have the.
But my account has not, my account, I am operating the account.
Then
See,
you continue to operate.
No, what?
Because no order
Your
is
Lordship,
passed by the court.
My only request is.
Get instructions. What happened to that account? Yes,
No interim order is
get
there.
instructions.
Please, ma'am.
Let this matter
2 weeks
on,
later, my lord.
on 7th of April.
Number 3.
By the time then at HCGB shall get specific instructions about the status of the petitions.
Number 3, BV Pinto.
Serial number 3, I appear for the second respondent bank, Your Honor.
List number 2, serial number 3, sir.
Yes.
In this,
List number 2,
in this
serial
matter,
number
my
3, I appear for the second respondent bank, please.
In this matter, my lord, C report is filed. Before filing C report, my lord, notice was issued to the petitioner. Same has been accepted, my lord. After this, my lord, there is a signature is also there, my lord.
This petition is filed in the year 2022
Please.
on 799. And when is this B report?
Lord, that is, my lord, notice, my lord, 25/6/2022, my lord.
25, after filing of the writ petition.
Yes, ma'am.
The present writ petition is filed. Seeking the following prayer. It is submitted that there is no representation on behalf of the petitioner. Learned counsel appearing for the learned HCGP submits that the police after investigation filed a B report dated
C report.
25/6/2022, and the same is a notice is also given to the petitioner. The document, the same is placed before the court, which bears the signature of the petitioner. In that view of the matter, nothing survives for consideration in this petition.
C report, ma'am. It is C report, my lord.
C report accordingly dismissed as instructions.
Serial number 4. Serial number 4 is Balakrishnan.
Lordships, here for the petitioners in this matter, your lordships. This writ petition is filed with a prayer to this court to direct the investigation to respondent number 5 and 6, that is CBI and CID, your lordships. This case is, your lordships, the petitioner.
Direct respondent 5 or 6 to take forth the further investigation.
Please, your lordship.
5 or 6.
Please,
No
your
choice is given to them.
CBI or CID is what we are requesting, your lordships, because for this
Crime
matter.
investigations department CID or 6 is Central Bureau of
Investigation.
CBI.
Please, your lordships.
Why you should be?
Your lordships, one, your lordships, this matter, the petitioner owns a agarbatti factory, your lordships. So he purchases bamboo incense sticks from China, your lordships. And the way the payment is made is through invoices raised by them through their email ID sent to my email ID, your lordships. And accordingly, the bank transactions and payments are being made, your lordships. So on one occasion, what happens, your lordships, we receive a invoice from a email account, which is seen, which if your lordships may kindly see page number 13, your lordships. Page number 12, your lordships. Page number 12, para number 2. The complaint.
Yes.
Your lordships, the email ID of the company from where we transact our import our instance sticks, your lordships, is in para number 2, line number 2, your lordships. Para number 2, second line, your lordships.
Yes.
As you can see, your lordships, the YTG, the domain name YTG 001 at yitinguo.com, your lordships. And at the fourth line, your lordships will get the fake email ID through which the invoice was given to us, your lordships. There's only one word difference, your lordships, one letter, W and U, your lordships. So based on that, your lordships, we set the bank to make the necessary transaction to be done, your lordships. And after 4 days, we get the information from the bank that it was a fraudulent bank account for which the transaction was made by us, your lordships. And the investigation, we filed a complaint, and the investigation was conducted by them, your lordships, and they filed a C report stating that the account where the amount was transacted is in Slovakia, your lordships. And since the Indian government do not have any MLAT MLAT treaty or a bilateral agreement with them,
This is
Please.
precisely the cyber crime.
Please,
That's
your
what is
lordships.
happening in every case.
Please, your lordships. But your lordships, that
Now,
according,
this petition is filed in the year 2022.
please, your lordships.
In 2025, what the CID and CBI will do now?
Your lordships, one request from us, your lordships, as we can see, your lordships, the investigation is gone only on one direction, your lordships. They have only try to trace out where the amount has gone, your lordships. But with regards to the email ID, your lordships, there's no kind of investigation that has been conducted, your lordships. The sections invoked are 66C and
Now they have
66D.
filed what report is filed?
C report.
However, my lord, liberty.
CID, CBI, all
Your
that we can't direct them.
However, my lord, liberty is reserved, my lord. May I pass it on the order sheet, my lord. The C report filed by the IO is accepted, reserving liberty to the IO to reopen the case if the accused is stressed.
Your lordships, but to trace the accused, some kind of investigation has to be done, your lordships, with regards to the domain registration or IP address, email address, or the email headers has to be done, your lordships. This,
We can't direct the CID, CBI to do all this.
or
The-
at
the
least, your
police-
lordships,
If
the
you're not
concern.
agreed, file a protest petition before the magistrate and tell the magistrate that this is what is happening. Then there will be a direction to the police.
Since the investigation is completed, my lord, the prayer does not survive for consideration. Since the investigation is completed and C report is filed, my lord, the prayer does not survive for consideration, my lord. No,
The presented
lordships.
petition is filed seeking the following prayer.
Your lordships.
Council appearing for the petition submits of the respondents. With regard to the email,
Your lordships, if I may, it will go back to the same investigating it. Again, the same kind of report will be
But
filed,
this kind
your
of,
lordships.
no, for CID, CBI inquiry, not these kind of cases.
Lordships, they do not even have.
You know,
the-
there are norms for that. Have you seen the judgment? When the court can issue a direction to inquiry by the CID, CBI, we can't do it just like that. What did you write? Submits that it's a cyber crime. And the police are not competent to the investigation, the law and order. It has to be either by the CBI or the CID. Then counsel appearing with respondent submits, Leonard EGA submits that, Leonard HCGB submits that. They've already concluded the investigation and filed a C report.
C report, my lord, on 5/2/2021.
5/2/2021.
Before the senior civil judge and principal JMFC Kolar.
So it is submitted that if the petitions are agreed by the same, they could have filed a protest petition. And in the light of the C report being filed, nothing survives for consideration in this writ petition.
And notice was also issued before filing C report, my lord. Notice was
So
also
notice
issued.
is
There is no
also
reply
issued
for
to
this
the-
notice also.
Issued to the petitioner. The prayer of the petitioner to conduct the investigation by the CID or the CBI cannot be considered by this court. If the petitioners are agreed by the C report that is filed by the police, there is a remedy available to the petitioner. In that view of the matter, this writ petition is disposed of giving liberty to the petitioner to question the C report filed by the police.
Number 5.
Grateful, your lordships.
Let the petitioner and the 6 respondents were the partners of the firm.
Please come to the prayer.
That prayer is quash annexure A on the ground that it is without jurisdiction.
Notice dated, what is the notice?
That notice, my lord, this is SC/ST commission enters into a civil dispute, SC/ST
It's a
inspector of
civil right
police.
enforcement.
One second.
Civil right.
Civil rights enforcement, my lord. The issues a notice saying that there is a civil dispute between both of, I'll just take your lordship. There is a partnership deed between the petitioner and the sixth respondent. Annexure B is the partnership deed. My lord.
Sixth respondent.
Sixth respondent belongs to scheduled caste. First
He's
petitioner
a
also.
complainant. He's a complaint before the department.
You should allow me to argue the matter. Just
Sorry.
allow me to argue so that you can argue later. My lord, kindly come to annexure B, my lord. Is a partnership, my lord.
First, let us see the
Yes,
complaint filed by.
my lord, he is the third partner. Then, my lord, there was a dispute between the petitioner and the sixth respondent in respect of this partnership. My lord, by being a partner of this partnership called Vigneshwara Granites, he started interfering with the acquiring activities of another company called Ganapati Granites Private Limited. My lord, I have produced the copies of the lease deed. My lord, the lease deeds are granted in the name of the company. Then, my lord, a police complaint was filed because he came and stopped the entire acquiring activities. And the police complaint is filed at annexure H, page 198. My lord.
Filed by you.
Filed by the petitioner. Sir.
Date.
This dated 10/5/2022. Then they issued an endorsement, my lord, stating that
Against the sixth respondent.
against the sixth respondent.
Yes.
Then, my lord, they issued an endorsement stating that, my lord, it is a civil dispute. The inspector of police issued an endorsement annexure K, page 208. My lord, there was constant interference in the acquiring activities and the police were not providing protection. Therefore, the petitioner approached this court, my lord, in WP 11,719 of 2022. Now, this court disposed of the writ petition, directing the police to look into the complaint and provide appropriate protection to the petitioner. Now, he files a complaint to the Superintendent of Police. Your Lordship, I kindly come to it is in Kannada language, annexure G, page 196. His complaint is, my lord, that he is being subjected to that he refers to, my lord, I will just read this in Kannada language. My lord, subject, my lord, what he says is he is the partner of Vigneshwara Granites. The petitioners have cheated him is the complaint. Annexure G, page 196.
Translation.
Translation, my lord, I will just read, my lord. Translation I have not filed, my lord. This.
No, what is it in annexure?
It says, my lord, ಪಾಲುದಾರನಿಗೆ ಮೋಸ ಮಾಡಿ ಮಾಡೋ ಉದ್ದೇಶದಿಂದ.
What is it at 198?
My lord, this 96, my lord, is a complaint filed by the petitioners. My lord. So that was protection was not provided. I came to this court. This court gave a direction and then it provided protection.
198 is
Then annexure Z is the complaint of the sixth respondent. The substance of the complaint is, my lord, that in respect of this partnership firm, the petitioners are cheating the sixth respondent. My lord, this complaint, other complaints, my lord, the police close. And then, my lord, he goes to the, kindly see annexure A, the police at Kolar, this is now, I'm sorry, the Bangalore, he goes to SC/ST, the directorate of SC/ST and files a complaint, the very same complaint, which was already filed before Superintendent of Police, that the inspector, police inspector issues a notice calling upon him to appear before him. But this is a purely civil dispute between the two partners and the SC/ST commission.
Who has issued you the notice?
But this notice is issued by inspector of police. He says you come and inspect in respect of financial transaction between the petitioners and the sixth respondent. Shall I read that annexure A and translate, Malad? Yes, sir. ಹಣಕಾಸಿನ ವ್ಯವಹಾರದಲ್ಲಿ ವಂಚನೆ ಮಾಡಿದ್ದು ಕೇಳಿದ್ದಕ್ಕೆ ಅರ್ಜಿದಾರರ ಮೇಲೆ ಹಲ್ಲೆ ನಡೆಸಿ ಜಾತಿ ನಿಂದನೆ ಮಾಡಿ ದೌರ್ಜನ್ಯ ಮಾಡಿರುತ್ತಾರೆಂದು ನಿಮ್ಮ ದೂರುಗಳ ಅರ್ಜಿಯನ್ನು ನೀಡಿದ್ದು ಸದರಿ ಅರ್ಜಿ ಕುರಿತಂತೆ ನಿಮ್ಮ ವಿಚಾರಣೆ ಅಗತ್ಯವಾಗಿರುವುದರಿಂದ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆಗಳಿದೆ. So and so you come. He says, my lord, that there is the fifth respondent, but there is the allegation with regard to financial transactions, and he was abused with his caste, and therefore he asked him to appear before the court. The first petitioner is also a scheduled tribe person. But the series of complaints were filed, and my lord, this is with regard to civil disputes. Your lordships are aware, my lord. In case of civil dispute, now police cannot investigate and call upon. No FIR is registered, my lord. This is not for preliminary inquiry. If there is a cognizable offense is made out, he is required to register FIR and then he is required to call upon. No FIR is registered.
Under which provision this?
There is no reference of any provision of the law, my lord.
Under which provision this notice is issued?
There is no provision is mentioned in the notice, my lord. I have to get instruction whether it is closed or
Not
Pending
closed,
state
whether
because
it
of the
is
interim
closed
orders.
or not closed.
because
Whether you have the jurisdiction.
No, there is
to
a
do like
act,
that.
not protection of civil rights, and there is a department directorate of civil right enforcement. There are provisions. Of course, they are not
So
referred.
they, civil rights, they can interfere with the civil disputes.
Not regarding to atrocities, my lords. Atrocities Act.
Does the petitioner belong to the SC/ST community?
Yes,
Then
respond number 6.
Between the two persons, two SC communities, then they will decide with regard to atrocities. If a person belongs to, one belongs to the SC community and the other is other community, then we can understand. Where are the atrocities there?
Well, this is second complaint, my lord. He files a complaint to superintendent of police.
Will allow the petition.
No, it's only one submission.
Yes.
No, sir, nothing more. No, it's only on the, no, I'm not on the law, on the position of law, whatever it is. Just only to apprise the court, not the conduct of the petitioner. Not he is one of the partner. He was supposed to not settle the whatever the profits with the other partner. He didn't want to settle it. Not he came, there were number of complaints, no doubt. He approached this honorable court. He obtained an order that an FIR should be registered against me. Not in that case, not though he has made me a party, he has deleted in the cause title. Not then I approached this honorable court. Challenging that order was passed behind my back. I was not given any opportunity. Then I got a stay of that order. Not in meantime, what happened? Kindly see the orders, my lords. There was a settlement between the petitioner and the respondent number 6. Not he undertook not that he will pay, my lords, 2.50 lakhs for 10 months. He undertook to pay that, and we also agreed that we will withdraw all pending cases between us. Now, what has happened is, my lords, now after honoring that, I withdrew my case, which he has challenged, and he got an order that FIR should be registered against me. No, my lord, so he is not honoring that commitment. Now he is not paying them whatever that he has agreed under the agreement. And now, my lords, again he wants to press the petition. Only that conduct I want to bring before this court. And another submission I want to make is, my lords, if the lordship were to refer, my lords, the annexure A, it refers, my lords, Alle Nadisi, assault, Jati Nindane, caste abuse with reference to caste, and other atrocities act. Not even otherwise, not these are the offences not under the.
There is a crime register.
Not that is the reason I want to reserve liberty. Despite I being approached there, I may be.
This is happening from 2022.
But there was interim order. This notice came to be stayed by this honorable court. Thereafter.
But for what?
Not to file a complaint.
You already given the complaint to the police. Police have not accepted the complaint. That's why you have gone to the
their complaint, they didn't register. They came before this honorable court. This court said, directed the police to register a case without making me a party. That order I got stayed, but in view of the settlement, I didn't press that petition. Now I am left remediless. I am not given my profit, and now they are not in a reply notice. They have clearly undertaken that they are going to pay 2.50 lakhs for 10 months.
All this we shouldn't take note of it.
Not only on the, not that is the reason I told them. It's only the conduct of the, not equity, not ultimately equity.
No, there can't be any direction, positive direction to the police say that you register the complaint. How can there be such a direction?
Not now only on equity. Let me not left remediless in respect of whatever the complaint.
Whatever.
Lordship to say.
If you have any other complaint, go to the police.
If Lordship to observe this, the authority has no jurisdiction. I may be left to.
Well, if I have not honored the terms of the agreement, there is a remedy provided in the agreement.
Yes,
there is an arbitration.
The present petition is filed. Seeing the following prayer. It's a case of the red petitioner that petitioners are carrying the business or carrying different types of business. The petitioner and the 6 respondent have formed a partnership firm known as Mr. Signature Granite on 14/8/2019. The partnership was registered and reconstituted on 14/8/2019. And the same is registered before the Registrar of Firms. It is submitted that on account of the outbreak of COVID-19, the firm could not do the business. Further, the company owned by third petitioner did not supply granite blocks on account of the non-payment of amount due and payable to the company. The firm is pursuing various applications filed in the KMMC rules for grant of quarry lease. The sixth respondent was in charge of the collection of the various supplies made by the firm to purchasers of the granite box. As per the understanding, no partner is permitted to receive any cash from the purchasers. During the course of carrying on the business, several persons have informed the sixth respondent collected huge amounts of money from the persons for the granite box supplied by firm. After receiving the information from the purchasers, the petitioner, as a partners of Mr. Signatura Granites, confronted the sixth respondent and called upon him to account for the amount received by him from various persons. Instead of accounting the amount, started threatening to file a complaint, and the provisions of this is Prevention of Atrocities, Scheduled Castes and Scheduled Tribes, Prevention of Atrocities Act. It is submitted that the third petitioner owns a company known as Ganpati Granite Impacts Private Limited, which is 100% export-oriented unit, and the same has nothing to do with the firm and the partnership of the firm. The third petitioner made an application in the name of his company seeking grant of the quarry lease in respect of survey number 78 of Tavarakare village, Kunigal Taluk, Tumkur district. The state government has granted the permission to conduct quarry operations. When the petitioners requested the sixth respondent to account for the amounts received, the sixth respondent started threatening that he'll take appropriate complaint against the petitioner and prevent the petitioner from carrying on the business. The sixth petitioner came to the petitioner's business place on 26/4/2022 and attacked the workers and stopped the conduct of quarrying operation. In this regard, the petitioner has filed a complaint against the sixth respondent on 26/4/2022. The petitioners have filed a complaint to the third petitioner has filed a complaint to the Superintendent of Police on 10/5/2022 and requested to direct Tavarakare Police to provide police protection by registering the criminal case against the sixth respondent. When there was no action, they filed WP number 11719 of 2022. And the same came to be allowed. By order dated 24/6/2022. It is submitted that the sixth respondent once again approached respondent number 224 on 12/7/2022, alleging that the petitioners have completed the act of cheating in the business. It is submitted that basing on that, the impugned notice is issued to the petitioner. It is submitted that the dispute between both the parties is purely civil in nature, and the respondents have no jurisdiction to issue the notice and entertain the complaint filed by the petitioner. It is submitted that the one of the petitioner belongs to the SC community. It is submitted that the notice that is issued is without any jurisdiction. Land counsel appearing for the sixth respondent submits that when in the petition what is filed by the petitioner in the without notice, when the same is disposed of, he has filed another petition, that is WP number.
It's 14597 of 2022.
14597 of 2022, and that came to be disposed of on 2nd September 2024, basing on a agreement between the compromise between the petitioner and the sixth respondent. and the petitioner has not, is till now, is not honoring the set terms of the compromise. It is submitted that this shows the conduct of the petitioner. What about you?
My lords, there is no provision is mentioned, my lord. Now due to the stay
Then
granted by this
counsel-
honorable court, my lord.
Leonard, HCCP does not dispute the fact that without registering a crime and without no crime is registered.
Only
and
on the
no
basis of the
provision is
complaint, notice
taken
was issued.
before issuing the said notice to the petitioner. Next paragraph, having heard the counsels on either side, there is a material not required. This court has perused the notice, impure notice, under which provision of law that is given to the petitioner is unknown, is not known, as no provision is mentioned, and as per the instructions of the learned HCGP also. No, and as per the submission of the learned HCGP also, without the police basing on a complaint given by 6th respondent and if issued such a notice, when the nature of the disputes between the parties is purely civil in nature, and both the parties belong to the SC community. In those circumstances, question of petitioner approaching the civil rights, what is that?
Enforcement cell.
Civil rights enforcement cell, and the police issuing such a notice to the petitioner is bad in law. Whatever the disputes between the parties, they can avail the appropriate remedies before the appropriate forum, but they cannot. But the police cannot interfere in civil disputes with these kind of allegations. In that view of the matter, the impugned endorsement dated so and so is set aside.
Notice.
The writ petition is allowed.
Because allegation
the
attracts
sixth
criminal
respondent,
offences. Allegations attracts criminal offences that I may.
the sixth respondent has any grievance, and if any of the acts of the petitioner makes out a criminal offence, he is always at liberty to avail to approach the police.
See the second complaint.
Huh?
First complaint is rejected by
registered.
superintendent of police,
Not at all
second complaint.
registered.
Annexure is not an endorsement, it is a notice, my lord.
Notice.
Annexure is the
Yes,
endorsement.
Number 6. Which Chandrachudha for
whatever it is, annexure so and so, that impugned. Yes, next.
6. MB Chandrachudha for
This matter, my lord, they have sought to file a final report, my lord. After investigation, my lord, charge sheet is filed, my lord.
I may appear for petitioner.
Huh?
I may appear for petitioner.
Yes. Charge sheet is filed, it seems.
It may be disposed of.
The writ petition is filed, seeking the following prayer.
Page
Land Council, Leonard, HCGP submits that the police have already filed the charge sheet and the same is numbered as
3313 of 23.
CC number
3103.
103 of
3103 of 23.
3103 of 23 on the file of
41st ACMM, Additional Chief Metropolitan Magistrate,
41st ACMM.
Bangalore. Bangalore.
Yes, in the light of the same.
Next date is on
Nothing
15th.
suffices for consideration. Accordingly, the writ petition is dismissed as infructuous. Yes, next.
7.
Serial number?
7. Sunil Kumar H.
Taking short adjournment.
Serial number? Yes,
Kindly see the prayer, my lord.
Short adjournment.
why you want it?
Now the dispute is closed, my lord, before the Lok Adalat. And there was a 4 cases for registered.
Get
against-
instructions. It is closed, it seems.
My lord, we will listen.
This is the matter on 1st of April.
Yes.
Get instructions by the time.
And there is a alternative remedies there, my lord. Kindly see the.
On that
They
day, we
made
will
allegation.
let him get instructions. Yes.
Cell number 8. Cell number 8.
The petitioner in this one. My lords, the background of this petition is, my lords, within a span of 10 days, my lords, there are about 3 murders in the district of Dakshin Kannada, my lord. All are interconnected and arising out of a communal angle, my lord. Now, the petitioner is the mother of the deceased. What happens is, my lord, on 19th of July 2022, a 19-year-old, her son, is brutally assaulted by
The
8.
respondents to consider the representation of the petitioner till 30/8/2022. Direct the respondents to invoke provisions of
The UAPM, my lords, and hand over investigation to the national.
the cases to the Nation Investigating Agency.
What has happened, my lord, there are 3 murders taken place. On 19th, her son is brutally assaulted by 8 unknown people. He succumbs to his injury after about 2 days, my lords, on 21st of July. Thereafter, within a span of 5 days, another youth is brutally attacked and killed. Subsequent to that incident, within 3 days, another gruesome act of murder takes place, my lords. What happens is the state government, in one case, hands over the matter of investigation to National Investigative Agency and invokes UAPA. Because now the petitioner is the mother of the deceased who died on 19th, saying that since the state government has invoked UAPA in the second case, and this is all interconnected as sort of revenge murders, Manoj, or an act of retaliation, which has sent shock and terror throughout the entire district. This matter may also be handed over to the National Investigative Agency and investigation to be done in a proper manner. That is the prayer, Manoj. Now, subsequent to filing of this petition, investigation has been completed by the state insofar as these 2 murders are concerned, and charge sheet is filed, Manoj. One of the matters has been also committed to the Sessions Court. In the other case, National Investigative Agency has conducted a thorough investigation, Manoj, and they have filed charge sheet. Subsequently, in April 2025, they have filed a supplementary charge sheet and they've arraigned another 4 people as accused. Totally, they've arraigned about 27 people as accused. They've examined about 282 witnesses, Manoj, and they've laid about 636 documents on record. In the other 2 cases, Manoj, hardly investigation charge sheet is filed in such a manner, Manoj, that the accused may immediately get discharged or they may be acquitted in the matter.
So what are the parameters for handing over the investigation to NIA?
One, Manoj, that ought to be a scheduled offense. Now, Manoj, for that is what, Manoj, may I just seek some accommodation? Manoj, I'll produce the charge sheet and point out the differences. In this case, Manoj, no test identification parade has been done. No call records have been seized. Manoj, there are so many flaws in the investigation. Manoj, if I may be given some opportunity, I'll just place all this before the court to point out the manner in which they have gone about. In one case, the state acts in such a manner.
Lord, insofar as my learned friend seeking for accommodation, Lord, I would not come in the way that is for your lordships. Insofar as the objections are concerned, my lord, insofar as the petition is concerned, if your lordship could kindly take, my lord, my objections dated 15/12/2022, my lord.
Yes.
Please, my lord. Your lordship got it, my lord?
Yes.
I would just read, my lord, paragraph number 5, page 2, paragraph number 5. My lord, the other 4 paragraphs are with regard to the petition, my lord. Please, my lord. Your lordship got it, my lord? Para 5. That it is submitted that in order to appreciate the contentions of the petitioner, it is relevant to produce section 6(1) to 4 of the National Investigation Agency Act 2008, which reads as follows. Investigation of schedule offence on receipt of the information and recording thereof under section 154 of the code relating to any schedule offence of the officer in charge of the police station shall forward the report to the state government forthwith. On receipt of the report under subsection 1, the state government shall forward the report to the central government as expeditiously as possible. On report from the state government, the central government shall determine on the basis of the information made available to the state by the state government or received from other sources within 15 days from the date of receipt of the report, whether the offence is scheduled offence or not, and also whether, having regard to the gravity of the offence and other relevant factors, it is a fit case to be investigated by the agency. Where the central government is of the opinion that the offence is scheduled offence and it is fit case to be investigated by the agency, it shall direct the agency to investigate the said offence. On perusal of section 3 of section 6 of the National Investigation Agency Act 2008 would clearly indicate that the primary ingredients for the central government to exercise its power under subsection 3 is what where an FIR been registered by the state police for the scheduled offence, and that the report in that regard has been forwarded by the state government, or that information has been received by the central government from any other sources with regard to the commission of the scheduled offence. It is only after the receipt of the aforesaid basic information from the state government or other sources, the central government can form an opinion whether offence is scheduled offence, and as to whether it is a fit case to be investigated by the National Investigation Agency in exercise of power under section 6, 3 and 4 of the National Investigation Agency Act. My lord, in this case, my lord, either the police officer has not sent under section 6, 1 to 4. If your lordship could kindly see, my lord, schedule offense, my lord, in the schedule of the NIA Act, my lord, this
This is not part of it.
no. Therefore, my lord, my humble submission is, Lord, the petition as such, Lord, is not maintainable. And my lord, I have also filed a judgment.
Is it
I would
your
rely
case
upon
that,
one.
The offense is a scheduled offense?
Well, they have not invoked it in these two cases. My lord. That is the exact grievance. My lord. Case of 302, my lord, murder has taken place. Now, initially, it was a case of attempt to murder 307. After 2 days, he succumbs to the injuries, my lords. 302 has been invoked. In the third incident also, my lords, it's a brutal case of, my lords, if you go through the documents, it's the brutal case of assault. And all this is...
No, you're referring to a case where it is investigated by the National Investigating Agency. So what are the similarities between both the cases?
In that my lords, all are related.
For that, you need to have what is the complaint in this case?
Please, my lord, that is what I
have clarified in my statement of
even the
objections,
charge
my
sheet,
lord,
my lord, they'll
paragraph
show
2.
how the manner of
My statement of objections, my lord, paragraph
investigation has
that,
gone about.
my lord,
Paragraph
read, my lord,
number?
Paragraph 2, my lord. The petitioner is seeking transfer of investigation to NIA only on the sole ground that murder taken place on 28/7/22, wherein a person by name Praveen Nettar was murdered in front of the poultry shop has been referred to NIA. This is not an acceptable. In the case of Praveen Nettar, there was a links of terrorists and the accused persons, and the accused had contacts with international terrorists as well as the elements which are harmful to the national security on account of the said compelling circumstances. Later in section 16 and 18 of the Unlawful Activities Prevention Act 1967 and section 120B of the IPC was invoked by the investigation agency. Accordingly, submitted a report to the Ministry of Home Affairs and section 6(2) of the National Investigation Agency Act 2008 intimating the fact that the schedule offense under National Investigation Agency Act 2008 has been invoked in the incident. The central government, considering the same, entrusted the case to National Investigation Agency on 3/8/2022 and under section 6(4) of National Investigation Agency Act 2000. However, in present case, my lord, there is no such elements was found at the time of investigation, my lord. He was murdered by the rowdy elements, my lord, of the locality. Therefore, my lord, it was investigated by the state, my lord. And charge sheet is also filed. Now the petition.
Whatever you want to submit. This is matter on 21st.
Great.
Number 9, final hearing.
Yes.
Bill number 9, Tekrappa.
Is there some other date for this? Is it on the final hearing matters after vacation? Yes, in the month of June.
Yes.
Yes.
Bill number 11 for dismissal. Lokesh SG.
And for the petitioner.
Yes.
The petitioners are running the beauty parlor and spa centers, my lord, wherein they are conduct the massage also, my lord. To conduct these business, my lord, they have taken the permission from the concerned authority, that is BBMP. Page number 16, my lord, page number 16.
Not to interfere with the business of the petitioner without any due process of law. Have you filed your objections?
The notice is not ordered.
Notice is not ordered.
Yes.
SCGB takes notice
Lord,
and
if
shall
they-
get instructions. I think
Due to the
it's better
passage
get
of,
instructions.
due to the passage of, it is the incident of 22. Now we are in 26, my lord.
No, anyhow, get instructions so that we'll dispose it off.
Petition will be directed to survey copy, my lord.
Serve the copy on him.
This copy is already served, my lord, because at the time of filing, it is not.
One more, sir.
I'll give,
Serve him now.
I'll give, my lord.
Yes, list this matter on 28th of April.
Actually.
Yes, next.
Bill number 12.
In this case, the wife of the accused, one of the accused,
One submission. It's on first of April. First of April, my lord. 28, I have some other. 28.
You want?
28 is, I have some personal inconvenience, my lord. 28.
When do you want?
First of April, my lord.
I am talking about 28th of April.
April.
28th of
Yes.
which is the writ of mandamus. Here, the wife of the, like one of the accused person has filed a
writ petition seeking a fair investigation of the matter, Lordship. Annexure A, we have given a representation to the respondent's Lordship.
Entire shooting incident, which is subject matter of crime number.
Yes, crime number
is read
330.
as a petition
So what has
also
happened in
to
this
say-
case, Lordship? This is
Supervision of the concerned district judge, Shimoga district. What happened?
Investigation is completed, my lord. Charge sheet is filed, my lord.
Lordship, that is a
Now does not.
charge sheet is filed in respect of the investigation of the crime. Our grievance was that he was picked up from our house. Picked up from our house.
When a complaint against in that.
Yeah, we had given representation. This annexure EA was the complaint we had given it.
That
All
is
the
crime
officers.
number 337.
No, subject matter, shooting incident was happened in that case.
No, no. If you have given a complaint, was it
There is no
registered?
FIR was registered, Lordship.
Then
No, we did not register. For that reason, we came before this honorable court.
you said you are talking about an investigation.
No, Lordship, kindly appreciate.
Look at the prayer.
Yeah, that is in respect of shooting incident we are praying, Lordship. In that incident, it is not,
In respect of that incident, they have filed a charge sheet.
no, in respect of shooting incident, there was no investigation. Lordship, what is happening? There is one communal incident was happened in the city of Shimoga. In respect of that case was registered crime number 330.
You should read your prayer before making all these submissions.
Yes, Lordship, kindly
Please
appreciate.
read your prayer.
Conduct entire shooting incident, which is subject matter. In that, why at the time of arresting the accused person, that shooting incident was happened. So we are confined to the shooting incident. We are not confined with the subject matter of 330. Shooting incident, no investigation was done.
Where is your complaint to the police?
No, his complaint is there, Lordship. This annexure A is the representation given by the petitioner to the station house officer, Lordship.
Where is the endorsement?
It is annexure A. Annexure is endorsement is there, and Lordship. Page number 52.
Yes, get instructions on this. What happened? The HCGP shall get instructions.
Lordship, just one submission, Lordship.
To the action taken by the police. This is matter on 22nd of April.
Lordship, this is also one of such case. In this crime number, subsequently schedule offense was invoked.
We'll see. Yes.
List one matter, serial number 42. Serial number 42.
APA for the petition.
I've taken up tomorrow, madam. Some argument is there in this.
No, tomorrow. Let's
Anytime.
it on 9th of April. Yes, next, another passover.
54. Serial number 54, Passover in list one.
Lord, I appear for
This
the
also-
petitioner.
The matter to be
It's also
posted
on
on
the same day.
My lords, on submission, list 2, serial number 10, interim order will be extended.
What happened to that?
Fine. Serial number 10.
Sir? ಈಗ ಕಾಲ್ ಔಟ್ ಮಾಡಿದ್ರು ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಯು ಗೇವ್ ಸಮ್ ಅದರ್ ಡೇಟ್ ಅಂತಂತೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇದೆಯಾ ಸರ್ ಪ್ರೀವಿಯಸ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ನೋಡ್ತೀನಿ ರೀ ಆಯ್ತಾಯ್ತು ಚೆಕ್ ಮಾಡ್ತೀರಿ ಒಂದ್ ನಿಮಿಷ ಇದು ಒಂಚೂರು ಡೇಟ್ ಇರೋದು ಆರ್ಡರ್ ಶೀಟ್ ಸೇರಿಸ್ಕೋಬೇಕು ನಾಳೆ ಇದೆ ಅನ್ಸುತ್ತೆ ನೋಡಿ ರಿಪೀಟ್ ಮಾಡ್ಬೇಕು ಸೇಲ್ ನಂಬರ್ 10 ಅಲ್ಲಿ ಅಲ್ವಾ 10 ಅಲ್ಲಿ ಇದೆ ಎಂಟ್ರಿ ಮಾಡಿ ಐವೋ ಇಸ್ ದೇರ್ 94 yes 9 list 154 94 के मैडम